Ladies and gentlemen, thanks for attending the regularly scheduled Tennessee Real Estate Commission January meeting. We appreciate you being here and hope you get something out of it. Before we get started, and as a requirement, Eve Maxwell, Executive Director of the Tennessee Real Estate Commission, will read a statement into the record.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 12th of 2014. The agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Tuesday, December 30th, 2014. Also, this meeting has been noticed on the TennGov website since Tuesday, December 30th, 2014. And now I will call the roll. John Grease.
Present.
Janet Chara.
Here.
Wendell Alexander. Gary Bloom. Grover Collins. Here. Marcia Franks. Diane Hills.
Here.
Austin McMullen.
Here.
And it's my understanding that Commissioners Alexander, Bloom, and Franks plan to appear at a portion of the meeting later by phone.
Let me advise the audience that this commission for perhaps the last year and a half has been involved in a fairly complex rules-making process. And we are at the end of that process today from the commission's perspective. And unfortunately, 2 out of our 3 missing commissioners, that missing is not the right word, absent commissioners, have some health issues and can't be here today, and a 3rd is out of town and can't be here as well. But they all are interested in participating in the discussion on these rules. So shortly, like in the next 5 or 10 minutes, we're going to try to put all of them on a conference call, and it could be somewhat tedious for people to understand, to see who's talking, to understand who's talking, but we'll try to keep it as clear as we can as we go through the process. With that said, I would like to ask Commissioner McMullen to lead us in an invocation followed by a pledge to the flag. Commissioner McMullen.
Will you pray with me? Eternal God, thank you for taking on flesh and coming to live with us, that we could spend eternity with you. Thank you for the blessings that you've given us. Help us to differentiate between the blessings that you've given and the burdens that we bear. Please guide this commission so that in all things your will would be done. In your holy name we pray. Amen.
And if everyone would stand, please.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God,
indivisible, with liberty and justice for all.
Last month at this time, right when we were having the invocation, my cell phone went off, and so I started praying desperately that it would quit ringing during the prayer, and it didn't. But that does remind me that if you all would silence your phones during our meetings, we'd appreciate it, and it'd help everybody focus. All right, we've got an agenda to adopt.
Motion to adopt the agenda.
Second. Got a motion to adopt the agenda, seconded, made by Commissioner McMullen, seconded by Commissioner Collins. Are there amendments to the agenda? All right, hearing no amendments to the agenda, let's vote on the motion to adopt the agenda. Those in favor say aye.
Aye.
Those opposed, no. The agenda is adopted. Ms. Maxwell, on this agenda, it says to adopt Robert's Rules of Order. Is that an annual thing we need to do, or is that?
Yes, we received an email from Ms. Goodwin, and she reminded us that all of the commissions needed this month to adopt Robert's Rules of Order as the procedural manual and set of rules by which they'll run the meetings and to sign conflict of interest statements.
What if we choose not to?
Well,
Mine's Rules of Order. Motion to adopt Robert's Rules of Order.
All right, you've heard the motion. Is to adopt Robert's Rules of Order as made by Commissioner McMullen and seconded by Commissioner Collins. Is there discussion on the motion? Any other smart aleck remarks? Hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion carries.
Mr. Chairman.
Mr. Maxwell, Mr. McMullen, excuse me, I was still dwelling on a previous issue.
That's good, because I want to reserve the right to make future smart aleck remarks.
Without exception, without objection, it can happen. Do you have a conflict of interest statement for us to sign, Ms. Maxwell?
It's,
I believe it's in your packet.
When do we get this packet?
Kimberly does those packets for you so that you have all your items that you might need.
Very nice for her to do that.
During
We
the
do appreciate
meeting.
it, thank you. That's not a conflict.
we're
Oh,
just
here
not
it is.
used to being so organized. Kimberly has us way too organized.
All right, each commissioner should find in their packet a conflict of interest statement to be signed. And I guess they'll be collected at the appropriate time, is that,
Yes, they will be collected at the appropriate time.
okay? All right, I say let's try to get those other commissioners on.
The minutes.
Approve the minutes.
Oh, okay. One more perfunctory item, the minutes of the December 2014 meeting have been distributed. Are there any objections, comments, corrections? If not, is there a motion to approve those
Motion
minutes?
to approve the minutes.
The motion is made by Commissioner DeCharo and
Second.
seconded by Commissioner Hills that these minutes be approved as submitted. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion carries unanimously. All right, members of the audience, members of staff, we're going to take a moment and try to ring up these three commissioners so we can get into a discussion on the proposed rules. So if you'll stand by. Who's Jenica, are you in charge of that? Okay.
Gonna ring until one of them gets on the line.
All right, let's call them back in a few minutes.
Okay.
Are, will they have to answer?
They have to answer for
Okay.
it to pick up together, yeah.
Oh, well, so we can call the line and open it. Can you do that still?
That's what that was. We call the
You-
line and it'll ring until they call in as well. Until two people are on the line, it won't.
Why did Kimberly
Pick up.
text them and tell them to call in?
Yes.
Oh, and they didn't, okay. And
To the members of the commission here, this discussion may be a little bit difficult, so I'll ask each member of the commission to talk loudly, slowly, and we'll do each vote by roll call just because we'll have three voices, hopefully, that we like to make sure we identify correctly as far as their vote goes.
Mr. Chairman, would it make sense to possibly start on the executive director's report or something while we have some time?
Right, I was thinking about maybe me just calling those three commissioners
I
real
think,
quick.
yeah, I thought she was, Kimberly, are you texting them? The line's not open right now, is it? No, it is. I think it's just a process.
Okay, I can't take too much more of that ringing.
Now,
Try again in a few minutes.
We're gonna have to excuse you.
but you have to give them a chance to,
How long a time do they need?
they're not nimble nimble fingered people, you know, I mean.
Is that on the record?
I don't understand where's that call going?
It's
I
going
think
to our
if it's
bridge
not ringing, they're not going to be able to connect
Right,
when
they
they try
can't
to call in.
Oh,
Call them.
Well, you should watch your earplugs from the hotel.
yeah.
I have some earmuffs upstairs, which I can go get them, see if you
Not till I leave.
I tried to do like a two-way, three-way calling, and we don't have that function. So this is unfortunately, our only option. I tried to not leave it up to them to call in.
I'll just call.
Hello, Commissioner?
Hello,
Hi, can you identify yourself for the record?
Wendell Alexander.
Thank you, Commissioner Alexander. Stand by.
Thank you.
Do we have any other commissioners on the phone?
I guess that's a no.
Wendell,
Yes,
do you have any time constraints this morning, like a doctor's appointment or anything?
this morning?
Yes, sir.
No.
Okay.
I'm good. How are you, John?
Thanks for asking. I'm doing just dandy.
Good.
Miss you, though. I wish you were here.
Well, you know, I just thought it was better.
I understand.
Got a crowd?
Pretty good.
You know how you like to look over the crowd and make comments about them.
Yeah.
Okay.
All right. You're going to have a quorum, I'm sure.
Yes, sir. We appreciate you being the first to call in too.
That's my efficient help I have.
If we can, hey Wendell, since you're on the line, and if the commission will listen to this,
Hello.
hey Gary,
Yes.
can you hear us okay?
Yes. Here, fine.
How are you feeling?
Much better, thank you.
Good, good. I'm glad to hear it. You're on the call with Wendell at this point, and there are 5 commissioners physically present. We're waiting on Marcia, and we'll get this process started.
Okay.
I'm going to, Wendell,
Yes.
you were assigned a case to review or agreed to take one last month, and I know you're not going to stick around for the legal report. Could you tell this commission, just in about 2 or 3 words, what your position is after reviewing that file?
After reviewing the file, should be dismissed. It was a foreclosure. The thing was going into foreclosure. When the offer of the person that submitted the offer, about 2 days, it's a routine thing that I think she just got perturbed at her competition. Recommendation is to dismiss it.
All right. Thank you. Thanks for reviewing that case, and thanks for that report.
Thank you.
Gentlemen, on the phone call, we're waiting for Marcia. We'll give her a few more minutes. We may start without her at some point, but let's give her a few minutes.
We're not sure she's got the right number to call.
Okay.
Doesn't take-
Yeah.
Gary, is it snowing in Memphis?
No, but it's cold.
It's about 21 degrees here. The wind's about 15 miles an hour. And spitting snow.
Yeah. Well, you.
Gary, do you have any time constraints this morning?
I have an appointment at in an hour and a half.
Yeah. Are you on a cell phone so you could talk all the way to that appointment if you needed to, or do you need to leave that number at some point?
I can change to a cell phone. I'm on my landline right now.
Okay, we'll see how this goes. I just want to make sure we get all your comments as we go through this.
Okay.
Hello?
Marcia,
Yes, it's Marcia.
how are you?
I'm good. Sorry, I've got bad connection down here.
Well, those things happen when you're in remote locations.
Yes, I guess so. Sorry to be late.
You're fine. You're fine. You're on a conference call. Gary and Wendell are also on it, and the balance of 5 commissioners are present here in Nashville. And so we're about to start this rulemaking process. We have a court reporter present who will want to make sure everyone identifies themselves. You 3 on the line may need to spell names. I'll defer to the court reporter on what you need. Ladies, is there any reason we don't get started at this point? All right. From a process point of view, how would you like for us to identify ourselves? What do you care? What names? All right, you 3 on the telephone. How about identifying yourselves and spell your name, just so everybody's clear? Start with you, Wendell.
Wendell Alexander, WENDEL ALEXANDER.
G
Say it again.
L U M E.
Gary Bloom, BLUME. And Marcia?
Marcia Franks, MarciaFranks.
And for the record, if commissioners will say your name out loud, starting with you, Austin.
Austin McMullen.
Grover Collins.
Janet DeChara.
John Grease.
Diane Hills.
And if members of the staff who are with the Real Estate Commission or the Department of Commerce and Insurance, if you all will identify yourself and position, please. Ms. Maxwell.
Eve Maxwell, Executive Director of the Tennessee Real Estate Commission.
Jenica.
Jenica Smith, paralegal. Keelan Gamber, Assistant General Counsel for the Tennessee Real Estate Commission.
I guess Tony is left. Is that okay? We'll have him identify himself when he shows back up. All right, commissioners, it's my understanding that we need to go through these rules. Some rules had no comments. For the record, we should decide whether we want to send them on up for a final time. We'll vote on each one of those by roll call. And then when we get to items that have had comments, it'll be the charge of this commission to address those comments and say, I agree with them, I disagree with them, I'd like to modify them, I've got a substitute motion or some issue, so that by the time we're done with this portion of our meeting, those rules are clearly stated and ready to be sent back to Keeling. Where do they go next?
I'll have to go back to the Attorney General's office for final approval.
It goes to the Attorney General for final approval. And does it also go to a governmental operations committee of some sort before we find out for sure whether they're final?
I think it goes back to the governor's office one more time.
You need to speak.
It goes back to the governor's office one more time, and then before they're filed with the Secretary of State's office.
And once they're finally approved, when do they take effect?
I believe it's 90 days.
90 days following final approval of the Secretary of State's office,
Correct.
you think?
Yes.
Okay, and we don't know, we have no idea, frankly, on this commission when that might be. This is part of a long process we've been working through. Any questions from commissioners or staff before we get started? All right, y'all received a package, for lack of a better term, from legal about each of these rules, and let's start on page 1. not that they're, yeah, page 2 of 23, and let's get started. For the audience's benefit, let me mention that we, as a commission, are subject to the state sunshine law, which means this discussion we're about to have on some of these is the first time we've had any type of discussion on these topics other than in public meetings. So we are subject to the sunshine law, and at some point you may hear a discussion and comments and go, that's stupid or silly, why are they talking about that? That's because it's the first time we've had an opportunity to talk about it. We want all these commissioners to give their opinions. Commissioner McMullen? Do you have any smart aleck remarks?
Yes, somebody might think it's stupid, even if it isn't the first time we've talked about it.
And you're right about that. All right, commissioners, let's go. New rule 1260-01-.19.
Mr. Chairman,
18, I'm sorry. Duplicate or confusingly similar names. Mr. McMullen.
Chairman, I move that we send Rule 1260-01-.18 to the Attorney General and the Governor and the Secretary of State.
Got a motion. Those of you on the telephone, could you hear that motion? Okay.
Yes.
Fine with me.
Okay. So the motion is to send it as has been previously submitted. Is there discussion on the motion? All right, I hear no motion. We're going to roll call this just to get in the practice of doing it. Ms. Maxwell, if you'll call the roll.
Yes, this is a motion to send Rule 1260-01-.18 as originally approved onto the Secretary of State, AG, and the Governor. Okay. Commissioner Bloom?
I agree, yes.
Commissioner Alexander?
Yes.
Commissioner Franks?
Yes.
Commissioner McMullen?
Yes.
Commissioner Grease?
Yes.
Commissioner Hills?
Yes.
Commissioner DeChara?
Yes.
Commissioner Collins?
Yes.
That passes.
Motion passes unanimously. The second rule to consider is new rule 1260-01-.19, informal appearances before the commission.
Mr. Chairman, I move that we send new Rule 1260-01-.19 on to the Secretary.
The motion made by Commissioner McMullen, seconded by Commissioner Collins, urges this be sent on to the appropriate agencies without change. Is there discussion on that motion properly seconded? I hear no discussion. Ms. Maxwell, will you call the roll, please?
Yes, this is Rule 1260-01-.19. Bloom?
Yes.
Alexander?
Yes.
Franks?
Yes.
McMullen?
Yes.
Grease? Hills?
Yes.
DeChara?
Yes.
Collins?
Yes.
Motion passes unanimously. The third rule we're considering today is new rule 1260-01-.20, military applicants.
Chairman, I move that we send new Rule 1260-01-.20 on to the appropriate agencies.
Motion has been made by Commissioner McMullen's properly seconded by Commissioner Collins that this be sent on to the appropriate agencies as previously submitted. Is there discussion on the motion? I hear none. Ms. Maxwell, let's see how the vote goes.
This is Rule 1260-01-.20, military applicants. Bloom?
Yes.
Alexander?
Yes.
Franks?
Yes.
McMullen?
Yes.
Grease? Hills?
Yes.
DeChara?
Yes.
Collins?
Yes.
That motion passes unanimously. We're on to the fourth new rule. Well, this is an amendment. No, we're on 1260-Z-01-.21. Reinstatement of an expired license of a broker, affiliate broker, timeshare salesperson, or acquisition agent.
Mr. Chairman, I move that we send new Rule 1260-01-.21 on to the appropriate agencies.
Motion has been made by Commissioner McMullen, seconded by Commissioner Collins, that this rule be sent on without revision to the appropriate agencies. Is there discussion on the motion? All right, I hear none. Ms. Maxwell, let's vote.
This is Rule 1260-01-.21. Bloom?
Yes.
Alexander?
Yes.
Franks?
Yes.
McMullen?
Yes.
Grease? Hills? DeChara?
Yes.
Collins?
Yes.
That motion passes unanimously. We're now on to an amendment to a rule. That rule number is 1260-01-.22. 02-.02, termination of affiliation. Now, Ms. Baird, in a case like this, well, we've got a comment. Do you want the comment read into the record, you think, and then we'll discuss it after that comment's read in?
The comments have been read into the record at the last meeting, so it's not necessary unless the commission wants it read into the record.
All right, let's, commissioners, especially you guys on the telephone, do you all have written copies of what we're looking at?
Yes.
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 All right. Now, just generally speaking, is there a desire by any commissioner to read the comments into the record, or would you like to only comment on those comments?
I don't think they need to be read into the record.
Does anyone have an opposing view to that? I hear none. So let's open the floor to any comments that a commissioner might have about, in this case, comments from J. Russell Farrer.
Well, he's asking about what constitutes receipt. I think what constitutes receipt by the commission is the date and time that we receive it at TREC.
That, just for the record, that's Commissioner Bloom that just spoke. So, Mr. Bloom, do you concur with Mr. Farrer's comments, or do you have a substitute or a motion to offer on this particular rule?
Well, his question is what constitutes receipt. I think receipt by the commission is the date and time as
And I'd like to maybe get Ms. Maxwell or legal's opinion on this, but throughout some of these comments, there are questions and as opposed to suggested changes, and I'm not sure we're necessarily in the business of answering some of these questions we're going to get today. Ms. Hills.
Diane Hills. And certainly you can document the receipt of a fax. You'll have a receipt of the email, but the mailed receipt is we may not know what day it's received here.
Ms. Maxwell, is that mail not date stamped when it comes through the mail room?
It's we usually receive the envelope along with the mail that we get. It's date stamped, and then it goes up to the cashier's office where information's entered. But we do normally get the envelopes with all of our mail. But then it goes to the cashier's. It goes from the post office to the cashier's office if it has money with it, and then the cashier's office processes it and posts it, and then all the documentation arrives in the TREC office 24 to 48 to 72 hours after that. So it doesn't actually arrive in our office until several, like there's some period of time between when it goes to the cashier's office and when it gets to our office.
And then how long before it's posted on the website?
When when a transaction would be completed? Well, it would be posted on the website after we enter our information, and then it runs overnight. So, if it was entered 5 days later, then when it ran overnight, it would be up on the website the next day. So that when the money's entered on the website, you can't see that. We can see it internally, but you wouldn't be able to see that on the website, when the process of the money is being entered.
Yeah, I think the comment that Mr. Farrer made had to do with us telling him when is receipt. And I think the question to the commission is, do you want to address that, or is it fairly obvious when receipt is?
Well, to make it Commissioner Alexander.
Go right ahead, Commissioner.
Let's take it just like it's in the comments. We will acknowledge that receipt as we receive it, even with the email. Whenever you get however mode of notification you get, that's mail. Then it's the time that it reaches the desk of That's my motion.
Wendell, if you would say that again.
What I'm saying that the transfer would be whenever we receive it, either by email, fax, or regular mail, and the regular mail be considered when the TREC office receives it in that office. And the proof of that receipt would be verified by the date stamped on the envelope.
There's no change to the current rule.
That's right.
Okay. So there's no need for a motion at this point.
Okay.
I'm just talking out loud. You can argue with me.
No, I wouldn't argue with the chairman.
Oh, come on. You've done it many times. All right. Well, the chair's going to rule we don't have a motion right now. Is there further discussion on this particular, Ms. Hills?
So in my mind, my interpretation is I fax it, the fax machine spits out a receipt, that's done. I'm not responsible from that point on.
That, if it's a money, I don't know if this is just, if he's just referring to online transfers or if he's just referring in general to actions that can be taken by the Trek One form. But when almost all the actions on the Trek One form require the payment of money. And so until that money is posted and processed, it's not even in our office, and the transaction can't take place because it requires money in order for that transaction to occur. So until the money is received, so you couldn't just fax a Trek One form to retire and still owe the money to retire, because we couldn't do that transaction. You know, we could not enter that transaction in without the fee that's required in order for that transaction to take place.
But it says the principal broker's supervisory responsibility for the future acts of the licensees shall terminate upon the commission's receipt of the release form. And it doesn't refer that then money gets deposited.
So if it's just a broker release form and that's all the person sent in, which is frequently what will happen, say in the instance of E&O, and you just want to broker release someone, that requires no money. And so those, as soon as they do arrive in our office, whether it's by fax, email, mail, that's good when it hits our office.
Okay.
So if that's all that's involved, then that is.
That's all that rule is referring to.
All right.
Other discussion on this particular comment?
This is Marcia Frank. I would like to say, as long as everybody knows what the rules are about the timestamp, there should be no problem about it. So I'm in hope that principal brokers are going to really be following this rulemaking hearing closely so that they understand the terms of this and it's not confusing to them.
Thank you, Ms. Franks. The chair needs a motion of some sort. That motion could be to approve the rule as previously submitted, or it could be some sort of amendment based on this comment.
Mr. Chairman,
Mr. McMullen.
I move that we proceed with the amendments to Rule 1260-02-.02, Subpart 1, as written.
Second.
All right, the motion has been made by Commissioner McMullen and properly seconded by Commissioner DeChara that this rule proceed on to the appropriate government agencies as previously submitted. Now, is there discussion on that motion? I've got the second. I'm looking for discussion. I hear no discussion. Last call.
Mr. Chairman, could I ask a question?
Yes, sir.
About procedure. I see that we're talking about Rule 1260-02-.02, and within that amendment there are 8 different subsections, but it looks like our memo only calls out the subsections that had comments specifically, which are subsection 1 and subsection 3. And so I think it would be good for us to get some clarification as to whether we vote on each of those separately, or do we discuss them all and then vote on the whole rule all at once, or what?
It's my understanding that the commission needs to adopt a collective response to each comment, so that we have basically a collective response to each comment as a whole by the commission, and then you would adopt the rule as is if you want to keep it the way that it is. And we would just do each subsection the same way because you would need a collective response to each of those comments.
All right, let's, Mr. McMullen, that's a good point. Let's see if you'd like to change your motion just for the subsection. We'll come back and get the whole rule after we handle the subsections.
Yeah, I'd like to offer a substitute motion to respond to the comment number 1 that the rule as drafted sufficiently defines receipt and so no further amendment to the rule is necessary.
Okay, now the motion in front of Commission is a motion offered by Commissioner McMullen, seconded by Commissioner DeChara, that addresses only that subsection identified as 1260-02-02, subsection 1. And there are some other subsections within this rule that we'll discuss, and at the end of those discussions and how we handle those subsections, we'll come back and then capture the whole rule as amended if necessary before we proceed to the next rule.
Mr. Chairman.
Yes, sir.
I understand it. This rule.
So, hey, Wendell, you broke up. If you'll start over.
I say there's been no change. We're adopting it as it was submitted.
Portion of, Commissioner Alexander, it's a portion of the rule. We'll have to come back and capture the whole rule after we do it.
I understand, but I'm talking about section we're talking about right now.
Yes, sir. We're only dealing with that, and there's no change if you agree with Commissioner McMullen's motion. Is everyone ready to vote?
Yes.
All right, Ms. Maxwell, let's vote. If you're in favor of Commissioner McMullen's motion, you'll vote aye, which means no change.
Do we need a roll call?
Yes, Ms. Maxwell's going to call it.
Okay.
Bloom,
Aye.
Alexander,
Aye.
Franks,
Yes.
McMullen,
Yes.
Grease, Hills, DeChara, Collins.
That motion passes unanimously. We'll move on now to page 4 of 23. There are some comments again from J. Russell Farah. And the floor at this point is open to comments from Commission related to Mr. Farah's comments. If there are no comments, the floor is open for a motion.
Well, I agree with what Mr. Farah is saying and understand where he's coming from. When I release somebody from my office, if they're leaving my office and going to yours, and it's your responsibility then to submit it to the state, but you don't get around to it, who is the responsibility of that agent lie on? Who does that responsibility lie on?
I could take a position that the licensee ought to be responsible for their own license, get the signatures and get it submitted.
But if they've given it to their new broker, and their new broker puts it on their desk and doesn't do anything with it,
Why don't you get the signature of the new broker and you, the licensee, you're an independent contractor, why don't you send that and be responsible yourself?
but we've made the broker's responsibility.
I'm just talking out loud at this point. I don't have a motion. Ms. Hills?
When I was principal, not principal now, when I signed them, once they left me, I went ahead and sent it to check because I didn't want that time lapse if someone did not act responsibly for their own license. And I don't know if that helped me in any way, but that's what I would do.
Ms. Maxwell, how would that be handled in-house?
If, in fact, Ms. Commissioner Hills, her approach was the probably safest approach because the principal broker can send in what would really constitute a broker release. Because even if there was another transaction that was part of that and it involved cash, but it was the person moving to another firm, the broker release itself would still be a valid transaction without a fee, and that would go ahead and be done. And then the person would be under the administrative measures where he would have to either retire his license or transfer within 10 days. So that's that would be one safest way to act.
Okay, but in the event the releasing broker does not do that, and the new broker doesn't follow through, where would the responsibility of that affiliate lie?
The commission had a formal hearing on that. It would really probably end up in the hands of the commission to make a decision who ultimately was responsible if there were a complaint opened against that person for not, taking a complaint could be opened against the licensee for not following through with the administrative measures that are required in the statute, which is within 10 days, you've got to either, transfer to a new firm or retire your license. And that's what's required of the affiliate broker to do that. The supervising broker, the managing broker, if you're going to go to another firm, the principal broker's already signed off on that document. And so once you've got all those signatures, then, whatever the protocol was, but with the firm or with the individuals would, I guess, dictate who actually did the sending in of the document. But we don't establish anything except that the person who's got the TREC 1 form, that they've got, if they've been broker released, they've got 10 days to do something with their license.
Ms. Franks, Mr. Bloom, Mr. Alexander, comments on this particular subsection?
No comment.
No comment.
I would like to say that as a principal broker, it's when that signature is when the valid time is as for that date. So I think as it's written, fine.
Marcia, would you repeat that?
Yes, I think as a principal broker, when my signature goes on a TREC form, that's when I become responsible or not. So the signature times are what the important thing is, and I would agree with going forward with this group.
As previously submitted?
Yes.
Is that your motion, Ms. Franks?
Yes.
I'd have a motion by Commissioner Franks, seconded by Commissioner McMullen, that this subsection of a particular rule proceed as previously submitted to the appropriate government agencies. I've got a motion and a second on that. Is there discussion on the motion? Ms. Baird.
Sorry, I know this is kind of confusing. I think we need to make sure we're adopting a collective response to the comment before proceeding on to whether or not to adopt the rule as is.
We're gonna do that.
Okay, just making sure.
In a minute, we're gonna adopt the rule as amended if it's been amended.
Okay.
So far, it hasn't been. You all hear the motion? The motion is basically to adopt, to make no changes. It's my understanding. Let's roll call.
Yes.
If you agree with that, then you'll vote yes. If you disagree, you'll vote no. Ms. Maxwell.
Yes. Collins. Yes. DeChara.
Yes.
Hills.
Yes.
Grease.
Yes.
McMullen.
Yes.
Franks.
Yes.
Alexander.
Yes.
Bloom.
Yes.
That motion passes unanimously. Let's see. Those are the only comments.
Well, we've got to make a response to Mr. Farah.
Correct. Sorry, I know this is confusing.
On subsection 3, is that what you're saying?
Yes.
Yes.
Mr. Chairman, I move that we adopt a response that the rule as amended, in specifically subsections 1 and 3, define what constitutes receipt, and that the rule is clear as to the effect of the 5-day grace period.
Is there a second to that motion?
Second.
And this is basically, we're voting, Ms. Baird, on a response to the comment.
Right.
Okay. You've heard the motion. Is there discussion? Anybody need clarification? Let's vote on the motion. Ms. Maxwell.
Collins.
Yes.
DeChara.
Yes.
Franks.
Yes.
Grease.
Yes.
McMullen.
Yes.
Alexander.
Yes.
Bloom,
Yes.
Those are the only comments we've had on that particular rule. Number 4, we've got to deal with that.
there's 4 that
Yeah, I got
bottom of page 4 and top of page 5. There's some comments on subsection 4.
All right, we're on at the bottom of page 4 of 23. Item number 4. This topic that's in front of us, you'll see that there were 2 comments to that particular suggested portion of a rule. You see those comments at the top of page 5 of 23.
Mr. Chairman, I'd like to offer amendment. It's
Mr. Bloom, you're up.
on number. A licensee terminates his affiliation with a firm, take nor use listings, buyers or sellers secured through the.
Okay, Mr. Bloom's motion basically, as I understand it, adopts Mr. Farrer's comments.
That's correct.
And so what Mr. Farrer's comments do, in my opinion, is expand the definition of listings to include buyer listings as well as real property listings. Now, let me see if I can get a motion to Mr. Bloom's motion before we go forward.
Second.
Seconded by Commissioner Hills. Now, that motion is on the floor. Mr. Chara.
Can we do a friendly amendment to that and just say unless specifically authorized by principal broker in writing? Which will address the next comment.
I think that's appropriate.
Mr. Bloom, what do you think? It's your motion at this point.
That's fine.
Okay. So what we have in front of us now is a combination or basically acceptance of those 2 comments. One saying that any release of listings must be in writing, and any listing should include both buyer and seller listings, for lack of a better definition.
Buyer's rep agreements.
Buyer's rep agreements. All right, you've heard the motion. That's what's in front of commission. Is there discussion on the motion? Do you want us to address, Ms. Baird, by accepting this, are we acknowledging that we agree with their comments, or do you need that first and then let's vote on?
I would just go ahead and state whether or not you're accepting this comment, and then further, if you are agreeing to a recommended amendment, we would just need you to describe that amendment.
It's the chair's belief that this commission is adopting both of those comments, one from Mr. Farrer and one from Mr. Watson. Is there any objection to the chair's interpretation? Okay, so by common consent, we've adopted those. And then the motion, which incorporates those 2 comments you have heard, but it basically states that any release of listings, whether buyer representation listings or traditional real property listings, have to be approved, have to be reduced to writing and include both of those type of listings. That, in my opinion, is Mr. Bloom's motion at this point, because I believe, Mr. Bloom, you've accepted friendly amendments along the way on this.
Correct.
And I'm going to give Diane Hills, Commissioner Hills, the second on that.
Yes, second.
All right.
Question.
I've got a call for the question by Commissioner McMullen. Is there any objection to the call? I hear none. Let's vote on the motion.
It might be more beneficial if we could get the amendment that you're suggesting more verbatim of how you would want it stated.
I can do that.
Ms. DeChara, who's not a maker of the motion, but she supports it, I suspect, will tell you what she thinks it says.
Well, I did the friendly, so. When a licensee terminates his affiliation with the firm, he shall neither take nor use any property listings or buyer's representation agreements secured through the firm unless specifically authorized by the principal broker in writing.
All right, commissioners, are you ready to vote on that motion?
Yes.
Let's do it. Ms. Maxwell.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
DeChara,
Yes.
Collins.
Yes.
All right, that motion passes unanimously. At this point, we need to go back now and capture the entire rule as amended. Is there a motion from a commissioner to send on to the appropriate government agencies Rule 1260-02-02
So move.
as amended?
Second.
Okay, we have a motion by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion on that motion? Let's vote. Ms. Maxwell?
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease, DeChara, Collins.
It's me.
Oh, Hills, sorry.
Yes.
Okay, that motion passes unanimously. We're now on to page 5 of 23. Amendment to Rule 1260-02-09 deposits and earnest money. And we did receive one comment from J. Russell Farah. And his comment basically said that whether the way it's written right now apparently identifies an agent, but it doesn't describe the possibility that a facilitator may be holding the earnest money.
Mr. Chairman,
Mr. McMullen.
I move that we do two things. First, that we amend the definition in section 1260-02-091 1B1 to say money belonging to others received by a licensee who is acting as an agent or facilitator in a real estate transaction, semicolon or. And secondly, that we respond to the comment by saying that we agree with the comment and are amending the definition accordingly.
Is there a second to that
Second.
motion? I have a second from Commissioner Collins, just by hair, Ms. Hills. All right, listen, you guys on the phone, did you hear the motion, and do you have comments?
I heard the motion, no comment.
All comments.
I heard it and no comment.
Let's vote. Ms. Maxwell?
Bloom,
Yes.
Alexander,
Yes.
Hills,
Yes.
McMullen,
Yes.
Grease,
Yes.
Franks,
Yes.
DeChara,
Yes.
Collins.
All right, we have another subsection to handle. And again, Mr. Farah made some comments. Particular, I think, well, let's without me speculating, is there discussion on this comment that Mr. Farah made?
I agree with Mr. Farr's comment.
So would you like to make a motion, Ms. Franks, that you're in agreement with, or the commission's in agreement with Mr. Farr's comments on this change, and make that the first part of a motion that says that you recommend that the rule be amended to state whatever you'd like for it to state?
Okay, where a contract authorizes a principal broker to place trust money in an escrow or trustee account, the broker should clearly specify in the contract.
I have a motion by Ms. Franks, a second by Ms. Hills. That's a two-part motion. One, to accept and agree with the comments offered by Mr. Farah, and second, to amend the rule to reflect those comments. Is there discussion on that motion? Are you ready to vote?
Yes.
Let's do it then. Ms. Maxwell?
Collins, DeChara,
Yes.
Franks,
Yes.
Grease,
Yes.
McMullen,
Yes.
Hills,
Yes.
Alexander,
Yes.
Bloom.
Yes.
All right. So I make sure we're all on the same page. What page are we on, Ms. Baird?
We're moving on to page 7 of 23,
Page 7 of 23,
to the next comment.
and that's on item number 9, subsection 9.
7.
Comment number, Roman number 7.
Yeah.
Okay, comment number, Roman numeral number 7. And again, Mr. Farah has a comment. And the chair will take the liberty on this one of saying I completely agree with those comments. And I'm not going to make a motion, but just so you know my position, I think they're correct. Other comments, or is there a motion?
What is the suggestion to change it from saying the name and address of the person to saying the name and address of the firm?
Yes, that's how I understand it.
Mr. Chairman, I move that we do two things. First, amend section 1260-02-.095B to read the name and address of the person or firm who will actually hold the trust money. And second, to respond to the comment numbered 7 by stating that the rule has been amended to reflect the suggestion stated in the comment.
A second.
Motion by Commissioner McMullen, second by Commissioner DeChara. Two-part motion, agreeing with the comments of Mr. Farah, number 1. Number 2, amending our recommendation to the appropriate government agencies that includes adding a firm, if appropriate, to the language. Is there discussion on the motion? All right, let's vote. Ms. Maxwell.
Bloom,
Yes.
Alexander,
Yes.
Hills,
Yes.
McMullen, Grease,
Yes.
Franks,
Yes.
DeChara,
Yes.
Collins.
All right. Item or subsection number 9. We have comment identified as Roman numeral number 8 from Mr. Farah. Does any member of commission want to make a comment or make a motion?
I agree with TER's counsel.
Oh, Mr. Bloom, I will yield to you. Did you say you agreed? You had two parts. You agreed with their comments, and you wanted to offer a motion.
I'm hopeful that our legal counsel agrees with me so he can offer the amendment, but I agree with the comment that Russ Farah made.
Other comments? So here's my comment, and maybe there's a statutory reason why I shouldn't be concerned about this, but for years, I didn't have to turn earnest money over to an attorney to go interplead it. I could just take it down to General Sessions Court. Can I still do that, counsel?
I've done both.
So, I mean, Russell's, Mr. Farah's language would require it to be turned over to an attorney. And I prefer not to hire an attorney in simple cases and just carry that earnest money down to General Sessions and interplead it.
Well, you could do
I
either
agree.
or.
Well, now that you say it that way, I've started liking the suggestion a lot more.
I've done it both ways.
Well, if
I think it adds costs to the situation that are not needed. I would disagree with Mr. Farah on this one.
I think there was an attorney general's opinion about that from the, in regard to a question that was asked by the legislature last year. This past 2014 legislative session. And so that would offer some guidance, I think, to an individual who wanted to file an interpleader. I think it would depend on whether you were representing a third party or representing yourself, and whether you were practicing law. And so I think that, I'm not sure that you can make a statement that would just be one way or the other. The legal counsel may know. There was an attorney general's opinion that was issued this past spring. And anyway, maybe that should be read before some decision is reached, or just go from there.
well,
Maybe you could adopt an amendment that said dispersed, interpleaded, or turned over to the attorney.
I agree.
That's good. That's good.
A motion.
all right, commissioners, Mr. McMullen has a motion. Pay attention.
I move that we do two things. First, that we amend section 1260-02-.099 to state that absent a demonstration of a compelling reason, earnest money shall be dispersed, interpleaded, or turned over to an attorney with instructions to interplead the funds within 21 calendar days from the date of receipt of a written request for disbursement.
Second.
And the second part of my motion would be that we respond to the comment by stating that the proposed rule has been amended to reflect the suggestions of the comment.
Second.
Let me go back to Ms. Franks for a second. Ms. Franks, you had attempted to second Mr. McMullen's motion before he got to the second part of it. Are you also in agreement with the second part?
Yes, I am. Sorry.
You're going to be the second of record then. The motion is by Commissioner McMullen, seconded by Commissioner Franks. Is there a discussion on the motion?
No discussion.
Thank you, Mr. Alexander. Let's vote, Ms. Maxwell.
Bloom,
Yes.
Alexander,
Yes.
Hills,
Yes.
McMullen,
Yes.
Grease,
Yes.
Franks,
Yes.
DeChara,
Yes.
Collins.
All right, that motion passes unanimously. We're on now to subsection 12 of the same rule. Again, Mr. Farah has comments. The floor is open for comments from commissioners about Mr. Farah's comments.
I'd like some explanation as to what the statute that he references says and how it relates to the proposed language. Number, we're on comment Roman numeral 9.
We're gonna have to look that up because it's not in our section of the rules.
All right, for those of you on the phone, Mr. McMullen has asked for an explanation of a portion of Tennessee Code annotated that the staff does not relate to the rules of the Tennessee Real Estate Commission, so we may have to.
He said something about Tennessee Code annotated section 6628-301A.
I'll have to run and get the book.
All right, let's think about taking a break for about 5 minutes while council gets TCA so we can reference that particular piece of legislation. Gary, how's your time doing? You going to switch to a cell phone here shortly?
No, I will do that at 11.
Okay, well, we'll try to keep it moving, but at this point, let's take, for commissioners' benefit and audience's benefit, a 5-minute break. We'll be right back.
Okay.
For the record, I'd like to let the record reflect that Tony Glandor from, let's see, Tony, what office are you from? Anthony, how do
I know, right?
who are you with?
I just float every once in a while. I come down. I'm the chief counsel for regulatory boards.
Counsel for Regulatory Boards. Thank you.
Yes.
This has joined the conversation.
The comment, there seems to be a comment about some confusion between this proposed rule, which is 1260-02-.09 section.
You're going to speak up a little.
Section 12 regarding the escrow accounts and all trust money received, held, which relates to lease of property, must be held in one or more separate escrow trust accounts, and the confusion of that and how that works in with TCA 6628-301 subsection A, or section A, which is under the Uniform Residential Landlord and Tenant Act, Part 3, regarding landlord obligations and security deposits. And that section states, all landlords of residential property requiring security deposits prior to occupancy are required to deposit all tenants' security deposits in an account used only for that purpose in any bank or other lending institution subject to regulation by the state of Tennessee or any agency of the United States government. Reading these two together, I don't think that there's much confusion. I think that they work in conjunction with each other. I see here that the Tennessee code that's cited, 6628.301, relates specifically only to those areas where ERLTA, the Uniform Residential Landlord Tenant Act, is required. And again, it's for landlord obligations only for residential property for that stated statute. And that statute is one that's not under this commission that it regulates. The rule here requires for all funds relating to lease of property has to be in an escrow or trustee account for all properties. And it appears that both of them are generally requiring that, whether it's in a separate escrow or trustee account, as our rule indicates, that would have to be in a bank financial institution, which is what the statute contemplates. I don't really see that there's a conflict, that it's so confusing that it can't be worked out. I think that I don't think that there creates confusion that it would be a problem.
Thank you. Mr. McMullen?
Satisfies my question, and I appreciate the answer.
Yep, motion.
I move that we respond to the comment by stating that the rule as written is not confusing, and that the rule does not impose any additional requirements inconsistent with the statute cited.
All right, so the motion is a motion commenting on Mr. Farrer's comment. And the motion you have heard from Mr. McMullen basically says, in our opinion, if you agree, there is really no conflict or confusion. And we will vote on that, and then we'll see if there's a motion, any other motion, but we're at this point only handling a motion related to the comment. Are you ready to vote?
Yes.
All right, let's vote. Ms. Maxwell?
Bloom,
Yes.
Alexander,
Yes.
Hills, McMullen, Grease,
Yes.
Franks,
Yes.
DeChara,
Yes.
Collins.
Chairman,
Mr. McMullen?
I move that we send Rule 1260-02-.09 as we have amended it this morning on to the appropriate agencies.
Motion by Commissioner McMullen, seconded by Commissioner Collins, that we wrap up our discussion of this particular rule by voting for the amended rule. If you're, let's see. First, is there discussion, or does anyone need clarification? That's a pretty poor description of what we're about to do by the chair. All right, I hear no discussion. Ms. Maxwell, let's vote on Mr. McMullen's motion.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
All right, thank you, Commissioners. We're now on to an amendment to Rule 1260-02-.12, found at the bottom of page 8 of 23. And we did receive comments on this particular rule from Steve Black, Todd Schuler, and J. Russell Farrer. Ms. DeChara.
I'd like to make a comment on the rule itself before we get into their comments. I'm not sure we ever discussed including business cards in that advertising, with the name on a business card having to be no larger than the company name. To me, business cards are kind of like name tags. If your name can't be any bigger than the company name on something that small, you probably just don't even need a business card. I'd like to see business card taken out of that.
Okay, let's come back to that. I've got a suggestion. Let's go to Steve Black's comment, and let's see if anybody wants to comment on his comment, which basically is he's suggesting sponsorship of charitable and committee events be considered promotional material and not subject to the general terms of this rule.
I would disagree with that, Chairman.
Okay.
I think what we're talking about here would be like large signs at charitable or committee events. and I think that with that large promotion, that the name should not be larger than the company name.
So your position is that sponsorship of charitable and committee events should not be considered incidental advertising.
Not a promotional material.
Okay, I got it. Other comments on Mr. Black's comment?
Mr. Chairman,
Mr. McMullen?
could I offer a little more general comment?
Sure.
I'm just wondering, based on our time that we have today, if it might make sense to maybe save the advertising rule comments for another meeting, because that's about 10 pages of the remaining 13 that we have here. And we have, I know, another rule that we wanted to talk about this morning, and then we have a lot to cover this afternoon and a formal hearing tomorrow. Would it make sense for us to maybe reserve the advertising for if we have time later today, or maybe next month, finish up with the other rules that we have in our memo here today, so they're all done, and then we could address maybe the advertising all at once, because I don't know that we're going to get through 10 pages of advertising discussion in time to get to the other things that we have on the agenda today.
Oh, I'd just like to make a comment that I feel like getting these rules done is more important than some of the other stuff. If we have to put off some of the other stuff, we might be better off to do that or postpone it till after the hearing tomorrow. But I think we need to get these rules finished up.
Other commissioners?
Well, I agree with setting it aside. It's going to be a lengthy discussion.
Mind, Mr. Bloom, is it setting aside to another meeting or later in this meeting?
Well, whatever could transpire, but my guess would be another meeting.
Ms. Hills?
I would agree, and my concern would be, and question would be, how would it affect the legal, or aren't we on the time frame, not for this, but for the cases this evening? So.
I think that it would probably be best if we could, this is just my opinion, if we could just tackle the rules as quickly as we can, just because the time frame on getting them filed and everything is already pretty drawn out. But Tony, I don't know.
One of the concerns that I would have also is that within this package of rules is the rule regarding the applications for, it's called military applicant rules, which would provide express licensing for military spouses, military members in certain cases, and that is required under TCA 43-1304, and it's in effect right now. So we are actually having to report to the legislature when all the commissions are in compliance, and right now this one is not in compliance. And I would just say, as fast as you could, that would be very, could find the time to have the rest of the rules looked at and commented on this month, that we greatly appreciate. I think it would be very helpful for the commission to be in compliance with that. Thank you.
So Mr. McMullen's suggestion, I think, is to kind of divide the question and handle the non-controversial rules today, which would include the military issue that you just brought up. Is that a possibility? Is there some reason why we can't divide the question?
Asking if we can go out of, like, do them out of order.
I'm just asking, can we handle 9 out of 10 of them today and handle number 10 next month? And those first 9 get in the stream.
And it would probably be best not to do that. I think it would be better to just tackle them all.
By a shaking of the head, Mr. Glandorf agrees with your assessment.
It's just a long process, and we just want to make sure that we are in compliance with everything that we need to be. So putting them off is kind of a.
Mr. Chairman.
Mr. Alexander.
I don't understand whoever's talking.
I'm sorry, it's Keeling.
The mic.
So Wendell, we're in the middle of a discussion about whether or not we ought to put off advertising. It's my sense that legal is suggesting that's not an appropriate thing to do, nor is it appropriate to divide the question basically, for lack of a better term, and handle some of them, but not all of them. They're all on the same track. Is that?
Well, what she proposed to do, 3 days without stopping?
Well, no. Here's where we are. Mr. McMullen, Mr. Bloom, and maybe others think that in the interest of time, we might want to take advertising and handle it at a later time or date.
Well, you need a motion to that.
Well, before, we don't have a motion at this point, but we've asked council's position on that, and it appears to the chair that council does not think that's a good idea. Now, they can speak for themselves, but that's my take on it.
Yeah, I mean, my concern is just I think we could spend almost the whole rest of the day probably getting through the rest of this memo, which if that's what we need to do, that's fine. I just was expressing my concern about that.
That's a fair concern.
Well,
Mr. Chairman, I'd like to express mine.
Mr. Collins.
You know, we've looked over these rules for 3 or 4 months, and I've pretty well made up my mind on them. And I don't think everybody has to put their seal on every item that goes on. We've talked about it and talked about it. I think we need to move on with it. Thank you.
Unless there's a motion, we're going to continue on. So the floor is open for a motion if any commissioner would like to offer one.
well, I'd sure like to offer one.
Thank you, Mr. Alexander. What's your motion?
My motion is that you defer the advertising until you've taken up all the other.
Is that later today, or is that a month from now?
That's later today if time permits. If it don't, we'll take it up next month.
All right, is there a second to Mr. Alexander's motion? We have a second by Commissioner Collins. The motion, as the chair understands it, is to take this particular section related to advertising, move it to the back of the discussion of these rules. Ms. Baird.
I think we should also take into consideration
Speak up.
that the court reporter, she's just going to be hanging out.
Well, the chair's interpretation of the motion is we can get the non-controversial ones out of the way, go back to advertising. That's the motion as I understand it at this point. Mr. Alexander, did I state that correctly?
What you stated it exactly what I meant.
I thought so. And we have a second to that motion. At this point, the chair's interpretation of the motion is we're going to handle advertising today, but since it may be the most controversial, we'll put it at the back of this particular discussion. Are the commissioners ready to vote on Mr. Alexander's motion?
Yes.
All right, let's do it. Ms. Maxwell, if you're in favor of pushing advertising to the end of this discussion, you'll vote yes. If you're not, you'll vote no.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease, Hills, DeChara,
Yes.
Collins.
Yes.
All right, that motion passes. It's still the intent of the chair and commission at this point to handle this topic today, just in a different order than originally presented. All right, Ms. Maxwell or council, where does that take us? What's our next rule? What page?
That takes us to page 19.
All right, we're going to page 19 of 23. And the new rule is found at the bottom of 19 of 23, which is 1260-02-.39. Commissions earned by affiliate licensees. All right, and we did have a comment from Mr. Farah. Some may argue that it's not pertinent. The chair might argue it's not pertinent. However, commission, any comments? Intent of the
Mr.
rules.
Chairman,
Yes, Mr. McMullen.
I move that we send Rule 1260-02-.39 to the appropriate authorities and respond to the comment by stating that it is not pertinent to the proposed rule.
We've got a motion by Commissioner McMullen, seconded by Commissioner Collins. You've heard the motion, Commissioners. Is there discussion? All right, let's vote, Ms. Maxwell.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease, Hills, DeChara,
Yes.
Collins.
That motion passes unanimously. We're now into new rule 1260-02-.40, electronic records.
Mr. Chairman, I move that we send new rule 1260-02-.14 on, -.40 on to the appropriate authorities.
Motion by Commissioner McMillan, seconded by Commissioner Collins, that this be forwarded on to appropriate government agencies. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye. I'm sorry. Roll call. Excuse me, Ms. Maxwell.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
That motion passes unanimously. Now we're on page 21 of 23. New rule 1260-02-.41. Licensees who hold themselves out as a team, group, or similar entity. All right, we have comments from a couple of different individuals related to this proposed new rule. One by Bradley Scott Troxler and one from Aaron Armstrong. Would you like, commissioners, to address those comments before we entertain a motion? Or is the commissioner prepared to make a motion at this time?
I'm concerned about where Mr. Bradley Scott Troxell's getting his information that an agent don't have to be on site.
Right, other comments?
I think it has nothing to do with being on site, except they're licensed at the real estate office. They
That's
can't
what I'm talking
get out
about. I mean,
somewhere else.
I don't think there's anything that says an agent can operate out of a different location than their
Right.
office.
But you,
Right.
no, statutorily you can, but it's considered a branch office at that point with a principal broker.
Right, but I mean,
So I agree with both comments that I don't think we have the latitude to do that, nor do I think it's what I would suspect is adequate supervision. So, other comments?
well, in response to Mr. Armstrong's comment, where we let teams from different locations advertise together, my concern is that nobody's going to be overseeing that. If you open that up just to say whoever wants to advertise together can advertise together.
Well,
Jara, could you state your responses to those two comments in the form of a
Well, I'm thinking about that, Mr. McMullen.
would it be fair to say, Ms. DeChara, that the physical address of all licensees has to be the address of their principal broker?
That would be fair to the first one.
Is that could that be your response?
That could be my response to that. The second one's one
The second one is kind of confusing because we can sell property in anywhere in the state of Tennessee. It doesn't matter, where if I'm advertising in Murfreesboro and I'm Franklin, it's still the same rule.
Thank you, Ms. Franks. It seems to me that the intent of his comment was to suggest that a team could be made up of members of different licensed real estate companies.
Right.
And so
That's not possible.
That's what she said.
she said that's not possible. So you disagree with the comment of Mr. Armstrong?
Yes, I do.
Chairman, I concur with Ms. Banks. You can't do that.
All right, so the motion that we're looking for has to do with a reaction to each of these comments and then what you want to do with the rule.
Okay, to Mr. Troxel, we need to respond that a licensee must have their license at the location of their principal broker. And that's not changed. And to respond to Mr. Armstrong, that each principal broker is responsible for the advertisement of his agents within his firm. And that opening that up is impossible.
So therefore, you don't think we need to change the rule?
I do not.
I second that motion.
All right, motion by Commissioner Chara, a two-part motion, one commenting on each of the comments from Mr. Troxel and Mr. Armstrong, and the second part which says, based on those comments, there's no need to change the rule as previously submitted. That's what's in front of us, Commissioners. You want to discuss?
Call for the question.
Thank you, Mr. Alexander. Is there an objection to the call? I hear no objection. Ms. Maxwell?
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom,
Yes.
Collins, Grease,
Yes.
DeChara.
Yes.
All right. The second part of 1260.02-.41 is found at the top of page 22 of 23. Mr. Farah commented on that. He was again trying to get the rule to clarify or state that a licensed assistant can be paid by the licensee. I think his point is as long as that licensed assistant is not doing work which would be considered real estate license required work, poorly stated.
That's such a, and that is just a train track ready to, train wreck gonna happen because it's, why do you need someone to assist you to do work when it doesn't have anything to do with real estate?
Well, I think his point might be that you might have clerical help that you as a group or team leader pay, and it's okay for that to happen. But I think the statute already says that.
Well, and
That's their license. It's saying it's their license.
Well, that's true.
and it's spelling out that it's in what's in Title 62, Chapter 13, which spells out what you can pay somebody for.
I think that rule should go forward as it's stated.
So, Mr. Bloom, your comment to Mr. Farah's comment is that already is the law, for lack of a better term?
I think that's correct.
I second that motion.
All right, so on this particular subsection, Mr. Bloom has a two-part motion, one responding to Mr. Farah saying, we don't disagree with you, but we think it's already in place. And second of all, there's no reason to check the language that was previously submitted by this commission. Did I state that correctly, Mr. Bloom?
Correct.
Mr. McMullen, you're okay with that? Is there discussion on the motion? Let's vote. Mr. Collins. Pull your microphone, please.
Agreeing with the first part conflicts with the total motion that he was concurring with Mr. Farah.
Well,
to me.
Here's my take on it for what it's worth. Mr. Farah is stating what's already in place. He would just like for it to be restated in more bold print.
Okay, thank you.
I think that's as I take it.
You explained it well.
Thank you. All right, I think we're ready to vote, Ms. Maxwell. The motion, if you agree, you'll vote yes. If not, of course, you'll vote no.
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen, Bloom,
Yes.
Collins, Grease,
Yes.
DeChara.
Yes.
All right, at the bottom of page 22 of 23, Steve Black Bradley Scott Troxler, Andy Brown, and J. Russell Farah have all made comments to proposed language related to this subsection of rule, whatever, 1260-02-.41, sorry. Just as a point, just maybe to help the discussion move a little bit here, the rule basically says the principal broker shall not delegate his or her supervisory responsibilities. No licensees who hold themselves out as a team group or similar entity within a firm shall represent themselves as a separate entity. And no licensees who hold themselves out as a team group or similar entity with a firm shall designate members as designated firm agents, as this remains a responsibility of the licensed firm's principal broker. So we received 4 comments on those portions of the rule. Mr. Black, I think, just makes a comment. I don't know what kind of response we want to give with that, except if we need a response, I suspect a member of this commission might say we agree.
We do agree.
Is there any objection to that response? That's going to be incorporated into a motion in a minute. Mr. Troxler, I'm not going to try to paraphrase it. You all can see it there. But it appears to me his comment says that teams can provide better training and supervision than the principal broker in many cases.
I think we need to respond to Mr. Troxler that it is still the responsibility of the principal broker.
And without objection or amendment or modification, that will be incorporated, Mr. Charles' comments in a moment, into a motion. Mr. Brown, in this statement, I think more than a suggested change is that as a team leader, personally, he does a lot more than what he would expect any principal brokers do to take care of members of his team related to training. Or somebody might read that paragraph to say, what does supervising mean?
I don't know what he's asking.
Responsibility, the principal broker.
And the principal broker's duties are outlined in the rules and law.
All right. Let's move to Mr. Farah's comments for just a second. Again, he's asking a question more than making a comment, I believe. Look through that and let's get your comments on it.
I think it's fine for a company to advertise for their commercial divisions. If it said Franklin Realtors Commercial on it, still had all the things that are required. Just because it says commercial on it, I have no problem with that, or property management, or REO.
Well, a broker can only manage 2 firms in the same location. If you've got a REO division, a commercial division, a residential division, a property management division, then you have 4 different divisions.
That's divisions. It's not different companies, though.
To Mr. Farah's comments, so his question is, this rule that we're proposing, where we address teams, groups, or other similar entities, does that also apply to divisions within a company?
Well, anytime you do business, you're going to have to be in the same building for each building.
Let me say it a different way. So let's say that there's a commercial division of a real estate company. Who's the principal broker of that commercial division?
Principal broker.
Is that the same as if a team were in that same company?
True.
So to Mr. Fair's question, are these rules going to apply to divisions as well as teams?
I think that the team, if you either going to, the principal broker's either going to have to be responsible for every team. Team's got to have a principal broker and go out on their own.
Mr. Alexander, if a company has a relocation division, does that division have a principal broker, or does the company's principal broker supervise the relocation division?
You'll have to ask somebody that has one that's been familiar with one. We don't have them in Dresden, Tennessee.
There are just people relocating out of there, aren't there? Not in, so.
Well, we do, and it doesn't take a separate principal broker. The principal broker, it's a broker over license. It's not over a team, a group, relocation. It's over licensee.
All right, so I'll pose one more question and be quiet. Let's say a company has multiple offices, and agents occasionally want to say they're in the commercial division of one of those offices. So across the town, agents out of 5 different offices all say they're in the commercial division. Who's their principal broker?
Principal broker is the broker that where his license are registered with the Tennessee Real Estate Commission.
That's right. It's where the license is on the wall.
All right, so back to Mr. Fair's question, should a division be treated like a team?
I don't think we should put names or divisions or teams or groups or anything on it. It should just be licensee.
I believe I can answer that real simple.
Thank you.
If you have a commercial division or whatever you have, a relocation, as long as it's in the same building, broker can be the principal broker in that office is responsible for everything in it that's happening there, including teams.
I agree.
All right, I think there's consensus there. So to respond to Mr. Farah's comment, it sounds to me as if one or more of you all said that wherever your license is, the principal broker is in charge of each individual license, regardless of how that license is classified.
Right.
Other comments on that?
I'm of the opinion that you can have different divisions, or you can have somebody that does commercial. In Dresden, Tennessee, we do it all. As the principal broker, I'm responsible for whatever that agent's doing. He's selling commercial property, land, or homes, or whatever. Principal broker is responsible. Be the same way with a principal broker. Got 14 teams and 40 folks on them 14 teams.
Mr. Chairman, I have to leave. I will be back in touch with you on my mobile.
You want to vote on this, Gary? We're about ready to do it, and we can go on.
Okay.
Is there a motion? Let's just talk about the rule. Does anyone see any reason to modify the rule based on these comments?
No.
No.
Okay, so Mr. Char made a motion that the rule should be submitted as previously submitted, seconded by Commissioner Franks. We're going to take care of that. We'll come back to those comments if you need to. All right, is there discussion on the motion?
All for the question.
Thank you, Mr. Alexander. Is there objection to the call? I hear none. Ms. Maxwell.
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom,
Yes.
Collins,
Yes.
Grease,
Yes.
DeChara.
Yes.
All right. Gary, thank you. We're going to take a quick vote on maybe these comments. But
Okay.
if you want to get in your car and
I'll be
call us
back.
back, that'd be
Okay.
great.
All right.
All right. Do you think, ladies, that you've heard enough from us that you've got our comments on their comments, or do you need a formal on each one of them?
Well, it's probably better to just comment on each one individually. I am.
All right. So regarding Mr. Black's comment, the chair would entertain a motion that the commission agrees. Are you making? You're
I'll make it.
Okay, Mr. Char made it. Mr. McMullen seconded that motion that we agree with Mr. Black's comments. Is there discussion on that motion?
And that no change to the rule is necessary.
Thank you. All right, you've heard the motion. Let's vote. Ms. Maxwell?
I'm running out of little sheets of paper here. Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen, Bloom, oh, it's gone. Collins, Grease,
Yes.
DeChara.
Yes.
All right, the second comment was from Mr. Troxler. He basically thinks if we pass this rule, Trek will be taking a step backwards. So do you have a comment on that we can put in the record?
Don't
I
feel
think,
the
I
need.
think I think we could. I would accept a motion that said we disagree with his comments.
Well, I'll make the comment to Mr. Troxel that we disagree with his comment and it's still the job of the principal broker.
A motion by Mr. Char, seconded by Mr. Collins. You've heard the motion. Is there discussion? Let's vote. Those in favor of that vote. And there was that little line you like to put at the end of it, Austin, and therefore there's no reason to change. We'll add that to it. All right, let's vote, Ms. Maxwell.
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen, Bloom, Collins, Grease,
Yes.
DeChara.
Yes.
Okay, Mr. Brown. Asked for better definitions of supervision, the word supervision. And I think Ms. Franks at some point referred him back to the statute that has the definition. Is that right, Ms. Franks?
That broke up. I couldn't hear that. Say that again.
I believe that you had referred or discussed the idea that Mr. Brown could go to the statute to find the definition of supervision.
Exactly.
But would you like that to be your motion in some form or fashion?
Yes.
And therefore, there's no real reason to respond further to his comments or to change the proposed rule.
That's correct.
Is there a second to Ms. Frank's motion? Seconded by Mr. Chara. Discussion on the motion. Hearing none, let's vote. Ms. Maxwell.
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom, still on, Collins, Grease,
Yes.
DeChara.
Yes.
That motion passes unanimously. Finally, Mr. Farah had comments, and I believe Mr. Alexander sounded like he was making a motion that said whatever licenses are associated with a principal broker are to be supervised by the principal broker. And so it doesn't matter what they're categorized as long as that license is at that firm. Is that what you said, Mr. Alexander?
That's correct.
Is there a second to Mr. Alexander's motion?
Second.
Mr. Collins beat you, Ms. Franks. I know you couldn't
Okay.
say that, but he did. Is there a discussion on the motion? Ms. Hills?
And I understand. I just it escapes me as to how I understand these comments and these directions. It escapes me as to how to clean it up or tighten it up. I've thought and thought.
Mr. Chairman,
Mr. Alexander?
to be true with the teams, and you did not mention that, the principal broker is responsible for every team.
I thought your motion said he was responsible for every license inside his firm,
That's right.
regardless of how they're classified.
Correct.
That's what I believe the intent of your motion was.
True.
Okay.
And I think that the you don't have to have separate firms unless the people are out there representing their team to be a separate firm. I think that's the point of what I think is section 4 within that, or paragraph 4 within that section.
So, Mr. Alexander has offered a motion, and I can't recall who seconded it. Was that you? Mr. Collins seconded, beat Ms. Franks, as a matter of fact. All right, is there further discussion on the motion? Are you ready to vote? Since you are, let's vote, Ms. Maxwell.
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom, Collins, Grease,
Yes.
DeChara.
Yes.
All right, friends, that takes us back to advertising in this
I
item.
think we need to vote on the rule.
That's
and-
correct.
Yeah.
So
Sorry.
we've spoken to specific sections of that rule. Now we need to go back, and the chair will accept a motion about the entire rule as we have discussed and amended when necessary.
Can we amend any of it?
You know,
I don't think so.
No.
Okay, motion to send Rule 1260-02-.41 on to the appropriate authorities.
Second.
motion by Commissioner McMullen, seconded by Commissioner DeChara, that the rule as previously submitted be resubmitted to the appropriate governmental authorities. Is there discussion on the motion? Let's vote. Ms. Maxwell.
Hills,
Yes.
Franks,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom, still gone, Collins,
Yes.
Grease,
Yes.
DeChara.
Yes.
All right, ladies and gentlemen, we're back to page 8 of 23. Yes, Mr. Collins.
Previous rule. You have 1260-02-.09 deposits and earnest money. Is that what he's asking if they approved the whole thing in its entirety? Yes. I have it.
I thought we did.
Yes.
All right, Commissioners, we're back to advertising, page 8 of 23. Is there a desire of any commissioner to take a quick break before we get into this? All right, let's take 5 minutes and we'll be back. Thank you guys on the phone for sticking with us. And I assume Mr. Bloom will call back in shortly.
Okay.
60-02-.12. We've had 3 similar comments 10, 11, and 12. And let's, for the record, make sure we're back in session. And then, commissioners, each of those 10, 11, and 12 have this thread of charitable and community events running through those 3 comments. Who would like to speak to those?
Should we just take on each one, and because I think we could do that pretty quickly, unless you're wanting to vote on all 3 of them at the same
Oh,
time.
it's fine with me. We need to address each one individually, so that's perfectly okay. Do you want to start the discussion on Steve Black's comment?
Okay, the suggestion to include sponsorship of church. I don't think that needs to be separated out. I think signage would be used in those cases, and so we do not need to add or include sponsorship for charitable and committee events. If there's a sign, it's signed regardless of where or how it gets put.
I think we need to add sponsorship.
Okay.
I think we need to add sponsorship. 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 I think we
All right, that's Ms. Frank's comment. Just get the topic on the table. Marcia, do you want to make that in the form?
Yes, that's that Mr. Black, we do not feel that his suggestion is needed.
Okay. Is there a second to Ms. Frank's motion, which is basically to thank him for his comment, but tell him
Right.
that signage is signage? Is there a second?
I'll second that.
All right, a motion has been made by Ms. Franks related to Mr. Black's comment and seconded properly by Mr. Chara. Is there discussion now on the motion, which is basically to say we don't see it the same way you do?
Yeah, I have a comment. I think our concern ought to be that the signage on a property for sale is adequate and it informs the public what's for sale. And if an individual wants to help in a charitable organization, I don't think there's any deception. I don't think there's any problem with them doing that.
Make a substitute motion so we have your thoughts on the floor. Gary?
Yes.
The floor is yours if you would like to make a substitute motion that basically reflects the thoughts you just stated.
I'll make a substitute motion consistent with what Mr. Bloom said. My substitute motion would be to keep Rule 1260-2-.12 as it currently is in our book instead of what's in the new rule that we're looking at. And
all right, we have a substitute motion offered by Commissioner McMullen, seconded by Commissioner Collins, and Mr. McMullen has referred us to which page in the book?
66.
Yeah, and just for discussion purposes, what it says there is that the advertising that we're regulating is the advertising that promotes the sale or lease of real property.
Right.
And the new rule says that we're regulating advertising that promotes a licensee or the sale or lease of real property. And then once you do that, then you start getting into all this additional language about what is or isn't advertising. You just keep it as it is, and currently that it's advertising that promotes the sale or lease of real property, then you don't get as far as that because you're not regulating that promotes a licensee.
So Chair will just give a comment. I think part of the reason this rule even came about was because of advertising by licensees who are holding themselves out, sometimes separately from the firm they were even associated with. And so, Mr. McMullen, are you suggesting that we don't need to worry about that issue?
Well, if they're not trying to sell real estate or property, I don't see that that's a problem. I think our responsibility is to regulate signage on the sale of property.
The rule that Austin's referring to, it says all advertising, regardless of its nature and the medium in which it appears, which promotes the sale or lease of real property, shall conform to the requirements of this rule, which is going to include things like your letterheads, your flyers, your websites. And I'm kind of thinking we're starting to spread ourselves too thin when we start trying to regulate everything an agent does. Because if you sponsor an event, sometimes you're only allowed 2 lines or very limited space. So if you're allowed 2 lines and you've got to put your company name and your company phone number on there, then you can't even put your own name on there.
If I may, let me just follow up for a second. I think Mr. Black I'm not trying to read his mind, but I think he wanted to make sure sponsorship of charitable and community events fall under the last sentence in the proposed rule, that advertising does not include sponsorship of charitable and committee events. I think that was his intent. And from the chair's position, I agree with Mr. Black. I think that's fine, but I think that's a little less in scope than what Mr. McMullen is suggesting at this point.
I agree that his change is different than what I was suggesting. I think that if you went back to just what we have now, that sponsoring a charitable event is not promoting the sale or lease of real property, and so I don't think the charitable event would be regulated by what we have now. So that's my recommendation.
If it's a two-part motion you're making, one is you agree with Mr. Black, and would the second be, I'm not trying to put words in your mouth, would the second be to amend the last statement of the proposed rule to include or to identify sponsorship of charitable and community events as not subject to these advertising rules?
The second part of mine is to just not get into the idea of regulating advertising that only promotes a licensee, and so therefore keep the language that we have in the current rule as opposed to the new rule. I think that's consistent with what Commissioner Bloom was saying.
That's right.
I think that I sort of agree with his point on that, and so that was the reason I made the substitute motion.
So, just again for clarification, if your motion passes, do you and Mr. Bloom and others who want to speak to this think that a licensee can advertise without identifying their firm at that point?
John, I didn't understand that.
So my question is, if Commissioner McMullen's motion passes, in your mind, Gary, does that mean a licensee then could advertise himself or herself without including the company's name and company information in that advertisement?
No.
Are you talking about during for charity reasons?
Just in general, if a licensee wants to promote themselves, I think Mr. McMullen's motion says they can do that without any restrictions on their advertising.
Oh, I don't think that's right.
I'm not sure if I'm putting words in your mouth, Austin. Let me know.
So I think if we say you're going to sponsor a ball team, and the shirts, do they need to say Franklin Realtors, or can they say the Marcia Frank team?
Again, I'll let Commissioner Mullen speak to this, but I think the scope of his motion is pretty significant in that it gives a licensee the latitude to advertise or promote himself or herself without any designation of which company he or she is with.
Now, wait just a minute. Let me ask the question.
You have the floor, Mr. Alexander.
I'm trying to determine if he's talking about advertising or if he's talking about
Wendell.
Yes, sir.
You broke up on us. Would you say that again?
Question is if he's talking about all types of advertising or is he talking about charitable organizations and caps, pencils?
Wendell, you cut out on us a little bit there, but the what I was proposing would have been broader than just the charitable advertising, so that hats, pens, note cards, etc., that only are promoting a licensee would not be subject to the rule. Either way, the hats, pens, and note cards and whatnot are exempt, whether it's under the new rule or the old rule. I understand John's concern about licensees being able to advertise, I guess, just to promote themselves without any particular property being affected, and that this would take out regulation of that. I understand that concern. On the other hand, when you get in, you start really getting into this stuff. It's a real thicket of having to draw lines, and that really makes it pretty difficult. There's not probably a good answer either way, but I offer this as a substitute motion because I'm sympathetic to the position that Commissioner Bloom stated.
I would also like to make a comment, though, that while we are promoting the sale of real estate, if you're doing a radio commercial or a television commercial or print advertising, you should have to put your company's name included in that. You shouldn't be able to run an ad just call the Gary Bloom team and blah, 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 and not ever say what company you're with. I don't think you can leave the company name out of television advertising and radio advertising.
So, Mr. McMullen, I think the effect of your motion as currently on the floor would give an agent that latitude to advertise without the company affiliation. I want to make sure I stated correctly.
To the extent they have the ability to do that now, then it would basically leave that in place.
And where most of the rules to do that.
Guys, on the conference call, we can't hear you clearly.
Marcia, you're breaking up completely.
Okay. Can you?
That's better.
Okay. Okay, now I lost my train of thought. I was asking, book, where specifically is he looking?
Right now. Okay, can you hear me? Right now, our current rule, not the amendment that we're talking about, but just the one that's already the law right now, says all advertising, regardless of its nature and the medium in which it appears, which promotes the sale or lease of real property, shall conform to the requirements of this rule. So that's the language I was reading from, which is what the current law is, and then obviously we have the law.
Then what this says then?
Right. What we're looking at now would be a potential new rule that adds to the definition of what's regulated, any advertising that promotes a licensee.
Right.
And then it gets into differentiating certain types of advertising as being advertising and certain types of, other things that are not defined as advertising.
Okay, so I'm going to restate this again just so we keep focused on it, but it appears that Mr. McMullen's motion only wants the Tennessee Real Estate Commission to regulate this advertising related to the sale or lease of real property and not regulate advertising related to licensees promoting themselves. Is that stated correctly?
I think that's accurate.
Okay, that's the motion I believe is on the floor at this point. Ms. Hills.
Now,
Go ahead, Mr. Alexander.
then that takes away our ability to do anything about all this team
Perhaps.
Pardon?
Perhaps. If we don't have if a case could be made if this motion passes that licensees can advertise themselves any way they would like to, and we can't regulate that at the Real Estate Commission.
Except on yard signs.
Except on signage. Thank you. Ms. Hills.
I think adding the either a licensee is just a key factor. If the rule as it stands now was followed, or it's just gotten so out of whack, and I think that's why it's important to add the licensees. Now, whether we give so many examples or something, maybe that's not it. Maybe we've gotten lost in all the examples we've given, and we should just have it in advertising property lease or licensees.
Well, I may be, you through, Ms. Hills?
Yes.
Yes, go ahead, Mr. Alexander.
I'm a, Austin, I may be a little bit confused about your.
Mr. Wendell?
Yes.
The first statement it reads is all advertising, regardless of the nature or the medium in which it appears, which promotes the way it is now, the sale or lease of property, but we're adding or propose to add, or either a licensee, and I, in my interpretation of what you had said before, I think that is what you had said you wanted for licensees not to be. And that's my concern on having it, keeping it the way it is now. I think it does need to include the licensees.
So can we go ahead and vote on the question?
Let me make one statement, and then let's vote.
Maxwell's not here.
Well, we can do it. So none of the three comments related to this rule that we're considering right now spoke to the either a licensee portion of the proposed rule. They only spoke to what's included in promotional materials, in my mind.
Yeah.
Well, the comment from Todd Scholler did get into that concept, that the distinction between advertising on, sale signs and things like that, as opposed to just advertising the licensee.
Right, point well made. Thank you. All right, the motion.
Mr. Chairman.
Yes, sir.
Would it be possible that I think most of us have a pretty good feel for what a sign on the property ought to look like? It's this other that we're having trouble with. I wonder if there's a possibility that we could have a rule separating the two, what a sign ought to look like and what advertising for a licensee ought to look like.
I understand your point, Mr. Bloom, but that's really not in front of us at this point, I don't think. That's under a different rule.
Could you not break that out into two? Leave the one like Austin is proposing that's already in place, and then do another section that addresses the licensee advertising?
Here's what we're going to do. We'll vote on Mr. McMullen's motion, and if it passes, we can move on to the next section. If not, we're still on the topic, and then we'll see what it looks like. Unless somebody wants to tell me the chair is out of order making that suggestion.
That's a good suggestion.
All right. Well, let's. Does anyone desire to discuss this more before we vote, or are you ready to vote? Mr. McMullen is going to restate his motion.
My motion is that rather than going forward with the proposed change to section 1260-02-.121, we instead keep the existing 1260-02-.121 that we have right now, which says all advertising, regardless of its nature and the medium in which it appears, which promotes the sale or lease of real property, shall conform to the requirements of this rule.
All right, you've heard the motion. I'm going to ask Ms. Smith to call the roll. If you are in favor of Mr. McMullen's motion, you'll vote yes. If you're opposed, you'll vote no.
Bloom,
Mr. Gary Bloom, you're first.
Oh, yes.
Alexander,
I'm so confused, I'm going to vote no.
Franks,
No.
McMullen,
Yes.
Grease,
No.
Hills,
No.
Deshara,
No.
Collins. You seconded.
It's okay. It's okay.
All right, it fails.
Okay, the motion fails on a 7-no, let's say 2 yes, 7-no vote. The floor is open for further discussion.
Six yes.
Six and 2, I'm sorry.
6 no, 2 yes.
Yep. All right, the chair's anxious to entertain another motion. Would a commissioner be willing to make a motion that includes sponsorship of charitable and community events in the last paragraph of the last sentence of the proposed rule.
I'd like to make a motion.
Go ahead, Ms. Franks.
I'd like to make a motion that we approve Rule 1260-02-.12 as written.
All right, so Ms. Franks has offered a motion that says no change made to the motion the rule we've previously offered to the state. Is there a second to that motion? Last. All right, the motion is properly seconded by Commissioner Collins. Now, discussion on the motion.
Well, I still think we need to move business cards down to the incidentals. And I would be willing to offer an amendment to the motion.
I think one of the problems is the word incidental. Because they wanted clarification, Todd Scholler wanted clarifications of incidental. Maybe we need to take out that word, incidentally.
Well, let's, just for purposes of keeping on track, let's vote on your motion, and we can come back and craft another one, depending on how this goes.
Call the roll.
Okay, this is to.
Okay, so is there an objection to go ahead and voting on Ms. Frank's motion, seconded by
Could I
Commissioner
make
Collins?
a friendly amendment?
You can make a substitute motion at this point, just so I can keep track of it.
Okay. All advertising, regardless of its nature and the medium in which it appears, which promotes either a licensee or the sale or lease of real property, shall conform to the requirements of this rule. The term advertising for purposes of this rule, in addition to traditional print, radio, and television advertising, also include, but is not limited to, sources of communication available to the public such as signs, flyers, letterhead, email signatures, websites, social media communications, and video or audio recordings transmitted through internet and broadcast streaming. Advertising does not include promotional materials that advertise a licensee, such as hats, pens, notepads, t-shirts, name tags, business cards, sponsorship of charitable events or charitable or community events.
All right, so this is the substitute motion offered by Commissioner Tachara, seconded by Commissioner Collins, that for all intent purposes moves business cards from the body to the last sentence, includes charitable and community events in the last sentence.
Takes incidental out.
And takes incidentally out. Okay, commissioners, do you have questions for Ms. Tachara or comments on her motion? All right, I sense you're ready to vote. Ms. Smith, let's roll call this.
Okay, Bloom,
No.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
Deshara,
Yes.
Collins.
All right, that motion passes on a 7-1 no vote. Now, let's talk about this. Go back to these comments for a minute and address the comments. Ms. Tachara, would you state that you agree with Mr. Black's comments?
I agree with Mr. Black's comments, and we have adjusted our motion to verify that.
All right, so I'm going to take that as a motion. Is there a second to that?
Second.
All right, the motion is to confirm that we agree with Mr. Black's comments. Is there discussion? I hear none. Let's vote. Those in favor. I'm sorry. Let's roll call it. I'm moving too fast.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease, Hills,
Yes.
Dechara,
Yes.
Collins.
Right, Mr. Scholler, at least in a portion of his comments, had the same thoughts. And then it appears he asked a question about how advertising has changed. And the chair would love to get a motion that addresses Mr. Scholler's comments.
Well, we have taken out incidental and we have taken out the like. So that clarifies that.
Your motion is that you agree with two of his comments and further agree that times have changed as far as advertising.
Absolutely.
Okay, motion by Commissioner DeCharis, seconded by Mr. Collins, designed to address his comments. Is there discussion on Mr. DeCharis' motion? All right, let's vote. Ms. Smith.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
All right, Mr. Farah had a comment. Mr. Char, can you make a motion?
Mr. Farah, comments have been addressed in Mr. Black's and Mr. Schuler's comments, so that has been attended
So
to.
you, and your motion basically says you agree with Mr. Farah's comments and have incorporated them into a revision, as I understand it.
That's right.
That's what you said too, Mr. Collins, right? All right, that's the motion. I've got a call for the question. Is there an objection to the call? All right, Ms. Smith, let's roll call us.
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
All right, we're going to the bottom of page 9 of 23, the very last sentence, item number 2, under 1260-02-.12. We have a comment from Julie Moss. If commissioners will take a look at that.
What page was that on?
The comment is at the top of page 10 of 23.
Thank you.
I'm really a little confused about her comment, because by being allowed to use either the name of the firm or your DBA, that makes you able to distinguish your firm. So I'm not sure what else she's wanting to do other than that.
Well, I think the position of the commission at this point is we give the firm the choice of registration or DBA. So I understand her question. I don't know that a comment other than.
I think the rule speaks for itself.
That's your motion, is that right? Thank you, Mr. McMullen, for that motion, seconded by Commissioner Collins, but basically the rule as written and interpreted speaks for itself.
And so therefore we're not making a change and moving forward with it.
Okay, the motion is no changes necessary to this subsection. Is there disagreement or discussion on that motion? If not, let's vote. Ms. Smith.
Bloom,
Yes.
Alexander, Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
Okay, comment number 14, found in 2/3 of the way down page 10 from Mr. Farah, asks if all subparts of section 3 apply to all advertising or just signage. So your comment would be,
We've addressed it.
and what do we say? Might as well be clear on it.
Voting on the changes, we've addressed all those matters.
I think you have to read each subsection. Like, for example, subsection D seems to talk, or 3D seems to talk just about signs. But, F talks more generally about advertising.
I think maybe to get a sense of what commission is thinking, commissioners, do you believe these proposed advertising rules apply to all advertising media as listed up there in number 1? Or to Mr. Fair's question, is it just the signage?
I believe it applies to everything is listed in number 1.
Oh, that's listed it because there was questions about it.
So, Ms., is there other discussion or comments on that? Mr. Chara, would you like to, in response to Mr. Farrell's question, say that the purpose of these proposed rules is to apply to all advertising as listed up there in paragraph 1?
I would.
That's the motion offered by Mr. Chara. Is there a second?
Second.
Second by Commissioner Hills. Now, discussion. Is there any commissioner that thinks these rules only apply to signage? All right, I'll take by your silence that no one wants to comment on that. Let's vote on the motion, Ms. Smith.
Bloom. Bloom.
Yes.
Alexander.
Yes.
Franks.
Yes.
McMullen. Grease.
Yes.
Hills.
Yes.
DeChara.
Yes.
Collins.
All right, at the bottom of page 10 is the start of a proposed rule that received comments at the top of page 11. And we have 3 different comments, one from Julie Moss, one from Russ Farah, one from Philip Cantrell. And let's talk about each of those individually before I entertain a motion. Ms. Moss asks, what does prominent mean? Oh. And so the question, the chair will pose to the commission, is it the commission's role to describe what prominent means, or is it the commission's role to be able to look at an advertisement and tell whether it's prominent or not?
Well, I think this is very important because this could be financially a real burden for all the different companies that we're looking after. If you have to change, like Benchmark sign, you know, the letter he sent to us, that would not comply. But I think it meets all the requirements of telling the public who is listing this property. The property is for sale. I think some of that has to be in the purview of the broker. And I really think that we ought to keep the current rule in place, 6213.310B.
Give us just a second to look that up. 6213.310B?
Yeah. If you figure a sign $40 to $50 somewhere in there, and you're going to figure that 75 to 80% of our companies are not going to be in compliance with this, you can do the math, and that's pretty significant.
All right, so
310B.
60, for those on the call who might not have this in front of them, 6213.310B says, licensees may not post signs on any property advertising themselves as real estate agent unless the firm's name appears thereon in letters the same size or larger than those spelling out the name of the licensee. The proposed rule not only, I'm not even sure if it addresses signage, but it speaks to all advertising, which would include signage, which is already.
Yeah, that's the reason that for me, it's pretty simple what we ought to do with signage. It's not real simple what we ought to do with licensees.
So, Gary, just so we can discuss this, do you agree the firm name should be the most prominent entity, or are you suggesting an agent's name could be the most prominent entity?
I'm suggesting that the broker could make that call.
One of the things that I think part of this addresses that is not addressed in 6213.310B is the firm telephone number. And I think that's why we started looking at it, is because that part is not real clear, is about the firm telephone number even having to be on a sign.
Yeah, I would suggest that the firm name and the firm phone number be the same size, and the licensee and the licensee's phone number be the same size.
Regardless of the advertising medium?
No, signage on property for sale.
Same size or smaller for the licensee? This is Diane.
Yeah, either one would be fine with me. I think that's still a broker's call. I don't think that I ought to be interpreting how a sign ought to look for a company.
I want you to just think about looking at it from the perspective of the public, not the broker or the licensee. My initial thoughts are that a person ought to be able, if we're holding the principal broker responsible, then it should be easy to identify which company this licensee is affiliated with. That's why I offer a little bit of pushback to your suggestion.
So the company name and number would be bigger than the licensee.
Or maybe the middle ground is at least the same, no larger than, or the same size.
Yeah, okay, I'm all right with that.
And that's actually the next section that we're going to vote on. Number 2.
So
I'm just hesitant for us to be able to tell ABC how their sign ought to look. As long as it comports with the law and tells the general public, I'm selling this property.
I think one reason why we put the prominent part in there was because we were seeing issues where they were putting the company name maybe in a light yellow and then putting their agent name in black, so that the company name is barely visible because of the color that they're using. And I think that was when we put prominent in there.
So are we in agreement that somebody could have a billboard, and the billboard have the agent's picture real big on it, and then lower a small name of the company, and that agent's name has to be no larger than the size of the company name?
Yes.
I think that's probably accurate.
Okay.
Your thoughts are what did you say?
You know, if somebody wants to put a big picture of themselves on a sign or a print advertising or an internet advertising, as long as that agent's name is no larger than the company's name in that same advertisement, you know, I think I'm okay with that.
Yeah, I am too.
So what does entity mean? The firm name must be the most prominent entity. Does that mean writing or?
Because if you use entity, then that's going to mean it should be more prominent than the picture.
I think that's what's. It's. I mean, you can debate about prominent, but I think you could also debate about entity. I don't know what I mean, like if entity doesn't mean pictures, then you don't got to worry about that. I mean, does entity mean the word for sale? You know, does the firm name have to be bigger than the words that say for sale?
Or is an entity a company?
Yeah, or does it mean company? Or name, or...
It seems to me that if you are going to be able to allow an agent, if he wants to spend his money to put his picture on a billboard, that he do so. If you're going to stick with what the rule says right now, then you're going to have to put the broker's picture on there too.
My picture on there.
So back.
What if it said most prominent name?
That wouldn't be better.
I think Gary has a good idea, and he and John both. As long as you've got a firm's name or that team's name can be any larger than the firm name or the firm telephone number. Is that what you all are trying to?
This. All advertising shall be under the direct supervision of the principal broker and shall list the firm name and the firm telephone number as listed on file with the commission. With regard to the size and visibility of the firm name and firm telephone number, all of the following shall apply. Number one, the firm name shall be the most prominent name featured within the advertising, whether it is by print or other media. And
Second.
Okay, that was a motion by Commissioner Charis, seconded by Commissioner Frank. Sorry, Mr. Collins, you were late on that one. Now, discussion. So let me just ask this question. So you could have a company name, an agent name. Those two could be the same size. And then could you have, like, below that in larger letters, janetdechara.com?
No.
no, because that would make my name larger than the company name.
Well, your name is already up there. We're talking about a different entity.
Oh.
So I'd like to get some clarification on that before we vote on it. But I can see that happening. Or is your intent, Mr. Char, that the name, regardless of where it is in the advertisement, can't be larger?
That is my intent, but I don't know how you're going to say that. Other than
JanetDechara.com sounds like a name to me.
it does to me too. So, but I can see John's point there.
Well, I'm almost ready to vote. All right, there's been a call for the question. Is there an objection to the call?
Well, what are you going to do? Yeah, I would check right.
All right, thank you, Mr. Sar. So we're going to vote on the call for the question to see if you all are ready to vote on the motion Mr. Char offered. If you want to discuss this more, you'll vote no. If you want to stop and go ahead and vote on Mr. Char's motion, you'll vote yes.
What is her? Let her state her motion again.
Well, Wendell, at this point, all we're doing is voting on the call for the question. If you want further discussion, you'll vote no. If you're okay with her motion, which is to change the word entity to name.
And take conspicuously out.
All right, let's vote on the call.
Bloom,
Yes.
Alexander,
Yeah.
Franks,
Yes.
McMullen, Grease,
Oh,
Hills,
No.
Dechara,
Yes.
Collins.
all right, the vote on the call for the question passes. We're now ready to vote on Mr. Chara's motion, which was seconded by Ms. Franks, which basically, as a quick recap, takes the word conspicuously out in the second line, and then down under number one, it will read, the firm name must be the most prominent name featured within the advertising. That's the motion. We're ready to vote. Let's vote.
That includes her .com. Can't be larger than the other, right?
Well, that's open to interpretation at this point.
Pardon?
That's open to interpretation in my mind because name might be different than a website name.
Well, that's what one. Oh, she agreed to in her motion that the .com wouldn't be any larger either. Right? Let's step up.
You called it a website name, so I mean it's a name. DanetDechara.com is a name.
You could make me feel better if you had something in parentheses after name that said, including website.
Including website names.
Or something along those lines.
I'm okay with that. Do you want to make a friendly amendment, Marcia?
Who was it that said wasn't a name?
Yeah. It's your motion, Janet.
I would go. I would make a friendly amendment.
friendly amended me.
It may have been Shakespeare.
All right, so I think Commissioners, the motion on the floor now, following the word name, has a set of parentheses or brackets that says including website domains or addresses, or is that what you're thinking?
Yep. Website addresses.
What's that?
I think it's website addresses.
Is a domain name an address?
There's a domain name.
Let's just make sure that we're specific on exactly what you're putting in parentheses.
All right, for those of you who couldn't quite hear Ms. Marriage, she said she, as an attorney representing this commission, would like for us to be specific about what's going in the parentheses.
Website address. Domain name?
Pay for when you renew them, they call them domains.
I'm
This
open.
is your problem.
Put a website name on there. Does that mean Twitter handle too? Hashtag, you start-
Including social media names.
That's where the word entity came from when we discussed this a long time ago.
Including social media names.
That's where the word entity came from when we first proposed this.
Okay.
I have a suggestion.
Ms. Baird?
When we're ready for suggestions, I'm not sure if we need to go ahead and vote on what Ms. Achara is saying since we already called for the question, but what if you use the word item? Instead of saying name, what if you used item or word? Just to alleviate what
I think
have-
item's too broad.
Item could include picture and word could include for sale.
Yeah.
And I think you ought to be able to put a big old picture on there and put for sale.
Okay, never
If
mind.
you want to. I don't know. I mean,
I
I'm
was
not
just trying to-
criticizing you. It's just, it's not a
I
perfect
understand. I
answer.
was just trying to think of
know.
something to alleviate all the parentheses. But
Marcia, it's your amendment. What you want in there?
Oh, Lord.
Oh, okay.
Marcia,
Yeah.
so you've got the floor. We're trying to determine what you want in those parentheses. And whatever you say, we're going with it. And just for consideration purposes, we had a suggestion, maybe the word name should be the word item, so that the firm name must be the most prominent item featured with advertising. At least one commissioner thinks that's too broad, but I haven't heard from anybody else that might want to speak to that. Second commissioner thinks that's too broad. Okay. Maybe there don't need to be parentheses at all. If the word is name,
Well, you're the one that's muddying the
I'm just asking questions.
I'm really for no parentheses. Really. Leave it as it was amended.
What'd she say?
I'm sorry. Would you say that again, please?
I say leave out the parentheses and leave it as it was amended.
Let's vote. We've had a call for the question, and the chair was kind of derelict in his duties on that. But, of course, I defer to Mr. Alexander whenever possible. Ms. Smith, let's call a roll.
Bloom,
Yes.
Alexander,
Yeah.
Franks,
Yes.
McMullen,
That's
Grease,
Yes.
Hills,
Yes.
Tachara,
Yes.
Collins.
All right, let's just take a look at these comments. We need to give a response to each of these comments. What does prominent mean? Does the commissioner want to offer a response to that?
Somebody offered a response to look it up in Webster.
Did we take
response-
prominent out?
I think the response is that yes, it does relate to size and the position, and that the licensee's picture is not an issue due to the amendment.
That's the motion. Who seconded that motion? Commissioner Collins seconded that motion. Discussion. Let's vote. Those in favor of the motion are going to vote yes. Those opposed will vote no. Ms. Smith?
Bloom,
Yes.
Alexander,
Yep.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
All right, Mr. Farah has a comment. Mr. McMullen, your motion may be almost identical. I don't know. What do you think?
Same response, but no reference to picture.
All right, that's a motion by Commissioner McMullen that the commission's response be the same as to Ms. Moss, with the exception of the word picture is not included in your motion. Seconded properly by Commissioner Collins. Discussion. Let's vote. Ms. Smith?
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease, Hills,
Yes.
DeChara,
Yes.
Collins.
All right, Mr. Cantrell has a comment. Any commissioner like to respond to his comment?
The company name can use multiple font sizes as long as that's the largest name on the sign.
Thank you. That appears to be a motion from Mr. McMullen.
Second.
Second by Commissioner Chara. We'll take a vote unless there's discussion on Mr. McMullen's motion. Ms. Smith?
Bloom,
Yes.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins absent.
All right, that motion passes on a 7-0 vote. I'm
Mr.
simply,
Chairman, I'm sorry. I'm at my appointment. I'll get back with you after lunch.
all right, Mr. Alexander and Ms. Franks,
Yes.
what's your schedule like? I know you guys have put in a lot more time already than you planned. The chair's in the mood to continue on if it'll help you, but if you'd like to take a break and can participate this afternoon, I'm okay with that as well.
You're going to continue on. I'm right here.
I can continue on.
Would you prefer to continue on or take a half an hour or 45-minute break and come back?
Oh, I'm all right now. That's it.
I'm fine to go on now too.
Okay. I'll
Commissioners,
get back with you after when I get through.
okay.
All right.
Thank you, Gary. Sitting commissioners, objection to continuing on?
We still got a ways to
I understand. All right, let's take a 5-minute break. And those of you in the audience, this is an unusual event for us to work through lunch, but that's what we're going to do at this point. 5-minute break. Get back in session. Direct commissioners to the bottom of page 11 of 23. The proposed change says the firm's telephone number shall be featured in greater size or prominence than the telephone number of any individual licensee or group of licensees. And we received 4 comments on that proposed rule. And I'll open the floor, commissioners, if you wanted to start talking about this, or we could take a motion and then speak about it at that point.
Is it enough that we just make the firm name be the most prominent? Does telephone number have to be too? I mean, if the firm name is on there prominently, then if they've got a complaint, they know who to file the complaint against.
Can I give you an example of that?
Sure.
An agent called me that was quite angry about this on Christmas Eve of last year and spent 2 hours screaming at me because he said he's paid tons of money to have his phone number. He don't care if we even let him put his name on the sign or not. but he wants his phone number larger. And I said, well, how much larger are you talking? And he said to me, well, go out there and look at that sign at such and so. I said, well, what's the size difference? He said, the company phone number is 2 inches tall. My phone number is 17 inches tall. So you really had to look. When I went and looked at the sign, you really had to look to even find the company. So that's the kind of problem we're dealing with. I don't think it has to be in greater size, but I think it does need to be the same size as the agent's number.
That same size or larger.
Yeah, I mean, I don't think it has to be greater, but I do think, just like the company name, it needs to be same size or larger.
I sense there are two people that agree on something. Why don't you make a motion? Let's see if we get a second and have it on the floor.
Okay, the firm's telephone number shall be the same size or larger than the telephone number of any individual licensee or group of licensees.
Second.
Motion by Commissioner Chara. Is there a second to that? Seconded by Commissioner Hills. Now that motion is on the floor for discussion. Is there discussion?
And I think that would address Commissioner Bloom's concern with signage expense, and I just think it's more reasonable.
Okay, other comments? Let's vote on the motion. Well, we've got it in front of us. Who's calling the roll? Ms. Maxwell.
Yes, I'm back. Bloom. Oh, it's gone. Alexander.
Yes.
Franks.
Yes.
McMullen.
Yeah.
Grease.
Yes.
Hills.
Yes.
DeChara. Yes. Collins.
Yes.
Okay, so that motion passes. We need to address these comments. Hopefully, briefly. Mr. Black has a comment. Yes, sir.
Answer each one. Can we not answer them as a group unless we frequently disagree with it, or does it matter that we disagree with it?
Well, like the difference between this first comment and the second is kind of huge. So I don't know if we can put them all in the same box in this case.
I see.
But I asked counsel the same question. It may, for the record, would prefer to have an individual vote for each comment, just to show that we gave consideration. Okay.
But we've given it consideration by reading it the last month.
I understand. This is well, it's just the way it is.
Consideration on the record.
Consideration on the record. Thank you, Ms. Baird.
To Mr. Black's comment, I understand that this is costly. One of the reasons we're having to address this problem is because people are not following the rules as they are currently stated, so we're having to define them better. And this is one of the places that was really loophole that they were not using the company phone number as listed with the commission.
And actually, if you look under the advertising in 1260-2-.12 for C1, it already says his name and firm telephone number. So maybe people are not in compliance with that, and that's where the problem lies.
The Commission's response to Mr. Black's comment is, we understand his concern, but in the interest of protecting the public, we think this is the right way to go.
That's good.
That's a motion by Ms. Frank, seconded by Mr. Collins. Is there discussion on that?
I did not respect that.
Or were you just coughing? Or?
I'll second it.
Oh, I'm sorry. Second by Commissioner Chara. My effort to get this motion on the floor and voted on, I misunderstood a cough. All right. Ms. Franks.
Yes?
You ready to vote?
What?
Are you
Yes.
Any other discussion?
I mean, I just think this probably goes beyond what's necessary to protect the public, and I'm concerned about the cost. Those are my comments.
Not the form of a substitute motion, just a comment on the motion.
I comment.
I got it. Okay, well, you've got the motion on the floor, made by Commissioner Frank, seconded by Commissioner Chara. Let's vote. Ms. Maxwell.
Alexander?
Yep.
Franks?
Yes.
McMullen?
No.
Grease? Hills?
Yes.
Datara?
Yes.
Collins?
Yes.
All right, that motion passes 6-1. Ms. Moss asked the question, must a firm's telephone number be on a sold sign? Currently, a licensee's name and phone number attached on a rider below the sign. So I assume she's talking about an additional rider that would go on the sign, and if it just says sold, is that?
It's the same sign. If it's a rider on the sign, it's the same package, same sign.
And
Unless
you know, I
it's
think
something-
this would solve a lot of people's problems. Instead of buying new signs, they could buy riders with the phone numbers on it and put on the sign. So I think a rider is fine.
So is it the commission's response that a sign including riders is one sign?
Yes.
So that's Ms. Hill's motion in response to Ms. Moss's comment. Is there a second to Ms. Hill's motion?
Second.
Seconded by Commissioner Chara. Now, is there discussion on the motion? Ms. Maxwell.
Yes.
Let's vote.
Alexander?
Yeah.
Franks?
Yes.
McMullen?
No.
Grease?
Yes.
Hills?
Yes.
Datara?
Yes.
Collins?
That motion passes on a 6-1 vote.
On the second part of Ms. Moss's comment down there, can a firm have more than one phone number on file with Trek? I think we have to let Ms. Maxwell answer that. I think they can only have one phone number. Is that correct, Ms. Maxwell, as far as they can have a fax number and a phone number? Is that right?
Some firms have an 800 number as well. They have an 800 number and then a area code number, and we allow them to have both of those numbers.
So that answers the second part of her question there.
And so they can have either number in their advertising.
They can have either number on the sign.
That is correct.
Okay.
Do we assume that either number rings to the same place? Is that, just out of curiosity, we do think.
That's the representation
Okay,
that we get.
Just want to make sure. All right, Mr. Scholler, what is greater size and prominence? I think the motion that we recently passed addresses the greater
We
size
agree
issue.
and amended it.
We agree. So Ms. Hills makes a motion in response to Mr. Scholler's comment that we agree with his comments and have amended the proposed rule to reflect his concerns. Is there a second to Ms. Hill's motion?
Second.
Second by Ms. Franks. Is there discussion on the motion? All right, hearing none, let's vote. Ms. Maxwell.
Alexander?
Yep.
Franks?
Yes.
McMullen?
Yes.
Grease?
Yes.
Hills?
Yes.
Datara?
Yes.
Collins?
Yes.
Thank you. Now, Mr. Farah has a comment that asks that the commission give agents a grace period to budget for new advertisements.
My position on that is that if we pass all these today and send them up to the Attorney General, they have got plenty of time from now until the time the rule takes effect, because even after it's signed, it's 90 days after that, right, Finley?
I think maybe more importantly, I don't know that we have the latitude to give them a grace period. You speak.
I mean, they.
I don't think you can do that
Speak in
without
the microphone.
changing the entire rule, which is not what we're doing here.
We can't tell the Secretary of State's office that we want this rule to take effect January
Right.
1st, 2016.
Correct.
We don't have that latitude.
Correct.
All right, thank you. So would someone like to phrase a motion to reflect that?
our response to Mr. Farrer would be that we don't have the latitude to extend a grace period, and that we have addressed the prominence question by changing the rule.
Is there a second to Ms. Bechara's
Second.
motion? Second by Ms. Hills. Is there discussion on that motion? All right, let's vote. Ms. Maxwell.
Alexander,
Yes.
Franks,
Yes.
McMullen,
No.
Grease, Hills,
Yes.
DeChara,
Yes.
Collins.
That motion passes 6-1. Comment number 12 is related to a proposed section in the rule that says any advertisement which refers to an individual licensee must list that individual licensee's name as licensed with the commission, and the individual licensee will not be any larger than the smallest font of the firm name. Comments from commissioners? How about a motion from commissioners?
I know that we've had some comments, and I understand where they're coming from, where it may be cry-like ink, and then the ink is really small, as to how they have to address that. And it was suggested that maybe we could change that to it. The licensee's names cannot be any larger than the most dominant font in the firm's name. So that if they had like a big first letter and then the majority of their name, say, is 3 inches tall, then that's what the company's name could be. And then if ink was only a 1 inch, that would not play into it, that the 3 inches of the most dominant.
Mr. McMullen?
I think you've already amended this to say that the firm name has to be the most prominent name, so I think it's redundant to have this in there, and I think you could just leave it out. Go with what you already got, because it says, we've already talked about something that says it's got to be the most prominent name.
And it could be the DBA name also.
That's your motion. I'll second it.
Well, the other part of the rule, it has to do with you got to have the name that's licensed with the commission for the individual. Do y'all want to keep that too? I mean, do y'all want to keep that, or?
Yeah.
So you could amend it. I'll move to amend C to delete everything or change the comma after the word commission to a period and delete everything after that.
Okay.
A motion by Commissioner McMullen is offered, seconded by Commissioner Hills, that basically cuts this proposed rule in half. This, just a question or discussion topic for commission. So this would also affect signs. Is that correct?
Yes.
So this is a sea change when it comes to signs. It's a big deal.
Well, I think if we don't do something, we're not solving the problem that we have right now, where companies are using a great big first letter and then the rest of their name is small. So then the agent thinks their name can be as big as that big letter in the company name.
So we're going to refer them back to a rule we've already passed that says their name can't be any more prominent than the company name.
That don't mean necessarily
Prominence out.
Take them off now.
Yep,
Size or larger. Because the prominent.
Still says it has to be the most prominent name.
On the bottom of page 11.
and we did take prominence out.
Are you referring to what's on the bottom of page 11 on number 2? It looks like you changed that one to say the firm's telephone number shall be the same size or larger than the telephone number of any individual licensee or group licensees.
Yeah, but in B1, we said the firm name must be the most prominent name in the advertising.
What page is that on?
Top of 11.
Up of the 11. That prominent.
Okay, so Wendell and Marcia,
What do you say, Commissioner?
I'm just saying that Austin is making the point that we already have addressed the relationship between the firm name and the company name.
We did that back a few minutes ago.
And you're making the same point at this time.
That we said that nobody's affiliated anything to be any larger than the principal.
But, okay,
What you're referring to, Austin?
That the firm name has to be the most prominent name.
True.
And this is just duplicative of that, I think, where it says that the individual name can't be larger than the firm name.
That's true.
I don't see why we need to have this rule in there. It's duplicative of the one we've already done.
We took care of that a few minutes ago.
well, but what we've got here is that it can't be any larger than the smallest font of the firm's name.
Well, I don't know about that.
And that's why I made the comment that larger than the most dominant font in the firm's name. But Austin's, just like my company, is Exit. Exit's really big, but my actual company name is Exit Select Realty, and it's 2 inches tall because it has to fit between the housetops. So is my company name Exit, or is it Exit Select Realty that's between the housetops?
Seems duplicative, and I think it's just adding more regulation and more burden on the individuals than and I don't see that there's a corresponding benefit to the public that's very significant. So that's my view.
Okay, so the motion in front of Commission right now, found at the bottom of page 12, letter C, strikes everything from the word commission with the belief that we've already addressed the issue on that second part. Any further discussion on that?
I don't see why we ought to be arguing over it, where you've already specified it be any larger than the broker's name. I think it's irrelevant, and I think that the Exit being smaller or the other name part of your company has what would bother me if you made it larger.
Speaking for the motion, as I understand what
That's
you're saying.
right. I'm for the motion.
Okay. Other comments before we vote?
Will you repeat the motion, please?
We will. 1 second. Commissioner Collins has a comment or question.
There's one other item that we're overlooking is logos like KW. That's huge, and then the company name. Are we talking about the person's name can be as big as KW or just the name?
That's kind of where I was going.
I knew
Grover.
you were. You were talking about Exit and KW and a lot of the other franchise logos. Now, is that included? Where are we on this?
I'll just try to address it.
On Remax, a big balloon.
In a previous rule that we passed earlier today, we said the firm name must be the most prominent entity.
Okay. What's the firm name?
It's not
KW?
It's not KW. It's what's registered. Unless it's how it's registered with the Real Estate Commission. It's not. That's a logo.
That's
okay.
Firm name is Keller Williams, and that's where can't be any larger than the Keller Williams name.
We defined firm name.
That's right.
As the entire name or the DBA name.
Right. So I think we're all saying the same thing, just looking at it from different perspectives. But I think the motion, from my personal perspective, is a good catch, and I'm ready to support it.
Call for the question.
All right, Mr. Alexander is called for the question.
Marcia wants it repeated.
Okay, we're going to repeat the motion at this point, Mr. McMullen.
Section C, change the comma after the word commission to a period and delete everything after the period.
Okay.
That's the motion. Any questions, Marcia? Are everybody ready to vote?
No, I got it.
Okay, let's
Thank
vote.
you.
Let's vote, Ms. Maxwell.
Alexander.
Yes.
Franks.
Yes.
McMullen.
Yes.
Grease. Hills. DeChara.
Yes.
Collins.
Yes.
That motion passes 7-0. All right, we've got to talk. Let's just speak to these comments for a second. Mr. Black had a comment. It appears Commission has reviewed that comment and tried to mitigate his concern.
Reviewed and amended it.
All right, Ms. Hills makes a motion that in response to his comment, Commission states that we've reviewed his comment, taken it into consideration, and folded his thoughts into the change we made. Something like that.
That sounds good to me.
Mr. Alexander seconds that motion. Are you ready to vote?
Yes.
Yes.
Without objection, let's vote on that motion, Ms. Maxwell.
Alexander.
Yes.
Franks. McMullen.
Yes.
Grease.
Yes.
Hills.
Yes.
DeChara.
Yes.
Collins.
All right, Ms. Moss has a comment. Again, on my quick review, it looks like we've taken her comment into consideration and modified our rule. Is that how?
I moved. Yes.
Ms. Hill sees it the same way, and so she makes a motion to that effect. Is there a second?
Second.
Second by Ms. Franks. Is there discussion on the motion? All right, let's vote, Ms. Maxwell.
Alexander.
Yes.
Franks.
Yes.
McMullen. Grease.
Yes.
Hills.
Yes.
DeChara.
Yes.
Collins.
Motion passes unanimously. Now at the bottom of page 13 of 23, you'll see some other
We
proposals.
got to address Mr. Farah.
Oh, I'm sorry.
We agree and amended.
Ms. Hill says we've taken his comments into
Second.
consideration and incorporated those comments into our revised rule. Seconded by Commissioner DeChara. Is there discussion on the motion? Let's vote. Those in favor of the motion, Ms. Maxwell will vote aye. Those against will vote no. Would you call the roll, please?
Oh, sure. I thought you were just going to have a joint effort there. Alexander.
Yes.
Franks.
Yes.
McMullen. Grease.
Yes.
Hills.
Yes.
DeChara.
Yes.
Collins.
All right, sections D, E, F, and F1 and F2 are changes that Russ Farah wanted to comment on. You can see his comments on page 14 under number 25, comment number 25. And his comments basically say an individual office should have its firm name included in its entirety. However, on a website that features multiple offices, it should be okay just to put the company name without identifying each individual company within that franchise. That's my take on what he said.
Well, and I agree with that. I mean, but also this is Tennessee law, and it's just like my corporate website is out of Canada, so we really don't have any jurisdiction over where franchise websites are other than the ones that are in the state of Tennessee. But I don't think we ever intended it to be a franchise website. I think it's always been the intention that we were talking about individual websites or companies, not the whole franchise.
Well, for instance, if RE/MAX has a big Tennessee website and every RE/MAX franchise in Tennessee has their listings aggregated, thank you, not aggravated, aggregated on that site, should each listing on that RE/MAX website have the individual company's name next to each listing?
Well, I think your IDX feed dictates that.
maybe I'm misreading Mr. Farris' comment or request here, but
I think he's saying on that big Remax website for the state, it says Remax and it don't have Remax Realty Source, Remax Cornerstone, Remax, and every company within the state of Tennessee listed there. I think it's his point, right?
all right, so I take it that you'd like to respond to his comment first and move that we agree with his comment.
Yeah, I totally agree that this only is required of individuals and company websites, not franchise websites.
Ms. Hills, you also agree with that?
I do.
Okay,
Second.
so the motion is made by Mr. Chara, seconded by Ms. Hills, that we've reacted to Mr. Farris' comment by incorporating his comments into the proposed rule. Now, we haven't done that yet, so you want to see where you want to put it before you vote on that or not?
Our
Is there anything to do?
response.
So let me ask you a question.
Okay.
Make sure I understand what y'all are talking about. No licensee shall advertise false, misleading, or deceptive. False, misleading, or deceptive includes advertising that includes only the franchise name without including the firm name. So it's false, misleading, and deceptive to run if there's a TV commercial that's run that just has a Remax balloon floating around up there and doesn't list all these firms.
That's a perfect catch.
I don't think we ought to prohibit that. That doesn't make sense to me.
Well, the intent, I think Mr. Farris' intent, I think the motion, the second, make a motion the second, meant in the event that the advertising is on a franchise website, you don't have to put each individual company name. Every other time you do, which is your point, I think.
So Super Bowl ad for a company, Remax, Coldwell Banker, whoever, on TV will just be that.
But I don't consider that false, misleading, or deceptive.
I
No,
don't
that's what
either.
we're saying. We're agreeing that
Yeah.
that's not.
What are we trying to catch?
We're agreeing to Mr. Farr's suggestion, aren't we?
Yes, we're agreeing with what he's saying.
Okay.
What we're saying that is on my website, my personal website, I have to have Exit Select Realty
Right.
because that's my personal website. I have to identify the company and firm that I work for. And I think everybody's in agreement with that. But like my franchise website, which is Exit Realty, we can't control somebody in Canada and make them put every office in Tennessee listed there. And
Paint the
every,
true picture.
yeah, put everything on their page. So, that's where.
So everyone's in agreement with that, right?
We are. We just need to know how to adjust number 2 to incorporate that thought. So to Austin's point, if you refer back to letter F, it's false, misleading, or deceptive advertising if you don't have the full franchise name in the advertisement, with the exception of the franchisor's website. I mean, I think that's what we're trying to say.
Let me address a couple of things. Point 1 about any advertising that refers to an individual licensee utilizing a nickname. I think we already covered that on the previous page when we said any advertising which refers to an individual licensee must list that individual licensee's name as licensed with the commission. Right?
That's right.
So 1 seems duplicative. So then number 2, I think we could rephrase that maybe. I think we should definitely keep that first sentence under F where it says no licensee shall advertise in a false, misleading, or deceptive manner, period. we should definitely keep that. What if we deleted the rest where it says false, misleading, or deceptive includes? You deleted number 1 and then kept a sentence that just says any, something to the effect of any licensee that advertises using a franchise name must also include the firm name.
I like that.
I do too.
So if you went that way, then F would just say 2 sentences. First sentence, no licensee shall advertise in a false, misleading, or deceptive manner. 2, any licensee that advertises using a franchise name must include the firm name.
That's good.
But there's still, Russ's exception to that is unless it's a franchisor's website.
Well, but this is
But he's not a
addressing
licensee.
the
Not the
individual
licensee.
licensee.
That's not a licensee advertising.
Oh, the licensee separates it.
Got it. All right, that motion is in front of us. Seconded by Commissioner Collins. Thanks for that. Thanks for that work,
Right.
Ms. McMullen.
So then, number 1, Austin, would you rephrase that? Or it's not going to be number 1. It's just going to be a follow-up on.
It'll just be F will just have 2 sentences. First sentence, no licensee shall advertise in a false, misleading, or deceptive manner. 2, or not 2, second sentence. Any licensee that advertises using a franchise name must include the firm name.
Second.
All right, you're too late.
Okay.
But we'll let you vote first if you'd like.
Yeah, that's okay.
All right, is there discussion on the motion? Ms. Maxwell, would you call the roll? Start with Commissioner Alexander, please.
Sure. Alexander,
Aye.
Franks,
Yes.
Grease,
Bruce?
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins, McMullen.
For the audiences, in case you didn't know, that we have we're all licensees with one exception up here, and that exception happens to be Commissioner McMullen over here, who's an attorney and a darn good one from our perspective. We're thrilled to have him on the bench with us.
He tries to keep us straight. Notice I said tries.
All right, so Russ Farrer's comment. I think a motion would be accepted that we've reviewed his comment, agreed with his point, and incorporated it into the revised.
So
rule.
moved.
Motion by Commissioner Chara, second by Commissioner Hills. Discussion on that motion? All right, let's vote. Ms. Maxwell?
Yes. Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
The motion passes unanimously. Now, on the middle of page 14, a proposed rule change is in red. There are comments from Steve Black, Bradley Scott Troxler, J. Russell Farah, and Philip Cantrell. All right, this could generate some discussion. Does any commissioner wish to start this off? Does any commissioner like to make a motion? Any commissioner like to make a motion? Let's get something going here. Chair will take the latitude of just speaking on one issue just to see if other people agree or disagree. The proposed rule identifies several words or phrases that this commission has said should not be included in advertising. I've looked at this and I've talked to people, and I agree with those words with one exception. And I'm willing, as a chair, or as a vote on this, to pull the word group out of that.
I agree.
However, the rest of those, to me, definitely have connotations of entities that the public might see as a separate real estate firm. So my concession or discussion as we bring this on the table is to take the word group out of it, but the rest remains as it's written. I'm not making that motion, but those are my thoughts.
I'll make that motion, Mr. Chair.
I have a motion by Commissioner Char that this rule be revised to withdraw the word group, remove the word group from the language of the proposed rule. It's seconded by Commissioner Collins, third by Ms. Hills. Is there discussion on the motion? Are you ready to vote? It seems to me you are. Ms. Maxwell?
Yes. Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease, Hills,
Yes.
DeChara,
Yes.
Collins.
All right, that motion passes unanimously. Now we have to address the comments. Mr. Black? Anyone want to make a motion? We've already taken actions. We've in part responded to his comments positively.
I would say we took his comments into consideration and amended the motion to the part that we agreed to.
That's a motion by Commissioner DeChara, second by Commissioner Hills. Discussion on that motion. Let's vote. Ms. Maxwell?
Yes. Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
Thank you, Mr. Troxler.
John, you're cutting out. I don't know what you're doing to your mic.
It could be my voice, not my mic, Wendell.
Oh, you know what to cure it, won't you?
Yeah, I do. But it's too early. And we're in a government building. Would a commissioner like to comment on Mr. Troxler's comment?
We've considered it.
Made what changes we thought were appropriate.
And that's all. I'm not interested in trans.
Okay, so the motion by Ms. Hills basically says we've considered the comment. Our decisions are based not on national trends, but what we think are relevant to the public in the state of Tennessee. That's my guess.
Thank you. Yes.
And it was seconded by
Me.
Mr. Chara. Discussion. Let's vote. Ms. Maxwell?
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
All right, Mr. Fair on page 15 has some comments.
Those comments have been addressed, have been read, understood, and we have amended the motion to reflect.
Of course, those comments, not all of them.
I think we've taken all of them into consideration.
Well, we have, and that's my point. For instance, he suggested that the words real estate, realty, and group be deleted from the proposed rule, and we have deleted group from the proposed rule, not those others. So
we didn't agree with all of them. We just took them into consideration.
Right.
Second.
That was a motion made by Commissioner DeChara, seconded by Commissioner Hills. Is there discussion on the motion? All right, let's vote on it, Ms. Maxwell.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
All right, Mr. Cantrell also had a comment on that.
Same thing. We've addressed it, made our amended motion, and moving on.
I think this motion Mr. Chart made stated that we've reviewed his comments, but we put the welfare of the public a little bit ahead of the new hardships that licensees might have.
Well, they should have been
Who seconded that? Did you?
I did.
Thank you. Discussion. Let's vote, Ms. Maxwell.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
Okay. Number 4 at the bottom of page 15 reads, any advertisement that utilizes pictures including both licensed and unlicensed members of a team, group, or similar entity within the firm, but which does not clearly identify the licensed individuals by name. Mr. Farah had a comment to that. It's so short, I'll read it. TAR opposes this rule as it is believed to be extreme and does not accomplish anything in protecting the public. It only places a burden on teams, groups, or similar entities.
So,
So do we need to take group out here?
Yeah, because we added group. Make group okay.
Group is okay. The point is,
Okay.
here's the point. So there's a picture of a team or a group, and it has 5 people in it. Should the licensees in that group be identified?
I don't think they would need to be identified. However, I think unlicensed people should not be in that group. I think that's where the difference is.
Charlie's Angels on your ad. That wouldn't be anything illegal, would it?
Well, it would appear that they're licensed to do business in real estate.
Well, well, what if they're not licensed?
That's my point. So
How am I going to know that?
I know. I don't see that the people in the pictures maybe need to be identified by every name, maybe, as long as they're licensed. That, to me, that's one of the big things. The unlicensed person being on the real estate, it makes them appear that they are licensed to help you with your real estate.
There's a lot of print out there that shows all these smiling faces and every form of advertising in the world that they don't identify the people.
Well,
they may be professional actresses or actors.
Mm-hmm. I think it's more important to not. I agree to identify them, but I don't. But even if you identify them, I still don't think you should have an unlicensed person's picture there.
I just don't see how it really benefits the public that much to regulate the pictures. If Grover's got a picture of him with the Charlie's Angels and he wants to put it on his website, more power to him.
Need help.
Right, commissioners, this is kind of a black or white issue. Either you think that people in a photo ought to be identified, or you don't think it's important. So, if I'll take a motion on either side, just so we can get a deal on that.
I make a motion that we delete paragraph 4.
Second.
I have a motion made by Commissioner McMullen, seconded by Commissioner Collins, just barely, that this be deleted, Section 4 be deleted from our proposed rules. Now, discussion on the motion.
Talked about it. Let's vote.
There's a call for the question. There's an objection to the call. I hear none. Let's call the roll, Ms. Maxwell.
Alexander?
Aye.
Franks?
Yes.
McMullen?
Yes.
Grease?
Yes.
Hills? DeChara?
Yes.
Collins?
Yes.
And that motion passes unanimously 7-0. Now we're going to page 16. Oh, do we have to address? We have to address the comment. Okay, Mr. McMullen.
Motion to address it by telling him that we got rid of it.
Thank you.
Agreed, delete.
The motion is we reviewed his comment, agreed, and took action. Positive action. Seconded by Commissioner Hills, made by Commissioner McMullen. Discussion on the motion. Ms. Maxwell.
Alexander?
Aye.
Franks?
Aye.
McMullen? Yes. Grease?
Yes.
Hills?
Yes.
DeChara?
Yes.
Collins?
All right, that passes unanimously 7-0. Number 5 in the middle of page 16 reads, any website that contains a link to an unlicensed entity's website where said entity is engaged or appears to be engaged in activity which requires licensure by the commission. And remember, this comes under the heading of false or misleading advertising, basically. We have one comment to that. It was from Russ Farrer, who wanted us to provide a firm definition of what is being prohibited and or examples of cases which would be considered a violation. It's nice of him to request, but my sense
we
is
do that.
we'll know it when we see it. It's not that hard.
He's a lawyer. He knows what right, wrong.
So is there a motion either regarding his comments or the proposed rule change?
I think the rules in place to benefit the public, and we've examined all other ideas and are sticking with what we got.
All right, so Mr. Collins sees no need for change, and therefore moves that this stay as the described, presented, written. Yes, sir. Thank you, Mr. McMullen. Seconded by Commissioner McMullen. Discussion on the motion. If passed, this will remain unchanged. Let's vote, Mr. Maxwell.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
Okay, that passes unanimously 7-0. We have to address Mr. Farrer's comment.
Is there a definition for firm already in the law?
What,
I think-
Marcia?
I think firm
If-
means definite. I think he wants us to tell what that means.
Okay, got it.
I'm not speaking on behalf of any commissioner, but I'm not sure that's our responsibility. We're supposed to be able to identify it when we see it.
Okay.
Talking about in comment Roman numeral 31,
Yes.
his use of the word firm.
Yeah.
I don't think he's talking about like real estate
No.
firm.
Right, not a firm company.
That's what he means.
Okay, does anybody want to make a motion that we can pass on in response to his comment?
Considered it and not going to give examples. No action.
I think the problem with giving examples, as soon as you give examples, anything that's not included might be deemed to be acceptable. We're not in that position. So that was your motion in so many words. It was seconded by Commissioner Collins. Is there discussion on the motion? Let's vote. Ms. Maxwell.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
Motion passes unanimously. We're on now to advertising for franchise or cooperative advertising groups. Mr. Farah has 2 comments on that.
Or he says,
And Philip Cantrell has a comment.
I don't.
Oh, I'm sorry. I'm going to the wrong page.
Yeah.
Excuse me. I'm going backwards instead of forward.
We're on the bottom of 16.
I got it. Sorry, my fault. Is there a motion?
Where did we pick up that from anyway? Advertising for franchise or cooperative advertising group? What was
That language has been in the rules, at least it was in all of them. It's been in the manuals for probably 15 or 20 years. I don't know where it came from whence it came, but it has been included in there. So that's why it's just sort of continued on.
I move that we respond to the comment by stating that the term cooperative advertising group is not being added to the rule, but is an existing and long time used term from the existing rules.
Mr. McMullen, do you want to go ahead and include that we accept that? Or we're going to do that all at one time?
Right, you can also include that
Okay.
you're not requesting any changes to this particular, along with what you just stated, if you want to.
Sure. I'd said that too.
Okay. Any discussion? No discussion, Ms. Maxwell? All in favor?
Alexander,
Yes.
Franks,
Yes.
McMullen, Hills,
Yes.
DeChara,
Yes.
Collins. Grease has left the room briefly.
Okay, we're at the bottom of page 17, where Julie Moss has a comment. Comment on that? We kind of already addressed that earlier to some degree.
I move that we pass this as written.
Thank you, Marcia. Adopted as written. Do I have a second?
Second.
Second by Mr. Alexander. Discussion on the motion. Have a call for the question, Ms. Maxwell?
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease, left the room. Diane,
Yes.
Janet,
Yes.
DeChara, Collins. Sorry.
We know our first and last name. We're good. Okay, who wants to address Ms. Moss's comment?
Action did we address this all the
I
same
think we
already?
just voted to accept the rule as is, but we haven't addressed Ms. Moss's comment yet.
That's what we're talking about.
Are you looking for a page number? We're on page 17 on.
No, I'm
Oh.
just looking to see
Okay.
some past.
We talked about the websites earlier and addressed that. She's looking for where we addressed it earlier.
Talking about where we talked about the advertising by licensees who are part of a franchise. Yeah, that was where we said any and something to the effect of any licensee who advertises using a franchise name must include the firm name. Is that what you're thinking of? Is it the same concern here with this internet advertising rule that some national website of the of the head of the franchise is somehow going to get in trouble here because it's not going to list every franchise in Tennessee? So I think on this one you could maybe, where it says internet advertising, in addition to all other advertising guidelines within this rule, the following requirements shall also apply with respect to internet advertising by licensees.
Oh, that's right. That's we'll separate it. You're right.
Is that the
Yes.
concepts you want added in there? So therefore it wouldn't catch some national website.
Correct. And leave it separated.
Yeah,
Is that your motion, Ms. Hills?
Yes.
I'll second that.
Okay, seconded by Mr. McMullen.
Are you trying to make a motion to change the language in 5A now? Because we already voted.
Yes, we voted it as it was, so we're going to have to amend.
Internet advertising, that's what we're
Okay.
In order to address Ms. Moss's concern there. Come into your microphone.
I think that also addresses his concern about large franchises.
Ms. Franks,
Yes.
are you opposed to that change?
No, I'm not.
Okay, do we have,
We have to take another vote to retract the last vote.
All right,
yeah, I think we do.
let's have, is there a motion for reconsideration?
Right. We need to start over.
Who,
Yes,
did you vote in the affirmative? on
Yes,
that
we
passage?
all did.
Yeah, we all did.
Okay, so that,
We've got to reconsider.
interrupt you just for a second. Let's just we're gonna have a vote to reconsider the previous item. And if you're in favor of that, you'll vote yes, and if you're not, you'll vote no. Ms. Maxwell, this is a motion to reconsider the previous item.
Alexander,
No.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
Yes.
All right, the previous item is now on the table, and Mr. McMullen has offered a motion.
Ms. Hills.
I'm sorry that Mr. McMullen seconded.
Yes, Ms. Hill's motion.
It's Ms. Hill's motion. The motion, Mr. McMullen, would you?
And she was going to add the words by licensees after shall also apply with respect to internet advertising.
Discussion on the motion. Let's vote. Those in favor will say aye when Ms. Maxwell calls their individual name.
Alexander,
Yes.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
All right, that motion passes 7-0. You want it back? I just, okay. So have you, sorry, I stepped out for a minute. Have you addressed Ms. Moss's comments? Or we need to do
That was what we just were doing.
They
That
agreed
was
and
the change.
addressed.
Okay, great
Yeah.
address. Perfectly. So that takes us over to the bottom
Mr.
of page
Ferris.
18.
No, we gotta get Mr. Ferris' comment.
I think that Mr. McMullen, did you include the response to Mr. Fair's comment in that last?
Yeah, I thought we had both in the same motion.
Okay.
So let's go to the bottom of page 18. Again, Ms. Moss has a comment about sections B and C. Really, I think it's more of an editorial comment than a suggestion.
Probably all agree with what she's saying, but there's really nothing we can do about that.
Chair will entertain a motion to accept and acknowledge your comments and stop right there.
So moved.
Motion by Commissioner Chara, second by Commissioner Hills. Discussion. Let's vote. Those in favor of the motion will vote aye, right, Ms. Maxwell?
Yes, this was a motion to, just to say that you agree with Ms. Moss's,
We received.
you got it, and you
we
agree, with- okay,
received or reviewed her comments, but
okay.
there's no action we can take based on the comments that I said.
Alexander,
Yes.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
All right, page 19, guarantees, claims, and offers. And this is a comment from Andrew Brown.
I read his comment and don't see that there's any action necessary to take. I think that's just a comment.
So your motion is that to acknowledge receipt of his comment?
Yep, no need to take any action.
No action necessary. That's Mr. Charles' motion. It was seconded by
Second.
Ms. Hills. Is there discussion on the motion? Ms. Maxwell, let's vote.
Alexander,
Aye.
Franks,
Yes.
McMullen,
Yes.
Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
All right, new rule 1260-02-.39 found at the bottom of page 19.
We need to go back and accept the.
Are we done?
Well, I make a motion that we, accept
Yeah.
Rule 1260-2-.12 as amended.
All right, you heard the motion. Is there discussion on the motion? Properly made by Commissioner Chara, seconded by Commissioner Hills. Let's vote. Ms. Maxwell.
Alexander,
Yes.
Franks,
Yes.
McMullen,
No.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
The motion passes 6 ayes, 1 no. Now, we have Mr. Alexander and Ms. Franks. We have lately been presented with one more little rule issue that if you'd like to stand by and participate in, you're welcome to. Frankly, you've provided a yeoman service holding that phone up to your ear for the last 3 or 4 hours. So,
We're not giving up now.
do you, Mr. Glandorf, do you want to handle this rule, or do you want to, Ms. Baird?
I'll just listen.
Yes, okay. Thank you. Tony Glandorf, Chief Counsel. What we wanted to add to the agenda was that it was a proposed rule regarding certificates of eligibility back in July. This board had approved a rule amendment regarding certificates of eligibility that would basically, yes, that was basically, it required, there was a statute that passed previously. And I believe it's 4029-107 regarding persons who had previously been convicted of with felonies, that they can now come back to the court and receive a certificate of employability. And the statute indicates that boards were now required, they could not by rule outright prohibit persons who are previously had a felony from receiving a license, and it requires that they be considered on a case-by-case basis. And I'm just giving you a quick overview so that, you know, for your of what you all did back in July. We sent that rule, as you all had approved it, to the Attorney General's office, and they did not feel that it was completely within compliance by adding a provision to paragraph 4. So what we did is we worked with them, and we came up with some language of just adding paragraph 5 that would basically do the exact same thing. It would be have a little bit of clarity in there. And so we provided to you, if everyone has it, that rule that the Attorney General's office had approved, and it would add a new subparagraph 5 to 1260-01-.01. And that paragraph basically says, notwithstanding the provisions of paragraph 4, this rule, if a person possesses a certificate of employability, that person shall not be denied the issuance of a license based solely on that person's past record of criminal activity, but shall instead be required to appear before the commission for the purpose of the commission considering on a case-by-case basis whether to grant or deny the issuance of the license. So all that really does is, if somebody previously had a felony and they do not have a certificate of employability, then the previous rule that you have, which is Rule 4, the current rule, still applies. Those can be denied outright within that rule, within the parameters that you've set. What paragraph 5 does is takes into consideration those people who have a certificate of employability, and it doesn't mean that you cannot ultimately deny. It just means that you must give them an opportunity to come to appear before the commission, and then you must make a determination on a case-by-case basis on the facts regarding their felony, whether or not you would deny that license or grant that license.
A proper motion in this case would be to move to add paragraph 5. Would that get it easily enough, or do we need to be more detailed at this point?
Oh no, that would, as written here, that would be good. That would be good enough, and that's all that we would need. We would also need a motion that on the Regulatory Flexibility Act and the Economic Impact Statement that was previously given back in July, that we would reaffirm that because it's absolutely doing the same thing.
Without reading through it all.
No, I don't think we have to read it. It's already been read on the
Okay.
record back in July.
All right. Is there a motion to amend this rule to add a paragraph 5?
Second.
Motion by Commissioner Collins, seconded by Commissioner Shaw, that this particular rule be amended by adding an additional paragraph identified as paragraph 5. Some discussion on the motion. I hear that. Let's vote. Let's vote on this one as well, Ms. Maxwell.
Alexander,
For the motion.
Franks,
Yes.
McMullen, Grease,
Yes.
Hills, DeChara,
Yes.
Collins.
All right, that motion passes on a 7-0 vote. Now, is there a motion to reaffirm the representations we made about the economic impact of this rule remain the same?
And the Regulatory Flexibility Act.
And the Regulatory Flexibility Act remains the same as well.
on both of them.
Thank you, Mr. Collins.
Second.
Second by Mr. Chara. Is there discussion on that? All right, I don't hear it. Let's vote. Yes, please.
Alexander,
Yes.
Franks, McMullen, Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins.
Yes.
That motion passes unanimously on a 7-0 vote. Mr. Flandorf, what else can we do for you?
That's all that I needed. What we will do procedurally is send this to the Attorney General's office, and once their approval, we will file it as a proposed rule, and everybody of the public will be able to see that rule, and those who would not agree with it would have the opportunity to provide that notice to the Secretary of State's office. If no more than 25 notices are received, that rule will become effective within 90 days of its filing. Thank you.
Thank you very much. Marcia and Wendell,
Yes.
you're welcome to stay around, but I wouldn't recommend it.
I'm gone.
All right, bye.
Thank you.
Thank you.
I hear a noise. I guess that's when they were. On my agenda, it says 11:30 break for lunch, so I don't think we're going to make that. Yes.
We have one more thing, and I don't know if this is a bad thing since they hung up, but we have to have, it slipped my mind. The rules as a whole, because we
I
have
think
to.
that the line's still open.
Are you guys still there? Are they still connected?
Disconnected.
They both hung up.
I think it's just the line's open.
We're gonna have to do that.
Make a motion, we approve the proceedings that we've done today.
All right, I'm just wondering if we need to get them back on the phone.
We got a
We got a
quorum.
quorum.
Okay, then we're good.
You got the motion?
Oh, by roll call?
It has to be by roll call.
Okay, so the motion is to approve in total everything we have done today. And that's what Mr. Collins moved, and it was seconded by
Second.
Mr. Chara. Let's roll call that. Ms. Maxwell.
The record that Commissioner Alexander and Commissioner Franks have both left the meeting by their telephonic connection has been cut off. McMullen?
Yes.
Grease?
Yes.
Hills?
Yes.
DeChara?
Yes.
Collins?
Yes.
All right, that motion passes.
Do we not need to make a motion, a total motion that it doesn't impact the public?
We did
We
that.
did that with the reg flex and economic impact.
I thought we had to do it again today, we don't.
Oh, we did. We didn't. We don't have to read them back into the record.
Such a suggestion.
Based on memory. I'm sorry, leave me alone.
Hey, Austin, I think we can take him, don't you?
I surrender. I surrender.
The chair's going to ask for a point of personal privilege. Mr. Gibbs has been in the audience, and he's here for one item that we may or may not get to today. And from the chair's perspective, I would like to handle his particular core class so he knows whether he's approved or not approved, rather than wonder whether we're even going to get to it today. Now, that's the chair's request for personal privilege. I think we're done with you, and we appreciate your patience as well. The only person in here kept her mouth shut all day, right? We appreciate that. Is there an objection to just amending the agenda so we can hear that class, that course?
Is there a time frame on this?
Well, it's from a business person's point of view, the longer he has to wait to find out whether or not it's been approved.
No, I didn't mean.
You mean today, as far as our meeting goes? We got a lot to do, is all I can tell you.
Okay. I'm talking about, I thought he was going to present something to us.
No, we didn't amend the agenda to allow anyone to speak today, so it's strictly a matter of handling this course.
All right.
Is there an objection from, so let's do it. Ms. Maxwell, at our last meeting, it's my understanding you were going to give certain curricula, for lack of a better term, to different commissioners, which I understand you did.
Yes, that is correct. I did.
Okay, I just want to make sure you get everybody up to speed. And you assigned Mr. Gibbs's class to Ms. Hills, correct?
That is correct.
And that's the topic I'd like to focus on at the moment. The guy's spent enough time here being patient that we ought to at least address him to keep him from having to sit here forever. Ms. Hills, so would you like to give us your comments on what you reviewed and your recommendations or motion to approve or disapprove, wherever you are at this point?
Yes. What I would recommend is that the commission sends it back to the instructor. I think there are points of order that are not in order. For example, Chapter 1 quiz at the end is labeled Chapter 6 quiz, and it is Chapter 6 quiz, but the numbers on the page match as Chapter 1. I think there are other things that are not in order with that, and one outline, Chapter 1, 2, 3, 4, 5, and then Roman numeral 5 and 6 and 7, and then to Chapter 6. They don't match the two, the module and the outline. So I would recommend that it go back to get it in proper order.
Let me ask if I could. Is what's supposed to be in there is more of how it's.
Yes.
So your concern is not the content so much as how it's in order, for lack of a better term.
Correct.
So if it were in good order, you would recommend approval today?
Yes, there are things I don't agree with, but yes.
Okay, so I'm going to just suggest this to the commission, and we'll see what you all think about it. What if a motion was placed on the floor that said, this course is approved subject to Commissioner Hill's representation that her concerns have been satisfied?
Well, can I ask her a question before we go there?
Uh-huh.
You said there's some things that you don't agree with. Are they personal opinions or laws and rules, or what?
Some are a little personal opinions or why they were brought into it. The other thing is that there are quizzes at the end of each chapter, and then there's an exam at the end, and most of the questions that are at the end of the quizzes are the same questions at the end of the that have not been reworded or anything in the exam. They've just taken those, say Chapter 2 each chapter has 5 questions. At the end is the quiz, and the exam is 30 questions, and all Chapter 2 questions are the same questions in the exam. I don't particularly agree with that style, but that's me personally. But the order is the main thing for a student to follow it, to follow the outline and the numbering order. Proper test number 1, which is not in here, was not in my package. It's the page number is I think 111, but it says chapter 6, and it does match chapter 6 quiz. So
Okay, so we
think
could
it's
make a
cleaned
motion
up.
to approve Mr. Gibbs' course with some minor housekeeping. Can we do that, Ms. Maxwell?
It's you all, it's really the commission's decision what they want to do.
What I'm trying to, I'm in favor of that conceptually. But are we think in your mind, Diana, are they substantive changes, or is this just kind of put together in a form that needs to be revised?
Put it in a form that needs to be revised in
But
the order that he lays out, because the materials don't match that.
And you'd be willing to share your notes with Mr. Gibbs to help him get that done?
Yes. Mm-hmm.
And again, my thought, which is not on the floor at this point, is if Diane is satisfied, would the rest of the commission be satisfied? That's my question.
I am.
And I'm not here, and I'm not going to make a motion, but if somebody would like to, let's see where it goes.
I'll make a motion that we approve Mr. Gibbs' core course with the housekeeping items to be corrected as Ms. Hills has found necessary.
Are we going to offer this to every person that does the test?
Well, I don't know what the other reports are going to look like, and maybe all the rest of them will be recommended to be approved. I just don't know. But I'm frankly doing this because the gentleman has sat here and.
I agree with you.
And I agree with you.
The door for everybody.
I know that we shouldn't, the commission nor staff should be the ones to go through it. I would think when it's presented, it should be presented in order. I agree with you.
So there's a motion on the floor. I have not heard a second.
Second the motion.
I have a motion made by Commissioner DeChara, seconded by Commissioner McMullen, that approves this class contingent upon Ms. Hill being satisfied the package is in the proper order, housekeeping, as Ms. DeChara described it. That could happen quickly, but until you're satisfied, this course is not approved, but it could be approved quickly.
Yes.
All right, that's the motion. Is there further discussion on the motion?
Just for clarification, to refresh my memory, why was it denied before?
There was on several courses, Ms. Maxwell took a look at them, and because certain commissioners have raised some issues about what's being taught, instead of her unilaterally or arbitrarily approving some of these core classes, she wanted various commissioners to take a look at them and get their comments on it.
And Austin was absent last time. So we assigned out.
So most people, other than the chair, got a class to take a look at.
Sounds like I dodged the bullet on that one.
You did.
So you're saying that as part of that process, you then reviewed this core class.
Yes.
And you're recommending that it be approved contingent on fixing some things that you've identified. Okay, I understand. Thank you.
I understand Ms. Hill says that material is in there. It's just not necessarily in the form or order that she would prefer it to be. And the intent of the motion is to keep from holding this course up for another month if we can get these changes made quickly. That's what the chair's understanding is. Are you ready to vote? Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, at this time, let's take a 15-minute break. But let me tell the people in the audience that are here for one reason or another, we're going to go a while today, but we also don't usually make you sit here through lunch, so at some point certain, like 4 o'clock, we're going to let you go unless you're just really having a great time listening to this and want to stay around. But we do have a formal hearing tomorrow with an administrative law judge, another court reporter. It starts at 9 o'clock, and we need you to be on time. I'm not dismissing you at this point at all, but I just want to give you a little sense of the schedule. And that hearing should be done before noon. We up here hope. Okay? So let's take it. It's right now. It's 20 till 2. Let's come back at about 5 minutes till 2. Give people a little time to get something to eat or talk or stretch. You may want to. Let's go over this.
We're gonna eat everything Kimberly brought. I know.
She got more pizza. All right, we're back in session. Whether this is on the agenda at this point or not, I don't know, but Ms. Robin Ryan would like to address the commission. And
I don't think she's on the agenda, so I'm not sure we should let her talk to us today.
You can overrule it.
It's on the agenda.
She says I am on the agenda.
I don't think so.
Well, first, let me ask this preliminary question. Are all 5 of you planning to be here tomorrow? Yes? Yes?
No, you know how things change.
We don't have a choice.
Are you
Well,
gonna be here?
Yeah, I have a hearing. That's why I'm making sure I have a quorum, so,
Oh, really?
yeah.
The audience, this is counsel that represents the state of Tennessee on these formal hearings, so you will hear her try to make the case that whatever she's espousing is correct. But that's
Will it be a contested hearing?
Yes, it is a contested hearing, and there is an attorney on the other side.
good, good. Is that what you were here to tell us?
No.
Well, go ahead and tell us what.
You should have in your packet, let me ask Ms. Maxwell this. Ms. Maxwell, did they get all this information about the?
Yes, they did.
Okay.
It's the Gaines reconsideration.
Well, it's not a reconsideration, it's an appeal.
Well, okay.
Okay, they're two different things.
Actually, I just called it a reconsider on my front
Okay.
sheet here.
Let me give a background and explain it and why this is here. Traditionally, this commission has heard all legal matters before it when parties don't come to an agreement. But you have voted some time ago that certain things you would let an ALJ do, for instance, unlicensed practice, administrative measures, some things that you have felt confident in ALJ. In this particular case, it was an unlicensed practice matter. It was heard in October. At that hearing, the respondent did not appear. And so a default judgment was granted against him. He then asked for a petition for reconsideration of that judgment, and the judge denied that petition for reconsideration. And then he has filed a notice of appeal, and this notice of appeal, if it were before you all originally, it would be now going to Chancery Court. But since it was not before you originally, this appeal is before you as the body. You have choices to make under the law on this appeal about how you want to proceed with it. You can choose to review it as a body, or you could choose to appoint a member to review it. One thing you must do, though, and we must do, and I am asking you to do today, sorry, Austin. One thing we must do and asking to do today is to set a date for briefs. While it's within your power to deny or grant oral arguments, you can choose not to do that. As far as briefs go, you must set a date, and parties must be allowed to file a brief. So that's what we're here today. First of all, decide if you are going to hear this as a group or assign somebody, and more importantly, get a brief date set. After the brief date is set, then we follow the rules, which is rule. You probably have a copy of it in your documents. They do? Okay. This is this is law 45315. The appeal itself has to state the basis for it. That could be an argument one way or the other on both parties' start. Then they have an opportunity, the agency has to afford every party, this is number E under 2CE, an opportunity to present a brief. And then if you choose, you can cause a transcript to be prepared from the hearing if you feel that's necessary. Then you can render a final order. And if you render a final order based on what you've got, that's fine. Or you can remand it, which means it comes back to you all for a full hearing. That's the process we have before us today. The two important things that we have to discuss are time for filing a brief and whether or not you're going to do this as a body or whether or not an individual is going to review it.
Mr. McMullen.
If it's one member does it, is it a recommendation that member makes to the entire board, or is it just that that member makes the final decision?
Well, I think, let me see where it has. Let me see if I can read you about what the agency can do. The agency, in the exercise of discretion conferred by statute, rule the agency can delegate its authority to review the initial order to one or more persons, and then that person would, I think, do a final order. I don't see the law is not as, unless you see something I don't, and you may see something I don't, the law is not that complete in the who, what, when, where, why, and how, and I could not find a rule that sets it forth more clearly either.
So far, it sounds to me like there's only one person qualified on this commission to handle this.
Well, you are all qualified to handle it because you are all members of this commission.
Yeah, but you're
If
using
you
like
want to
for-
get me to do it, I will, and I would say 30 days for the initial brief and 60
30 days from today?
Yeah, and 60 days for the response brief.
Okay.
See, my point exactly. Thanks for volunteering.
Say that there was an ongoing trial outside of, about this also.
I do not know if there's an ongoing trial about this outside. I just know he did not have an attorney, and he did not appear, does not have an attorney. He has done this on his own.
Briefs be sent to
Well, if
you or
have a-
Eve or
if-
somebody and then forward
if-
it to me
If you all vote to appoint you, then I will send them to you
after you get it.
after I get them.
Okay, that's fine.
Is there other discussion before we decide whether somebody wants to nominate Austin to be the point person for this?
As long as I don't ever have to review a core course.
I make a motion that
Huh?
that we, that Austin take this.
I second that.
Do you need those dates in the
McMillan.
motion? Do
Sorry?
you need those dates in the motion, 30 days and 60 days in the motion?
Yeah, probably as well.
Okay.
Well, someone needs to make a motion about what the dates are going to be for filing the briefs.
Within 30 days?
There are two different, technically, it usually is, as pointed out, a brief that's usually filed by the party who is appealing, and then the response brief, and that would be, in this case, the state. And it was suggested that a 30-day period for the person filing and a 60-day for the response. That's what was suggested.
In my motion, 30 days for filing the briefs and 60-day period for responding.
I'll second.
That's a motion on the floor. If there's no brief delivered within 30 days, what happens?
It still has to be considered. I think it might be quicker in making the consideration. I will tell you that the body has a 60-day period after the receipt of briefs and oral argument, if there was oral argument, unless that period was waived or extended, which, that would have to be either by agreement or by permission of this group. So after the 60-day period has run for the state's brief, then Mr. McMillan would have an additional 60 days within which to file it. If a brief was not filed within the 30 days, I think that he might have the authority to use whatever he does have and go forward from there. It's not, I don't know, if brief is not necessarily to make the decision. It's just, you have to afford the person an opportunity to file the brief.
So at the end of this process, if this motion passes as presented, will this commission be involved in it, or will it be?
It would be Mr. McMullen.
Okay.
Having said that, he would then make his proposal, and a final order would be drafted. Then the respondent has an additional time to appeal that before the Chancery Court.
Right, just to the audience, this guy that was found guilty, or guilty, is that the right word?
Violation.
In violation.
In violation of state law, was fined. Anybody want to guess the dollar amount, why he might be interested in appealing?
He was penalized, a penalty.
A penalty, not a fine, whatever. The penalty was $269,000, is that about right?
Yes, that is not what I asked for.
Wanted more?
No.
Shoot.
But it
He
is
wanted
up to
a
the
little
judge.
blood with that, right?
Yeah, and so the audience understands in the severity of the issues for any violation of the law under the Tennessee Real Estate Commission laws. As a general rule, there can be assessed a civil penalty of up to $1,000 per day of violation. In this particular case, the judge found that there were 200 in excess days of this person acting without a license. But the same law could apply if there were 200 days of holding escrow money or 200 days of advertising that's not correct. I mean, the same law would apply.
So y'all are just lucky to be here today on what you agreed to.
All right, there's a call for the question from Commissioner McMullen. The motion, as stated, is what we're about to vote on. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes 5-0. Thank you, Ms. Ryan. Is there anything else that you want to tell us about?
No, there is not. I will see you all tomorrow. Thank you very much for including me in your agenda.
Won't happen again, according to some people here, Mr. Char. All right, we're to the legal report.
You look so excited. He's like,
Once again, to the audience, people file complaints all the time. They file them against individuals, licensees, the broker that represents the individual or the licensee. Sometimes the state files complaints against them. And we're about to hear a series of complaints that this commission knows nothing about. The parties are not identified. The location the event occurred is not identified. And we're going to listen to it. Council is going to make a recommendation, and then we're either going to agree with council, ask council questions, disagree with council, make our own motion, but that's the process we're about to start. And this does not presume guilt. It's just if we suggest a fine, then somebody will go to that respondent and say, hey, if you want to, a civil penalty, not a fine. If you want to, we can get this settled right now. Sometimes they don't want to, and that's what we're hearing tomorrow. We made an offer, apparently. The respondent said, I'm not agreeing to that, and he has, as each of these people, each of these entities do, has the right to have a formal hearing, and that's what we're having tomorrow for one person. All right, Miss Baird, are you starting it, or who's?
I am.
All right.
Okay. Let's just start off by saying any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. Item number 1, 2013-013-011. At the December 2014 meeting, there was a motion and a second to dismiss the following matter, but the commission did not vote on the motion.
Okay, now let's stop you right there.
Okay.
Previously, we heard this particular complaint, and we authorized litigation monitoring. Is that correct?
Mm-hmm.
And that litigation has come to an end.
Correct.
And on page 3, Commission, at the top, you can see that following the conclusion of litigation, the respondent's attorney added some information. Would you start there, Keeling?
Yes, respondent's attorney provided additional information that an agreed order of compromise and dismissal was filed in Chancery Court on October 28, 2014. The settlement agreement between the parties is confidential and was not provided to legal counsel. The recommendation is to dismiss.
Motion to accept the recommendation.
Got a motion by Commissioner Collins, seconded by Commissioner McMullen, that the recommendation of council be adopted. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. That motion passes unanimously. The second, third, and fourth complaints have also been previously heard. And you may recall that this case and file was assigned to Commissioner Alexander. And this morning, in somewhat arbitrary fashion on my part, I asked what his recommendation is after reviewing the file, and Commissioner Alexander stated that his recommendation was to dismiss. He can't make that motion, obviously, since he's seen the file, but is there a motion to dismiss?
Yes.
Second.
I've got a motion.
We need to read the numbers into the record. I'm sorry.
I got it.
Okay.
Go ahead.
I'm not trying to interrupt. I'm just, okay.
You just want to stay here all day.
I do. I just love it. Item 2 is 2014-014711. Item 3, 2014-014712. And item 4, 2014-014713. Okay.
All right. Mr. Collins, did you make a motion to accept Commissioner Alexander's recommendation and dismiss?
And I second it.
and is seconded by Commissioner McMullen. Is there discussion on the motion? All right, hearing none, let's vote. Those in favor of the motion vote aye. Those opposed, no. That motion passes unanimously. Numbers 5 and 6, Ms. Baird.
Item 5, 2014016-941. Item 6, 2014016-942. Complaint was filed by a potential buyer who placed an offer on a home, and respondent 1 represented the seller. Complainant states that a home inspection was completed and a proposal for repairs was sent on May 8, 2014, but did not receive confirmation that the repairs were made until the scheduled closing day. Complainant states that during the final walkthrough, it was discovered that only 2 of the 6 repairs were done. Complainant states that when complainant's agent contacted Respondent 1 regarding the repairs, Respondent 1 stated that closing would likely not occur because seller was not aware that seller was to pay $7,050 in closing costs. Complainant states they offered a 3-way split of closing costs, but Respondent 1 denied, stating that the appraisal was for $11,000 more than the offer, so complainant should be able to pay closing costs. Complainant states that an unnamed person called the mortgage company claiming representation of complainant, and the mortgage processor provided the appraisal amount. Complainant states that complainant was forced to either pay the closing costs or be without a home, so closing occurred. Complainant further states that upon taking possession, the kitchen island had been removed and the seller canceled the home warranty that was to transfer. Complainant states that complainant's agent and attorney worked hard to have the warranty reinstated, but not for the full 1-year term as agreed to in the contract. Complainant further alleges that the air conditioning was not cleaned per the repair proposal, which was discovered when the central air unit stopped cooling 4 days after closing. Complainants allege that Respondent 1 was negligent by not explaining the contract to the seller and ensuring seller's compliance. Complainants also allege fraud in obtaining appraisal information and submitting false repair invoices. The purchase and sale agreement appears to have been accepted with adjustments on May 6, 2014, with a binding agreement date of May 7, 2014. It appears that the kitchen island was listed as an item to remain. It also appears that in the title expenses section on the TAR form, it states that each party is to pay their own expenses, and a few lines beneath that states, not all of the above items are applicable to every transaction and may be modified as follows. Seller to pay 3% of sales price towards buyer's closing costs and prepaids. It further appears that seller amended the possession date and added that seller was to transfer the home protection plan at closing for 1 year upon accepting the offer. Finally, it appears that buyer's inspection was to be within 7 days of the binding agreement date, and resolution period was 2 days following receipt of written list. The invoice for the air conditioning cleaning was dated May 28, 2014. Respondent 1 stated that when the offer was received, Respondent 1 was on the road returning from medical treatment for Respondent's spouse. Respondent 1 states that Respondent could not read the entire contract on the phone, so Respondent 1 placed a call to complainant's agent, who reviewed the contract. Respondent 1 asked about the title expenses and special stipulations and states that complainant's agent replied, "No, there is nothing there except for the usual closing cost breakdown as to what the purchaser and seller will pay, but did not mention the 3% closing cost." Respondent 1 states that through the process, the contract passed through multiple people, assistants, title company, closing attorneys, etc., and nobody caught the line item regarding 3% closing costs, and further states that the complainant accepted and approved a closing statement that did not include the 3% closing costs. Respondent 1 further states that a staff member called the title office to obtain the appraisal value and states that the staff member identified herself from Respondent 1's office. Respondent 1 states that the sales price would have been adjusted to accommodate closing costs on the onset if it was known. Regarding the repairs, Respondent 1 acknowledges that a repair replacement proposal was submitted, but states that a separate mutual agreement was not executed by both parties, and therefore an agreement for repairs was never established. Respondent 1 states that the repairs done by seller were in good faith and not out of obligation. Respondent 1 further states that the movers inadvertently moved the kitchen island, which originally cost the seller approximately $200. Respondent 1 states that the cost to ship it back would have cost more than $300, and seller offered to pay complainant $300, but complainant would not settle for less than $2,000. So seller's sister drove the island back to the property. Respondent 1 further states that the home warranty was never canceled, but was transferred in the complainant's name, but the company inadvertently canceled it. Respondent 1 states that the seller's side tried to work for a reasonable solution, but the purchaser demanded results instead of discussing solutions. Respondent 1 states that Respondent 1 relied on the goodwill of complainant's agent and believes that complainant's agent was negligent in explaining the terms of the contract, while Respondent 1 was in a difficult situation for the benefit of her client. Respondent 2, principal broker, states that Respondent 1 approached Respondent 2 when the question of closing costs surfaced, and Respondent 2 advised that Respondent 1 should pay closing costs with Respondent 1's commission and then file a claim with the E&O carrier. Respondent 2 was under the impression this was how it was handled until receipt of the complaint. The recommendation is as follows. With regard to Respondent 1, a consent order with a civil penalty in the amount of $500 for violations of TCA 6213-312B14 and 6213-4031, plus attendance at one entire regularly scheduled meeting of the Commission within 180 days of execution of the order. With regard to Respondent 2, consent order with a civil penalty in the amount of $500 for violation of TCA 6213-312B15, plus attendance at one entire regularly scheduled meeting of the Commission within 180 days of execution of the order.
Motion to approve council's recommendation.
Second.
I don't think the penalties are enough on these violations. We did vote when we were back in Jackson to increase penalties, not decrease them. I would like to amend the motion that each party civil penalty be $1,000.
So with 5 people present and 2 people already making and seconding a motion, now a substitute motion. It's up to you, Ms. Hills. Do you want to second
I
this-
second
the
it.
amendment? All right, so the motion as amended, and we'll vote on the amendment first, adopts council's recommendation with an amendment to the amount of the civil penalty. Let's vote on Ms. DeCharo's amendment. If you're in favor of raising it from $500 to $1,000, you'll vote yes. If you're not, you'll vote no. All right, those in favor of Mr. Charles' motion vote aye. The chair, there's no need to take the no part of it because it's all unanimous. Okay, so now the motion in front of the commission is legal counsel's recommendation with a $1,000 penalty to each respondent. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion carries unanimously. Number 7 and 8.
Item 7, 2014017151, and item 8, 2014017152. Complainant states that Respondent 2, who's unlicensed, is presenting himself as a licensed realtor on Facebook. Complainant states that Respondent 2 is working with Respondent 1, who's the principal broker's firm. Complainant states that listings are being posted without permission of the listing agents with much higher list prices than the actual list price. Complainant further states the firm is offering private financing with interest rates of 9% or higher. Complainant further states that Respondent 2 is asking buyers to submit very high down payments and guaranteeing financing with no documentation. Complainant further states that complainant has met with several potential buyers who worked with respondents and states that potential buyers were not given a copy of any executed documentation. The complaint was forwarded to respondents but returned unclaimed. Neither respondent responded to the complaint. Office of Legal Counsel researched the Facebook profile on December 1st, 2014 for Respondent 2. It appears that the most recent post was dated October 18th, which included a property address, short description, and photographs. Further, the name on the page appears to be a Spanish phrase that can be translated into "want to buy a house," and the About section states Respondent 2's first name and last initial. Respondent 1's firm also has a Facebook profile, and it appears that a photo was posted on or about March 8, 2013 that includes 5 individuals, none of which are named. The photograph also includes the firm name, stock photos demonstrating homes being sold, but it does not include a telephone number. A second picture shows the same 5 individuals listed in the picture and includes names and job titles. It appears that 2 of the 5 individuals are actively licensed with the Tennessee Real Estate Commission, one of which is Respondent 1. The other 3 do not appear to be currently licensed with TREC. Recommendation for Respondent 1 is a consent order with a civil penalty in the amount of $500 for violations of TCA 6213-312B14, bless you, and 6213-313-2 for failure to respond, plus attendance at one entire regularly scheduled meeting of the Commission within 180 days of Respondent's execution of the order. For Respondent 2, consent order with a civil penalty in the amount of $500 for unlicensed activity in violation of TCA 6213-102-4A, 6213-103, and 6213-301. Said order to also include language to cease and desist all unlicensed activity.
Motion to accept the recommendation but increase the amounts to $1,000.
Second.
Well, you've heard the motion. Let me ask one quick question. On respondent two, who's unlicensed, is that correct?
Yes.
We cite two, perhaps three different sections that you believe he's violating, she's violating. Motion, Mr. McMullen, per section or total? Understand that. All right, is there further discussion on the motion? It is to accept council's recommendation with the exception of the civil penalty, which will be doubled in each case to $1,000. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Numbers 9 and 10.
Item 9, 2014-017-171, and item 10, 2014-017-172. Complainant submitted an offer on a home, and respondent 2, who's the affiliate broker, represented the bank seller. Complainant states that complainant submitted an offer, provided additional documentation upon request, and complainant's offer was accepted. Complainant states that a few days later the contract was denied without further explanation. Complainant states that respondent 2 sold the property just a few days after declining complainant's bid, but ignored complainant's calls. Complainant states that respondent 2 did not follow the bank's guidelines, and complainant feels discriminated against after having provided proof of funds and all required documentation. Respondent 1, the principal broker, submitted a response stating that complainant filed a complaint with their office, and respondent 1 reviewed the file and sent an email to complainant clarifying the issue. Respondent 1 states that complainant's offer was marked as accepted online, but another offer was received around the same time, so the bank opened a multiple offer process requesting both potential buyers to submit their final and best offer. Respondent states that the bank accepted the other offer, and the bank does not customarily state why one offer was better than another. Respondent 1 states that respondent 2 did not return complainant's calls because complainant was represented by an agent, and that is not proper protocol. Respondent 1 denies that complainant's offer was disregarded or ignored, stating that
Chairman, since this is a bank foreclosure,
I'll second that.
Commissioner Collins moves that this complaint be dismissed. Mr. McMullen seconds that motion. Is there discussion on the motion? I hear none. Let's vote. Those in favor of Commissioner Collins' motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 11.
Item 11, 2014-017-291, a complaint was filed on or about July 21st, 2014 against respondent stating it is an unlicensed residential property management company. Respondent submitted a response on or about July 29th by and through an attorney denying allegations. Respondent states the complainant used a fax address and phone number when submitting the complaint, and the complaint fails to provide any basis for violation. Respondent states that it is a new entity that was formed in 2014 and is working toward forming a proper business structure. Respondent states that respondent is working with a broker and intends to file for licensure. It appears that respondent became licensed on or about August 22nd, 2014. Recommendation is to dismiss.
So were they doing something in July that required licensure and they weren't licensed or not?
I don't think that we had that information. We didn't get anything in the complaint showing that they were acting as a property management company whatsoever. It was a one-sentence complaint.
One sentence complaint.
they weren't offering to do anything for them or anything.
That we're aware of.
Okay.
Motion to dismiss.
Second.
There's a one-sentence motion to dismiss offered by Commissioner McMullen,
I can come up with some one-sentence complaints for you, too.
seconded by Commissioner Collins. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Numbers 12 and 13.
Item 12, 2014-017-391, and item 13, 2014-017-392. Complainant was seller and respondent 2, the broker, was buyer's agent. Respondent 1 was respondent 2's principal broker between April 9th, 2014 and August 26, 2014, and thus the time of the transaction. Complainant alleges that respondent 2 drafted an early occupancy agreement, but complainant did not sign it. Complainant further states that closing did not occur as scheduled on July 18th, and buyers again requested early occupancy, but complainant refused, only allowing buyers to place a few boxes in the garage. Complainant alleges that on July 18th, Respondent 2 instead gave buyers the keys to move in. Respondent 2 stated that the closing was scheduled to take place originally on July 18th. In good faith, the buyers submitted a temporary occupancy agreement on the morning of July 17th. Respondent 2 stated that they expected the complainant to sign the form and return it that day since complainant had already moved out of the house. Respondent 2 stated that although complainant had not signed the temporary occupancy agreement, complainant's agent gave permission for the buyers to move boxes into the garage and gave Respondent 2 permission to give buyers access to the lockbox to gain entry to the garage. Respondent 2 states that the loan company did not provide documents to the title company in time for closing on July 18th. At this point, the complainant wanted the buyers to pay $500 rent for the weekend and that the furniture could stay in the house, but complainant did not want the buyers to occupy the house until closing on July 21st. The buyers agreed to the terms and gave the keys back to complainant's agent. The rent check was given to complainant's agent, made payable to complainant after the closing on July 21st as agreed. Respondent 2 is truly sorry that the lender did not send the loan package when promised because it caused a stressful situation for all parties. Respondent 1, the principal broker, sent a response to the complaint stating that Respondent 2 gave express permission to the buyers to do precisely what and only what the complainant had authorized, that is, move boxes into the garage. The buyers moving into the living area of the property prior to close was initiated by the unfortunate and untimely intervention of the neighbor, wholly without the knowledge of Respondent 2. The buyers relied on the representations of the neighbor that the complainant had authorized them to move in before obtaining approval from Respondent 2. This was a mistake, but an understandable one, as the buyers are not real estate professionals. Once Respondent 2 discovered that the buyers had moved into the living area of the house prior to close, Respondent 2 set out to resolve the situation in a prompt and professional manner. The recommendation is to dismiss.
So move.
Second.
Commissioner McMullen moves to accept council's recommendation. Commissioner Hills seconds that motion. Discussion. All in favor of the motion vote aye. Those opposed, no. That motion passes unanimously. Number 14.
Item 14, 20140, no. Is that right? I don't think so. Just right. It should be 20140176621. I apologize. I made a little typo there.
You don't have clerical help with this kind of stuff?
I do, but see what happens when I do it myself, it gets messed up.
Oh, okay, I see.
She should have let the clerical
Exactly. This complaint alleged that Respondent Principal Broker failed to return earnest money deposit in the amount of $1,000 after complainant did not close on the contract date of December 13th, 2013. The complaint also alleged that Respondent attempted to write the original contract without the clause, purchase contingent upon buyer obtaining financing at lending institution at reasonable terms, terms defined. The complaint alleged that Respondent failed to keep abreast of developing situations during the contract performance period and failed to negotiate any of the terms of the contract once the original seller died. Complainant stated Respondent refused to get involved and left complainant to negotiate with the seller's heirs. Complainant alleged that now the Respondent is trying to insert himself back into the deal even though he has done nothing and is not in the new contract. Complainant alleges that the Respondent's interference in this matter is directly affecting complainant's ability to negotiate with seller's estate executor, as complainant has been told complainant will be sued if the full original commission is not paid. Complainant stated that complainant has $10,000 already invested in the property in order to get it appraised for the agreed upon sales price, and the property is in need of major repair to the tune of about $8,000, which the seller has agreed in principle to compensate complainant for, but not with the addition of a full commission going to the non-performing Respondent broker. Respondent sent a response to the complaint, stating that Respondent would be happy to interplead the earnest money, but Respondent has never received a request for disbursement from either party or their representatives. Respondent stated Respondent could not write in the requested clause as there was no legal definition as to reasonable terms. Respondent stated that Respondent attempted to remain involved with the contract throughout the process. However, during renegotiations, complainant was trying to cut Respondent out of a commission. Respondent stated Respondent's responsibility ended at the signing of the original contract, even though Respondent offered his services to assist. Respondent denies telling either party that Respondent would sue them, just that Respondent felt there was a valid contract for compensation. Respondent states that complainant's investment has nothing to do with Respondent, but the contract states buyers are to be responsible for repairs. Respondent denies being in violation of any laws or rules of the Commission. Office of Legal Counsel reviewed the transaction file, and it appears that respondent's auction firm is the selling company and respondent's real estate firm is the listing company. Complainant entered a lease purchase agreement with the seller for a term of June 1st, 2013 through December 31st, 2013, which included a $1,000 earnest money deposit that respondent's firm would receive a commission at the final closing of the property. An extension of the lease purchase agreement was filed on December 17th, 2013, amending the contract between landlord's heirs and complainant, extending the term through August 1st, 2014, and deleting the provision for commission. It further appears that complainant has not closed on the subject property. Recommendation is to dismiss.
I'm a little confused by number one, why they renegotiated the contract just because the seller died.
I can look.
I mean, that contract was still a valid contract. And so I'm not sure why they were trying to renegotiate it and leave the agent out of it.
I think the contract was an extension because the original term expired and they hadn't purchased it. I don't know why they changed additional terms to the contract.
So you're saying the contract had already expired when the seller died and there wasn't a contract?
We'll have to get the file. I don't think that's the time. I think the term expired after the seller died. And so when they went to extend the term, they changed the other provisions. But I'm not sure they addressed as to why.
So, do you think the complaint was filed? It looks to me like, just looking from a big overview, that the guy's filing a complaint because the realtor is insisting on his commission and is kind of clouding the negotiations. Although the first sentence of this complaint says he's failed to return earnest money deposits. So I'm trying to determine, the only thing I'm worried about on this is if he did fail to return earnest money.
What we determined with that was that the respondent did not collect the earnest money. It appears that through the contract that the owner of the property collected all of the rents, etc. on that.
Broker never had
And it was never requested in writing either.
I was gonna say, the broker's not denying having the earnest money, he just says nobody's
Nobody asked
requested
for it.
it.
Oh, that's right, I'm sorry.
Yeah.
Yeah, it was never requested in writing because they haven't decided whether or not they're going to go through with the sale. It hasn't been sold, so, and the contract hasn't been canceled either.
So, Ms. Baird, what are you looking up?
I was just looking to see, try to answer the question as to why there was another
In
contract.
negotiations.
It says there's an extension of the lease purchase agreement. It says, whereas the previous person who we were discussing passed away and has been unable to exercise his agreement to purchase property for the contract price as set out therein. That's all it says.
The purchaser died or the seller died?
The seller died.
Seller.
Which doesn't void a contract.
That's really all it says.
I have closed several that a
But if the
seller's
contract's,
died.
if the contract's out of date by that point,
Well, that was
It's
my
current,
question,
yeah.
that's what I was asking.
You could go to heirs and assign, but if you got a state person that doesn't really want to play the game, he can void.
dated December 31st. The seller passed away November 8th.
So they were still under a valid contract.
Correct.
To December 31st, 2013.
Right.
Yeah.
And then the seller passed away November 2013.
But when did they renegotiate the contract?
Like, if I'm reading this correctly, December 30th, 2013. There's
So they renegotiated the contract before it expired.
or the day of, maybe? The day before. It was renegotiated on December 30th. The original one expired December 31st.
I'd like to take that file and review it. There's something about that that don't feel right to me.
Is there any objection to, do we have a timing issue with this one?
We always have a timing issue. There's really timing issues on all of these.
Well, I don't know how we solve it.
It
Are they-
appeared to us that the only complaint that was under the Brokers Act was regarding the earnest money, and that the earnest money was not requested. The buyer and seller hasn't figured out what they want to do, if the buyer wants to carry through with the contract or not, and so therefore it's not been dispersed.
But if there's no contract left,
Well, there's a new contract
that
now.
expired, I thought it expired August 1st,
They extended it.
2014.
They extended it.
That's to that date.
To that date, so we're past that. We're past the extended date. Past the August 1st, 2013.
We're checking on that.
Oh, okay,
Sorry.
sorry.
Find the contract, they deleted the
Here we go.
commission. There's no issue.
Ended to August 1st,
They
2014.
can't delete that
August
agent's
1st.
commission just
So they extend
They're
to
out-
August
they're
1st.
out of contract now.
Yeah. So the broker needs to turn the money over. And the broker does have the money.
That's what I just
Read that,
asked Carl.
read that right there.
As far as we know, yes.
Is there a contract in that file that shows who's holding the earnest money? Is there a contract in the file that shows who's holding the earnest money?
Written request is made.
Don't request, you can
If you
sit
don't
on it.
request,
Make a motion, we dismiss it.
Got a motion by Commissioner Collins that council's recommendation be accepted and this complaint be dismissed. Is there a second? Mr. McMullen, did you hear the motion? Thank you. There's a second to the motion.
So I have a question.
Okay.
So if we were to go another month if it were to assign, we would be out of our dates. Okay.
I just don't know what harm has occurred to date. I don't see it. Perhaps a real estate agent's trying to protect his commission, and perhaps that's screwing up what the buyer wants to pay, but I'm not sure that's a violation of the real estate laws of Tennessee.
They signed another contract.
Yeah. So, in any case, we have a motion on the floor, properly made by Commissioner Collins, seconded by Commissioner McMullen. Is there further discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
No.
Passes 4-1 with Commissioner Chara voting no. Commissioner, would you take next several of these? 15.
Number 15, 16.
Okay, item 15, 2014017-951. And item 16, 2014017-961. The complaint was filed by an unrepresented seller and alleges that Respondent 1, who's the broker, intentionally misrepresented to Respondent 1's clients, the buyers. The complainant's outdoor non-attached utility building was included in the sale of the home and property. Complainant stated it was never included in the offer and never mentioned until closing when the buyers asked for the key. Complainant alleged that Respondent 1 insisted it was part of the sale and assured that complainant would hand over the key before closing documents were completed. Complainant states that Respondent 1 intentionally misrepresented that the building was for sale due to complainant not having representation in the transaction, and complainant was coerced to agree as the final documents and the ultimate sale of the home hinged on that agreement. After the closing, complainant spoke with Respondent 2, the principal broker, and complainant alleges that Respondent 2 agreed that the building was not part of the sale. Complainant states that Respondent 2 was going to look into the issue and respond back, but never did. TREC opened a complaint against Respondent 2, the principal broker, for failure to supervise Respondent 1. Respondents sent a joint response claiming that their clients were satisfied and not intentionally misrepresented as complainant suggests. Respondents also state that the shed does not convey. It is listed on the tax card as an improvement as well as the appraisal. Therefore, using the definition of property in the purchase and sale agreement, all improvements remain with the property. Respondents state that complainant was paid the fair value for the shed included in the sales price of the home. Respondent 2 denies agreeing that the shed was not part of the sale as suggested by complainant. Respondent 2 stated that Respondent 1 performed Respondent 1's job without incident. Respondents further state that the Commission should be made aware that respondents were not made aware in writing that complainant was obtaining a real estate license during this transaction. The recommendation is to dismiss.
I have a motion.
Yes, I'm recommending.
Dismissal. Okay.
Do I have a second? Yeah. Any discussion? We're getting kind of slim on commissioners here. Yeah. All those in favor vote aye.
Aye.
Opposed? Motion carries. Next.
Item 17, 2014-017-991. This complaint was filed by the sellers and alleged that in the contract, complainants requested that they be called and an appointment be set anytime the property was to be shown. Complainants alleged that the respondent and the buyers took it upon themselves to enter the house a third or fourth time without complainant's knowledge or permission, which were unrelated to the termite inspection. Complainants further alleged that respondent lied about the occasions that respondent was in the house with the buyers. Complainants allege that respondent practiced unprofessional and unethical behavior and should be reprimanded. In addition, complainant alleged that respondent sent threatening text to complainant's agent the day before closing regarding $250 that was to be paid by complainants. This amount was inadvertently left off the HUD settlement statement. Complainants agreed to write a check at closing, but stated that respondent's threatening text continued. Respondent submitted a response stating that respondent never entered without permission from the listing agent at any time. Respondent's buyers were first-time home buyers, and they were excited to be purchasing the home and asked after the inspections were completed to allow family members who live out of town to view the home. Respondent stated that respondent was in close contact with the listing agent during that time who knew they were entering the property and gave them permission to do so. Respondent also denied threatening the listing agent over the monetary dispute. Respondent states that respondent was simply trying to represent the buyer's best interests. Respondent also submitted a statement from the listing agent stating that she was the one who gave respondent permission to enter the house and that complainants know that. She stated that the complaint was unnecessary and that complainants were able to sell their home quickly and that respondent did nothing wrong. Recommendation is to dismiss.
Do I have a motion?
I move.
Do I hear a second? Any discussion? All those in favor, please vote aye.
Aye.
Opposed? Motion carries. Number 18.
Item
We
eight-
have one pass on the list.
Okay. Item 18, 2014-018-011. TREC filed a complaint against respondent principal broker for failure to supervise the respondent agent from the previous case number 2014-017-991. No response was received from respondent principal broker.
Motion to accept the recommendation, but make it $1,000.
Have a motion for consent order with civil penalty in the amount of $1,000 for violation of TCA 6213-312B14 and 6213-313A2, plus attendance at one entire regularly scheduled meeting of the commission within 180 days of respondent's execution of consent order. Do I have any discussion? All those in favor vote aye.
Aye.
Opposed? Motion carries.
Item 19, 2014018111. This complaint alleges that complainant called respondent, the listing agent, for two parcels listed for sale in MLS, and respondent attempted to describe the parcels and their history. Complainant asked respondent, who had the same last name as the listed property owners, whether respondent was related to the owners, to which respondent stated that one of the owners was respondent's spouse and the other was respondent's brother. When complainant asked why that was not disclosed on the MLS, respondent stated that respondent was not an owner or agent. Subsequently, complainant made an offer to purchase the property through respondent, accompanied by a $1,000 earnest money check. Complainant dropped off the contract and check at the real estate office and alleged that this angered respondent, who told complainant to email it instead. Complainant states that complainant called the principal broker, who agreed to scan the offer to respondent from the office. Later that day, complainant received an email containing the last page of the offer from respondent, allegedly signed by the owners rejecting the offer. Complainant replied to the email with complainant's address to return the earnest money check, but instead respondent requested that complainant go by the office to pick it up. Complainant states that complainant finally got the check back 8 days later after contacting the principal broker. Complainant alleged that respondent did not act honestly and in good faith in regards to the advertisement of the properties by not disclosing ownership, marital or familiar ownership at the least, in the properties, as well as respondent's refusal to return complainant's earnest money that was hand-delivered to the office. Respondent sent a response to the complaint stating that respondent did disclose the relationship with the owners but explained that this is an investment property and respondent's name is not on the deed. Therefore, respondent cannot put on MLS as an owner and agent. Respondent tried to explain to complainant that there was a personal interest disclosure form, but that complainant did not listen. The original offer submitted by complainant was typed by complainant personally, and respondent used the TAR form, which is copyrighted, only to be used by realtors. Respondent stated that when the offer was rejected, complainant became angry and asked respondent to return the earnest money check to complainant's house personally. The broker mailed the check back to respondent 5 days later. Respondent claimed that complainant practiced unlicensed activity. Recommendation is to dismiss.
I have a motion.
Second.
Motion made by Commissioner Collins, seconded by Commissioner Hill, that we accept council's recommendation. Any discussion?
That's a good question. Was there not a violation of 62-13-403-7A because they were acting on behalf of the licensee's immediate family without prior disclosure of the interest?
Respondent said he told him he was related. I don't know if that's true or not, but at least
Respondent's claiming that he told him, but that he was already so angry at that time that he wasn't listening to anything.
Okay, yeah, because, okay, they did tell him on the telephone conversation. Okay, got it. Okay.
As far as we know, yes, they did.
Okay.
Any other discussion? All those in favor of dismissal, say aye.
Aye.
All opposed? Motion carries.
Item 20, 2014018121. Trek filed a complaint against respondent principal broker for failure to supervise the respondent agent from the previous case number 2014018111. Respondent sent a response to the complaint stating that affiliate broker in no way made any substantial and willful misrepresentation. Respondent states that complainant from case number 2014018111 acknowledges that during their very first telephone conversation, affiliate broker told previous complainant of the relationship to the owners of the property. Respondent stated that owners' agents are only required to disclose in MLS listings. All of their personal interest is properly disclosed on the TAR form and becomes part of the contract. The offer was rejected, therefore no personal interest form was required. Within 3 business days, the check was put in the company mail to previous complainant. Should have gone out that day or the following day. Respondent states that affiliate broker did not refuse to return the earnest money, but refused to take it to the complainant's home as demanded. Respondent further states there was no trust fund deposit. Recommendation is to dismiss.
Move to dismiss.
Second.
Any discussion? All those in favor say aye. Aye. Opposed? Motion carries.
Item 21, 2014-018-521. Complainant alleges that complainant's rights as a tenant were violated and complainant's things were removed from the property. Complainant alleges that new tenants were given keys and unsupervised access to the townhome complainant was renting while complainant's lease was still current and active. Complainant alleges complainant's personal belongings were moved without permission and items were stolen and damaged. Complainant alleges that no verbal, written, or legal notification was ever presented, giving complainant a time frame to remove the items before they were removed. Complainant alleges that when complainant contacted respondent who orchestrated the removal, respondent took no responsibility, nor did he try to remedy the situation. Respondent sent a response to the complaint stating that complainant has filed a civil lawsuit against respondent and that this has been an ongoing problem. Respondent claims the new tenants were not given unauthorized access to the property. Respondent stated complainant was aware that the unit had been rented and was given many opportunities to take complainant's possessions out. The new tenants were not given keys until all of complainant's items were out, but they were allowed in the unit on the first day of their rental to deposit cleaning items. Respondent stated that complainant's items were not moved without complainant's knowledge. Complainant was notified prior to the new tenant's move-in date and was given instructions on what to do. Respondent claims that complainant acknowledged the many notifications through text message. Respondent states respondent was not responsible for orchestrating the removal of complainant's possessions, rather it was a landlord and his agent who were responsible. Respondent stated that complainant was in violation of complainant's lease by not switching the utilities over into complainant's name. The landlord paid the utilities for 11 months, and complainant did not pay her last month's rent. In regard to the police report that was filed by complainant, an investigation was completed and no charges were brought forth. Respondent states respondent regrets the series of unfortunate events but does not feel like respondent acted unethically or unlawfully. Complainant submitted an additional response stating respondent is not being forthcoming about the facts and respondent's answer is contradictory. It appears the lease agreement was from April 1st, 2013 through April 1st, 2014. Further appears from a conversation between the parties that complainant's items were removed from the property the morning of April 1st, 2014, and respondent told complainant that complainant could contact the landlord to arrange a pickup of the items and return of keys because respondent was out of town. A police report was filed by complainant on April 4th for theft of property, and a supplemental report was filed. Respondent also submitted a response to a demand letter from respondent's attorney to complainant's attorney. Complainant and respondent are negotiating a settlement agreement, but civil litigation has not been filed as previously suggested. Recommendation is for a consent order with a civil penalty in the amount of $500 for violation of TCA 6213-312B14 and 6213-4031, plus attendance at one regularly scheduled meeting of the Commission within 180 days of respondent's execution of consent order.
Do I have a motion?
Move to accept that recommendation.
Do I have a second?
I'll second for purposes of discussion.
Okay.
So, what does council think this licensee respondent did? Where was the violation?
Well, I was under the impression, and you can correct me if you feel differently, that she was allowed to stay there until the end of the day on the last day of the property that she was renting, and it appears that they allowed this person to move their things in before the end of that day. Does that make sense? That's what I thought.
Your rationale is a respondent gave access to property that she didn't have the right to give access to.
Right, correct. Not yet. It was a little early.
Okay.
Any other discussion? Have a motion to approve council's recommendation and a second. All those in favor vote aye.
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 Opposed? Motion carries. Pass. Okay, I'm sorry. 4 ayes and 1 pass.
Item 22, 2014018591, a complaint was filed against respondent for potential unlicensed activity. TREC received information stating that respondent would be featured on a television show for flipping houses. The advertisements state that respondent has been flipping Nashville homes for 5 years and has closed on 200+ deals. The advertisement states that respondent wants to educate others on what works and what doesn't work in real life, and the television program will show what respondent does day to day. A news article was also submitted that states that some home buyers who purchased these flipped homes have had problems with the renovated work. This complaint was sent for investigation, which yielded the following information. 2 homeowners have filed a civil lawsuit due to poor workmanship on their home renovations. The litigation is at a standstill because respondent filed bankruptcy. Further, in respondent's statement to the investigator, respondent states that respondent owns a company which purchases, renovates, and sells homes. Respondent states there is nothing illegal regarding the business, and respondent has a great reputation regarding the quality of respondent's homes. Respondent further states that all sales are handled by licensed real estate agents. Office of Legal Counsel reviewed the documentation obtained by the investigator. It appears that respondent's company is an LLC and respondent is the sole member. Respondent's firm's Facebook page contained one listing, which included the address, the name of the listing agent, phone number, and MLS number for the listing. The listing agent is a licensed affiliate broker. Information was obtained regarding multiple properties, including their transaction documents, most of which utilized licensed brokers. There are 3 transactions identified where seller, respondent's LLC, did not use an agent. Further, there is also 1 transaction identified where buyer, respondent's LLC, did not use an agent. Further, respondent identified additional properties that were bought, renovated, and sold through the LLC but did not provide transaction documents. Under the law, an LLC is not exempt pursuant to TCA 6213-104A1A or F. Recommendation is consent order with a civil penalty in the amount of $1,000 in violation of TCA 6213-301 for unlicensed activity, referencing TCA 6213-102-4A and 6213-103. Said order to also include order to cease and desist all unlicensed activity.
Do I have a motion?
What's the maximum penalty per violation?
$1,000.
It's $1,000 per violation per day. Per violation per day.
Were there 4 violations?
That we have transaction documents for.
Say we accept the recommendation but make it $4,000.
Second.
Discussion.
Is there any indication this respondent was accepting commissions? Or was he just
He was
flipping house?
acting as a sole member of the LLC.
But he wasn't collecting a commission from a seller or paying a commission when he
In
sold?
the transactions, the settlement statements did not show commissions other than to the other party's agent. But I think your exemption as defined by the Attorney General's opinion stated that the LLC is not exempt, so the question of commission would essentially be void.
And so basically, the Attorney General's interpretation is that an LLC has to be represented whether it purchases or sells.
Yes.
That's the basis of your recommendation.
Yes.
Okay, I just want to make sure I understand.
Any other discussion? All those in favor?
Aye.
Aye.
Opposed? Motion carries.
Item 23, 2014018691. This complaint alleges that complainant, a nonprofit corporation providing housing, food, and other necessities to persons in need, entered into a contract to convey a parcel of property to respondent by quitclaim deed. However, complainant alleges that respondent never paid complainant the sum of $2,500, nor has respondent conveyed the property back to complainant per the terms of the contract. Complainant alleges that respondent violated TCA 6213-312B 1, 2, and 5. Respondent submitted a response provided via a letter provided to complainant's attorney on August 1st, 2014. Respondent denies violating TCA 6213 312B 1, 2, and 5. Respondent states that respondent met with complainant who was interested in purchasing a home and was interested in selling some of complainant's 14 properties that were owned by complainant's nonprofit and were used to house the homeless. Respondent further states the complainant does not claim income when filing taxes, and respondent stated that complainant would need proof of income for at least 24 months to qualify for a mortgage. Respondent states that all of the properties, respondent could likely get an investor to purchase 3 of the properties in question, one of which is the subject of the complaint. Respondent then suggested a joint venture effort with clearly defined financial expectations, and the idea was to quitclaim deed the properties so respondent could apply for a home improvement loan. Respondent states that upon further review of the properties, taxes were extremely delinquent and some had already been sold at a public tax sale or had been scheduled for sale. But complainant claims that taxes are exempt and this was an error. Respondent states that respondent deeded the subject property back to complainant. Respondent states that complainant has contacted respondent's peers and clients and complained to complainant's principal broker who released respondent, which was caused respondent financial harm. Office of Legal Counsel reviewed the file and performed additional research. The purchase and sale agreement was executed by respondent as buyer for a purchase price of $2,500 with a closing date of February 15, 2014. The special stipulations state that complainant will execute a quitclaim deed to respondent. If respondent does not close on or before the projected closing date, respondent shall quitclaim the property back to complainant without delay. The agreement was accepted by complainant on or about January 16, 2014. It appears that a quitclaim deed conveying the property to respondent was filed on January 16, 2014, and a quitclaim deed conveying the property back to complainant was entered July 29, 2014. Further, the purchase and sale agreement does not include information regarding listing, selling, or independent licensees, and there were no personal interest disclosures in the file. Recommendation is for a consent order for $1,000 for violations of TCA 6213 312B 14 and 6213 4037A, plus attendance at one entire regularly scheduled meeting of the Commission within 180 days of execution of the order.
Do I have a motion?
Accept council's recommendation.
Do I have a second?
I'll second it, but I have a question. I'm confused by this. So the respondent was getting the complainant to quitclaim property to the respondent so that he can go get a loan, and if he can't get a loan, then he quitclaims it back at some point. Well, so all that occurred, right? Is council's recommendation based on the fact that there were not adequate disclosures?
Yes.
That's the basis of your...
Yes.
Self-dealing?
Yes.
Okay.
That's what
I just thought...
But was the respondent the buyer?
Yes.
So I don't understand how 7A applies, because it seems like he wasn't acting on behalf of an immediate family or other individual, organization, or business entity in which he had a personal interest.
Hold on, we're drawing our attention to Rule 1262.11.
Which one, Kim?
1260-02-.11, the personal interest rule. I can read it if I need to.
See, even in that case, it appears to me that everybody knew who everybody was. It wasn't like anybody was trying to hide anything. So while we're talking, the complainant says the property was quitclaimed to the respondent, but the respondent never quitclaimed it back.
Correct.
But I thought we, a moment ago, said that it was quitclaimed and had been quitclaimed back. So maybe that's where I'm confused.
The complainant alleges that he never quitclaimed it back, and when we looked it up, sometime in the process of us processing this, the respondent did go ahead and quitclaim it back.
Seems like 1260-2-.11 subsection 1 seems to apply a situation where somebody lists a property for sale with a broker, and then that broker buys it himself, or through some other person buys it himself. But this doesn't look like something that was listed for sale by the respondent and then the respondent bought it. It just looks like the complainant sold it to the respondent and then had some kind of deal where the respondent was going to deed it back, which I'm kind of a little confused about, but I don't know if it really matters. Ultimately, the respondent did deed it back.
I know I've seconded the motion that we're discussing right now, but I don't see the harm again at this point. Complainant is whole in kind of a shady deal to start with that the complainant was complicit in.
Or bank fraud.
Make a substitute motion to dismiss.
Off the question.
All those in favor of the substitute motion to dismiss, say aye.
Aye.
Opposed? Okay, case is dismissed.
Okay. Item 24, 2014018761. Trek opened a complaint against respondent principal broker for failure to supervise previous respondent affiliate broker in case 2014018691. Respondent was affiliate broker supervising agent from January 29th, 2013 through July 28th, 2014, and was the principal broker during the subject transaction. Respondent states that respondent had no knowledge of any transaction between affiliate broker and previous complainant until receipt of a letter from previous complainant's attorney, and respondent promptly released affiliate broker. Recommendation is for a letter of warning for TCA 6213-312B15 for failure to supervise. However, you guys might feel differently now that we have a different.
Do I have a
I
motion?
think I feel worse about this one.
Yeah, no, I think it really is clear he did fail to supervise.
He didn't know about it until he
I
got
know
a
he
letter
admits
from
he
the
didn't know
attorney.
about it, which is failure to supervise. However, the mitigating factor is as soon as he found out about it, he released the licensee. So I'll move that we adopt council's recommendation.
Do I have a second?
What did you say?
Council's recommendation. Letter of warning.
I'll second.
Reluctantly, is that how I took that?
Yeah, I kind of want to hit him with some money.
Well, do it, man.
I'll second it, and then I'll submit a substitute motion to do a consent order for $500 for violation of 6213-312B15 for failure to supervise, plus attendance at one entire regularly scheduled meeting of the commission within 180 days of the execution of the consent order.
Do I have a second?
I'll second it.
Okay, do we have discussion?
We might need to get specifics on which acts we're saying this person is failing to supervise since the previous matter we dismissed, just so that I can be clear when I'm
Self-dealing that he failed to supervise.
Well, it seems like he's got a person out engaging in this transaction, and he doesn't even know it's happening until he gets a letter from an attorney later on.
Well, he dismissed it as soon as he found that out, didn't he?
Still not really doing much supervision, it doesn't sound like.
Something like that happens. Sometimes you don't know it.
I think it's just a little confusing because in the previous matter, we didn't really get the person for a violation of self-dealing, so I don't know. There were no brokers on the purchase and sale agreements. They were just buyer and seller. No commissions paid to any brokers. So who is he supervising at that point?
he was engaged in activities that required a license, likely.
Not the brokers.
Well, but the broker's role is to supervise those agents that may be or may be not doing what they're supposed to be.
They said as soon as you found out about him, you let him go.
And I'm all for a vote because I'm real easy on this one. I'm just going for the majority, whatever it is.
I'll withdraw the substitute motion.
I'm making a motion to dismiss.
That puts us back at the original motion, which was to accept council's recommendation.
Speak it into the microphone there, Grover.
Oh, I was looking at you. I make a motion with supplemental motion to dismiss it.
You'll have a second.
Second.
Now discussion.
Call for the question.
We have a motion to dismiss. All those in favor say aye.
Aye.
Opposed?
No. Passes.
No.
Passed. How'd you vote?
I voted no.
Roll call, please, Ms. Maxwell, just for the heck of it. We hadn't had one of those in a while.
Do you want me to ruffle?
You can do it without
She's
getting that sheet
completely out of sheet.
No, I have to have my sheet. I got new sheets. I just ran some new ones off.
Favor, 3 against.
Okay.
Yeah. So now we're back to the original motion
Call for the question.
of a letter of warning for failure to supervise. All those in favor say aye.
Aye.
Opposed?
Case closed.
Okay, you gonna let it go, Austin?
Let me dismiss these people.
I'm gonna let Jenica take over. for a
One
little
just second.
bit.
Yeah. So, it's my sense that these attendees have probably spent enough time in here today because we skipped an hour and a half of lunch. Is there an objection from commissioners that if they want to leave, let them leave at this point? I'm surprised anybody would want to go, but they might.
They're loving this. I don't know
You
why
want a
anybody
motion
would
on
leave.
that?
No, we don't need a motion, but let me advise you, you've got to sign
Can we leave
out.
too?
Don't leave without signing out, or this whole day has been a waste. Or maybe, I mean, at least from the requirements that you're supposed to be here.
Oh, it is.
And please do it as quietly as you can.
Hey, we're on
let's take
Central
a
Time. You said you were gonna leave at 4.
Just to be here at 9.
9 o'clock tomorrow morning, don't be late.
Sign in.
Hey,
We're-
you're on Eastern Time. You said 4 o'clock when you let them go.
Yeah.
We'll
be done.
Give 10 minutes.
We do that. We'd be done by noon.
She has to be quiet.
Are we ready, Kimberly? Okay, ladies.
Jenica's got it, right?
Yes, I guess so. She does sound excited. I'm gonna try. Number 25, 201400187881, and 26, 2014018801. This complaint alleges that respondent one's sign violates the current statute TCA 6213-310. At the time of the complaint, respondent one was an affiliate broker. The licensee name font size is larger than the smallest font in the firm name on the sign. The legal file contains documentation in the form of a picture to prove this allegation. Trek opened a complaint against respondent 2, who was respondent 1's principal broker during the subject violation. Respondent sent a response to the complaint apologizing for his signage and stating that it was not Respondent 1's intention to not follow proper sign standards. Respondent 1 admits that the first letter of Respondent 1's first and last name is larger than the company name. Respondents state that the reason this had not already been corrected is due to Respondent 1 leaving the real estate company to open Respondent 1's own brokerage. Because of this, Respondent 1 is having to redo all of his signage. Respondent 1 states that Respondent has approved new signage and a solution to the subject sign and has expedited the install, so this is corrected. For Respondent 1, consent order for $250 for violations of TCA 6213-312B14 and 6213-310B, plus attendance at one regularly scheduled meeting of the commission within 180 days of execution of the consent order. And for Respondent 2, consent order for $250 in violation of TCA 6213-312B14 and Rule 1260-02-.122B stating that all advertising shall be under the direct supervision of the principal broker plus attendance at one regularly scheduled meeting of the commission within 180 days of execution of the consent order.
Do I have a motion? Do I have a second?
Second, but I have a question. Did we get a response from respondent two?
Yeah, they sent a joint response together. They both signed the one response. That happens pretty often, that they come together like that.
How many signs were there?
We only saw a picture of one. There was only one in the file. The picture.
So the maximum we could go.
1,000. Normally this is something that you guys do agreed citations on, but because of the time frame in switching admin and track, they weren't offered the agreed citation. That's why we put the amount the way it is.
The amounts in a typical agreed citation.
That would be the typical agreed citation amount. Is that correct, Eve?
They went up on October the 1st.
What would they be?
I believe it starts at 500 for
Okay.
advertising and goes 500
Sorry.
to
We weren't
aware
of that. I wasn't aware of that either.
All the fines were doubled.
They
Okay.
go from 500, 750, 1,000. I have one here. but-
Substitute motion to accept council's recommendation, but increase both dollar amounts to 500.
Second.
How much, Austin?
500.
Second.
Yep.
All in favor?
Aye.
Opposed? Motion passes.
Number 272014011891. The complaint was opened against respondent principal broker for failure to supervise two unlicensed agents. The complaint alleges that respondent's website indicates that two agents offer real estate services, yet they are not licensed with the state of Tennessee as licensees in violation of 6213-301 and 6213-103. Respondent sent a response to the complaint stating that the two agents listed on the website both hold active real estate licenses in a neighboring state. Respondent stated that both of the agents, through an internal co-brokerage agreement with respondent, were working on the property in question. Respondent stated that respondent strives to comply with the local license law in every state in which respondent does business and believe that this was the proper course of action when handling an asset in the state of Tennessee. Respondent stated that if they are handling the situation incorrectly, respondent apologizes and seeks commission's input as to how he may modify his actions going forward. Respondent is not principal broker for the out-of-state agents, and it does not appear to legal counsel that the out-of-state agents were compensated or employed by respondent pursuant to TCA 6213-302. Further, it appears that the website where the advertisements occurred is the corporate website and not the respondent's branch website.
Move to dismiss.
Second
that.
Do I have any discussion?
I just have a question, because this one turns me around, so what am I missing?
Last month was the complaint against the two agents. We kind of missed that this one went along with the other one, if that helps you. You authorized consent orders for unlicensed activity for those two agents. Does that help answer the question?
Okay. Any further discussion?
Oh, well, I appreciate that information. So the logical reason to dismiss is that this principal is not the principal broker of those two agents.
Correct. And the advertising was not on his personal website. He's the principal broker of the local firm. They're both in the same corporate company. He's the principal broker of the Tennessee firm, and they're agents in a neighboring state's firm. So they already were, you authorized consent orders last month for unlicensed activity for them. I apologize for not putting that with those two. I missed it, that they went together.
I was having trouble with that one the whole time. Okay.
Call the question.
All in favor?
Aye.
Opposed? Motion carries. Number 28.
Item 28, 2014-019-081. This complaint alleged that complainant had a signed occupancy agreement for buyers to pay rent while awaiting the closing on a home. The buyer allegedly paid the first month's rent, then provided a second check for the remainder of rent at closing for $1,421. After the check was provided, the buyer canceled the check, causing it to bounce. Complainant states that buyer did so because the term of the initial sales agreement were not met. However, complainant alleges there was a second sales agreement signed, as the house did not appraise for the agreed-upon amount. Complainant alleges that complainant was never provided a copy of this document, even though it was requested. The house closed at the lower amount. Complainant alleges that respondent and principal broker refused to release the documents to either complainant or complainant's attorney, and respondent has not returned complainant's calls or emails. Respondent sent a response to the complaint stating that respondent represented the complainant, seller, in this transaction. Complainant returned from deployment and the house was listed via email. Respondent stated they accepted an offer with a temporary occupancy agreement attached. Complainant agreed to pay $2,000 to the buyer for an appliance allowance. The buyer agreed to pay complainant so much rent per day at closing per the agreement. Closing extended due to lending issues and low appraised value. An amendment changing the purchase price to meet the appraised value and extending the closing date was executed. The buyer paid the complainant rent up to that time so complainant could pay the house payment. Respondent stated that when the title company closed on the property, and inadvertently did not include the $2,000 appliance allowance on the HUD, and the buyer caught the mistake after the closing. Respondent states the complainant refused to pay the $2,000, explaining that it was their mistake and complainant was no longer obligated to do so. The buyer stopped payment on their rent check to complainant once they realized complainant had no intention of paying them the $2,000 owed for the appliance allowance. This provided for a difference of $800 owed to the buyer. The listing agent called respondent and asked if the listing agent would split the $800 difference owed to the buyer. Respondent wrote a check to the title company for $400 so the title company could distribute the funds to the buyer. Respondent stated that despite complainant's allegations, respondent was provided a copy of all documents via email. According to the legal file, the contract was accepted by the buyer on January 17, 2014 and forwarded to respondent on January 18, 2014. It appears that respondent forwarded it to complainant seller on January 18, 2014. The amendment to the agreement was sent to the complainant on April 2, 2014. The recommendation is to dismiss.
You'll have a motion.
Move to dismiss.
Second.
Discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 29, 2014019091, Trek filed a complaint against respondent principal broker for failure to supervise the respondent agent from the previous case number 2014019081. That's okay. I was just getting fast with my reading.
Any discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Item 30, 2014020481, this complaint was filed by the buyer of a property and alleged that respondent owner agent vandalized property and committed theft of utility services and left the buyers to take the fall. Complainant stated that after their offer was accepted, they ordered an inspection. Complainant's agent told complainant that respondent had refused to have the utilities turned on for the inspection and asked that complainant turn them on in complainant's own name, even though complainant had not yet purchased the property. After about a week, complainant was informed that the utilities were on and a meter box had been installed on the property so that inspection took place shortly thereafter. At the walkthrough, the needed repairs appeared to be in working order. Complainant closed on the property and approximately 4 days later put in a request for services. It was at this time that complainant was informed that the utilities were turned on illegally and that it would be reported to the theft division to report theft of services. Complainant informed them that complainant had just purchased the property and that respondent seller had the utilities turned on. The text said that there had been no prior order placed for services at that address since January 2014. The tech performed the inspection anyway and noticed that there was extensive damage to the entrance cable mast. The wires had been tampered with and were badly burned. They also determined the meter box was stolen. Complainant alleged complainant informed respondent of these issues and asked why they were not disclosed prior to closing. Complainant alleges that respondent took no responsibility for the issues presented. Complainant also contacted respondent's broker to report the problem, who encouraged respondent to make restitution. Respondent's broker also stated that the house passed inspection and any damage discovered thereafter is the buyer's responsibility. This delayed complainant's move-in date.
Have a motion and a second to dismiss. Is there any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 31, 2014-020511, Trek filed a complaint against respondent, principal broker, for failure to supervise the respondent agent from the previous case number 2014-02048.
I have a motion to dismiss by Commissioner McMullen and seconded by Commissioner, or did I get that backwards? Commissioner Collins made the motion, Commissioner McMullen second. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 32, 2014-020571, complainant, a licensed affiliate, received information from a law firm in Illinois that someone at respondent's company was representing himself as complainant and using complainant's license number and trying to perpetuate a real estate scam on a client of the Illinois attorney who sent paperwork his client received and signed. Complainant emailed the commission office.
Motion to accept council's recommendation.
Second.
I have a motion and a second to accept council's recommendation. Do I have any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 33, 2014-020651, complainant states that respondent, affiliate broker, assisted complainant in submitting 2 offers to purchase properties, both of which fell through. Complainant alleges that complainant was unaware that complainant executed an exclusive buyer representation agreement for a term of March 6, 2014 through June 30th, 2014, when executing the first offer, stating that respondent never mentioned the document and complainant had no further contact with respondent after the deals fell through. Respondent contacted complainant on or about May 27th, inquiring about a home complainant had under contract and stating that the buyer representation agreement provides for complainant to pay respondent a 3% commission. The document is electronically signed and each page is initialed. Complainant consulted an attorney and paid respondent's firm a sum of $3,000, and the buyer representation agreement was mutually canceled on July 29th. Respondent states that respondent presented complainant with the TAR documents, working with a real estate professional, and an explanation of terms to explain the roles and duties of an agent. Respondent also acknowledges that complainant signed the last page of the buyer representation agreement and initialed every page. Respondent also states that complainant signed a confirmation of agency status indicating representation.
Motion to accept council's recommendation.
I have a motion and a second to dismiss. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 34, 2014-020661, Trek opened a complaint against respondent principal broker.
Motion to accept council's recommendation.
Motion to dismiss by Commissioner Collins, seconded by Commissioner McMullen. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 35, 2014-0020-691, complainant works for an insurance company and states that respondent posted on social media accounts that are used to promote respondent's business that consumers should not use complainant's insurance firm because federal charges were brought against complainant for stealing. Complainant states that there is zero truth to the statement. Complainant states that this is a malicious attempt to harm complainant's business, is unprofessional and unethical. Complainant alleges that respondent has violated the Code of Ethics and Standards of Practice of the National Association of Realtors. Complainant has also filed a complaint with the local chapter of the Association of Realtors. Respondent states that the social media posts do not mention complainant's name or company name, were not directed at complainant, and complainant also posted on social media in response. Respondent states that respondent found out later that complainant was involved in a lawsuit similar to the one respondent read about and posted about. Respondent states the post was meant to protect respondent's clients but was deleted in order to avoid hurting anyone's business. Recommendation to dismiss.
So move.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner Hills. I think beat you that time, Commissioner Collins. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries.
Item 36, 2014-0020-711, Trek opened a complaint against respondent principal broker for failure to supervise previous respondent, case number 2014-020691. Respondent states that affiliate broker had been employed at respondent's...
Excuse me, motion to dismiss.
Any discussion? All those in favor say aye.
Aye.
Motion carries.
Item 37, 2014-020721. A complaint was filed against respondent stating that respondent has been operating on an expired license since April 9th, 2014. Complainant states that respondent closed on 24 properties during the time period in which respondent's license was expired. Respondent states that respondent spoke with Trek on August 19th, 2014, emailed the executed forms, and overnighted the original forms with the $1,000 reinstatement check to Trek. That rhymes. Respondent states that respondent confirmed on August 20th receipt of the forms and received an email on August 21st stating that respondent's license was reinstated. Respondent states that the lapse was an oversight and did not realize the renewal had not been paid until respondent's firm's owner notified respondent. Respondent included copies of transactions completed between April 9th, 2014 and July 22nd, 2014. Recommendations for a consent order with a civil penalty in the amount of $250 for unlicensed activity in violation of TCA 6213-1024A, 6213-103, 6213-301, and 6213-312B14, plus attendance at one entire regularly scheduled meeting of the Commission within 180 days of execution of order.
Do I have a motion?
Before, I'd like to make a motion, but first, can you tell me how many transactions he proved or she documented during that period of time?
Well, the complainant says 24. I have to admit that I did not count each one.
You think it's close to 24?
We can look in the file if you want. You
Okay.
could. Well, if you want to make a motion for an amount for each transaction, you can just say an amount for each transaction we have documentation of, and then we can count them later and add it up if you want. If you trust us to count them, or if you want me to get the file, I can check right now and see.
First of all, we trust you to count them. That's not the issue, okay?
Feeling pretty good about that.
Yeah. Has this fine increased? Well,
It's a
this
500.
Well, this is before that.
Ms. Maxwell, is this one of the ones that the fines increased on?
asking me that, or if you just decided he didn't want to know the answer to that.
He was just pondering out loud.
No, that's what I kinda wondered, he was pondering out loud.
What are you speaking about?
Why did you not, in making that recommendation, consider each?
Wanted to give us something to work on.
I mean, you're certainly welcome to do that. I don't make that recommendation because a lot of times I don't like to make the
Microphone.
We spend 1,000.
We forgot another part of this. This is probably going to help answer your question. I think there's a little bit of a gray area when these things happen because things get backdated. So technically things may occur, and then when they apply, Eve, you might be able to explain that better. It gets backdated.
So, well, not, when someone applies to reinstate their license is reinstated back to their original expiration date. So it's as if it didn't expire, as it were. And, so if your license expired April the 4th of 2014, and once you reinstated, then once again, that was your expiration date, and you have a license in the future then until April the 4th of 2016. So it depends on how the commission wants to view that time frame, because really what they're doing is they're going back and being put in a place as if it never expired.
But they didn't have a license from April 9th to August 19th.
Right. The question,
That's correct.
and sort of the question then is, when you reinstate and you go back to the date that your license expired, and so it's as if it never expired. So if you looked at the cover, the front page of your file, you would not know that you had ever had anything other than your license just keep on this 2-year cycle. because there's nothing that would indicate that it expired. Now, we can go in the history and we see it, but you just looking at it would not see that happened, because you're put back in the place where you would be as if you had paid your renewal fee on time.
That's only if I then correct it.
Well, if
It
you
won't
read,
show, it would show expired, would
but what I mean is when you reinstate, that's
When I
part of the
reinstate,
penalty
yeah.
fee that you pay. Otherwise, you could retest and reapply. But when you pay that penalty fee, you're paying to reinstate your license. Now, there remains a question: does that correct those things that occurred during that time? And that's a question that the commission's really never directly addressed. Is that particular
That period
question?
of time that you're talking about, that they went back and got their license
Right.
reinstated, is that the time we're talking about?
Right. So those like 8 months or not, whatever that time frame is.
Reinstated?
Which isn't probably
ground.
another reason why
That's
the
true.
suggested penalty was low, is because it is a gray area. I mean, you can say that they were unlicensed during this time period when they were closing on these properties, but then when they reinstate their license, it gets backdated to their expiration date. So some might see it as, well,
They're unlicensed.
But the thing
That's
is,
how
once you,
my-
yeah, and you're right. So for that 8 month period of time, you were unlicensed. But when you reinstate, your license is put back and covers that period of time during which it was expired. So it would appear that it was not ever expired. So the question would be, does the mere fact that you reinstated and your license went back to that original date it would have expired, does that overcome anything that any violation that you might have committed during that time when you were expired before you reinstated? And that's a question that, as I say, the commission's never really directly addressed, and it's a gray area. I think it's a
Just like the E&O, we reinstate it.
and you're back as if you never were expired. So it's
Yeah,
just
but then they're not going to cover you, because if you
When she
expired,
backdates it-
it's only going to go back if
But
you ever make a claim.
But when she reinstates you, when Rice or any insurance company reinstates you, they're reinstating people back to 1/1. So you are covered during that time frame. Now, granted, you made a representation to the insurance company in that instance that you don't think you have any claims that have filed or going to be filed against you. But as I say, it's just one of those questions that there is a gray area, and it would be up to the commission to determine if they wanted to do something, but it would affect everyone who reinstates. I mean, I think it would have to affect everyone who reinstates their license.
Well, as long as they don't do anything wrong.
Right, but we never asked the question, have you been practicing real estate? Like one of the questions for reinstatement is not, have you been practicing during this time frame? And that's a question that just isn't like when the commission is supposed to say. The commission didn't used to ask that of people when they would appear for reinstatement. And as I say, it's something that the commission needs to decide. And
Has this person not already had to attend a commission meeting as part of their reinstatement?
they would have had to either attend a meeting or they would have had a medical waiver, or it would be a firm. I mean, because you're going to have to attend. Someone's expired this long,
reinstated.
you're going to have to attend. You're going to have to do all the conditions precedent, which is, sign a consent order, pay the money, and attend the meeting. You have to do all of those things prior to being put back in that reinstatement. That's why people who are grandfathered are really a lot of people who reinstate.
If we accepted their money for reinstatement,
Because you think we're forgiving them for,
yeah.
I mean, it's a commission's decision. As I
Looks
say,
like
that's
that's
just
what it
kind of the conundrum that's existed and,
Pay for a fine, you can't charge somebody for a fine that they've already paid for.
I mean, I don't know. I know that it is a,
I know it sounds awful, but
That's what reinstatement means.
I agree.
I mean, you put them back where they were.
Well, and I don't understand how we could fine them for unlicensed activity if we're saying they weren't unlicensed.
They were licensed.
Because they were reinstated.
So what if they didn't?
Then there would
And
be
we get
unlicensed, then there would be
that-
unlicensed
Right.
activity.
I mean, and up until the point they reinstate, they are, They are engaged in unlicensed activity, but once they reinstate it, it is kind of a hard concept. I mean, yeah, it is.
But it's, I mean, the statute, this is the statute, right? 6213-319.
After you fail your pay renewal, right?
Yeah, so I mean, the statute says.
Like getting forgiveness instead of permission. That's what I'm saying. I mean, they got forgiveness instead of permission. So where are we?
Second.
Any other discussion? All those in favor say aye.
Aye.
Opposed? No. 4 ayes and 1 no. Motion carries.
Sorry. Item 38, 2014020731. TREC opened a complaint against respondent principal broker for failure to supervise previous respondent in case number 2014020721. Respondent states that TREC sent 2 letters notifying affiliate broker that additional CE credits were needed prior to license renewal, and affiliate broker told respondent that they were in progress. Respondent states that affiliate broker completed CE courses by February 2014 in anticipation of the April 2014 renewal. Respondent states that no additional correspondence was received by TREC regarding affiliate broker's renewal. Respondent states that licenses are on display by the office door and nobody noticed the expiration date on affiliate broker's license, and it was an unintentional mistake. Respondent states that affiliate broker's work is overseen by respondent and the owners of the company, and apologizes for missing the renewal date and intends to enter expiration dates for all licenses and E&O insurance on the master calendar in an effort to prevent any similar occurrence. Recommendation was for a consent order with a civil penalty in the amount of $250 for failure to supervise in violation of TCA 6213 312B15 plus attendance at 1 entire regularly scheduled meeting of the commission within 180 days of respondent's execution of the order.
What's your pleasure?
Move to accept council's recommendation.
Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Number 39.
And just to clarify on that, are we going on failure to supervise because they weren't paying attention to when their person's license expired? That was not really.
I guess we could do it per day. 6
True,
months.
that's true. You could do that.
Action.
Yeah.
Okay, I just wanted to clarify that's where your heads were. Okay.
I think they'll write the check for $250.
Quickly.
Yes.
I would if I was in their shoes.
Yeah.
Item 39, 2014020831. Complaint was filed by a buyer alleging that respondent, affiliate broker, and listing agent intentionally and fraudulently misrepresented information and failed to disclose adverse facts to complainant regarding the condition of the home as follows. The home was listed as 15 years old, but was built in 1992. The home was listed as city sewer, but is on a septic tank. All rooms stated heat and air, but the bonus room does not heat. Roof is listed as being replaced 3 years ago, but has already needed repairs for leaks. Complainant further states that only the air conditioning units were inspected and not the entire HVAC, and the windows were painted shut. Complainant states that complainant has suffered damages in approximately $3,500 for repairs and attorney's fees. Respondent states that with regard to the age of the home, the property disclosure, which states the home is 15 years old, is a product of the seller, but the MLS clearly states that the home was built in 1992. With regard to the claim of city sewer, respondent used the information provided to respondent by sellers to list the home. Respondent further states that seller reported on the property disclosure that all rooms had heat and air, and this was not reported in the home inspection. Seller reported that the roof was replaced 3 years ago, and that it was a 50-year shingle roof. Respondent further states a request was submitted for an HVAC system check and to provide a receipt to complainant as requested. Respondent states that the firm reported coils were cleaned and operations were checked for both systems. Respondent states that respondent provided information as submitted by the seller in the property disclosure, and agents are not authorized to make any changes to the document. Respondent states that complainant had a home inspection and requested certain repairs by agreement. Recommendation is to dismiss.
It's your pleasure.
To accept recommendation.
Okay, I have a motion and a second to dismiss. Do I have any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Number 40.
Item 40, 2014-020-851. Trek opened a complaint against respondent principal broker for failure to supervise previous respondent in case number 2014-020-831. Respondent submitted materially similar information with regard to the allegations of the complaint. Respondent further states with regard to supervision that respondents holds monthly meetings with agents and has several classes per month to review procedures, forms, etc. Respondent states that affiliate broker teaches other agents regarding the Authentisign program, which was used during this transaction. Respondent further...
Have a motion to dismiss. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Can I just ask a question? The complaints that are opened against the broker, the principal broker, are those opened at the time that you receive the complaint against the
Yes.
affiliate?
Okay. Yes.
That's what the commission's asked us.
Okay. Just
I
verifying
mean,
that
and if
that's
the
when it's
commission would like
opened.
us to do something else, then if you just, we're glad to do whichever. I mean, unless it's filed against the principal broker, obviously is a separate person, but otherwise, everyone that comes in, we open against the principal broker for failure to supervise.
Okay. Thank you.
Item 41, 2014-020-861. Complainants state that a purchase was made with a timeshare company and were told that because they purchased a smaller package, they would not be able to go to the best resorts, but would have a lot to choose from, but their time would not be restricted. Complainants state that they attended a second meeting with respondent.
I'll second that.
Any discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries. Number 42.
42, 2014-020-871. Trek opened a complaint against respondent principal broker for failure to supervise previous respondent.
Second.
I have a motion to dismiss and a second. Any discussion? All those in favor, say aye.
Aye.
Opposed? Motion carries.
Item 43, 2014-021-951. Item 44, 2014-02-1961. Item 45, 2014-02-1981. And item 46, 2014-02-2001. Okay.
Do I have a second? A motion and a second. Any discussion?
I have a question. On the on number 43, 2014-02-1951, there are two that are open right now under review.
Correct.
On that one. For the firm. That's the firm.
Yes.
These are timeshare complaints, and so when
Oh.
we get a timeshare complaint in, it's opened against each of the salespersons who, if they're named, the principal broker of the firm, that's licensed in Tennessee, and then the developer, and and during the summer, some are open during the firm. We don't traditionally open it against the firm. We usually open against the developer themselves. But anyway, so that's why you see those pending, because normally they come in. We get bundles of them from the Attorney General's office, and so they just sort of end up being on the legal report all together.
All right, thank you.
Okay, any other discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Number 47.
Item 47, 2014-02-1231. This complaint was filed by respondent's former principal broker and states that it came to complainant's attention that respondent was accepting money orders, security deposits, or rental payments from tenants and not forwarding the payments to the office.
Motion to accept recommendation for litigation monitoring.
Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Number 48.
Item 48, 2014-02-1281. Complainants requested that respondent cancel their timeshare alleging...
Motion to dismiss.
Motion by Commissioner McMullen and seconded by Commissioner Grease to dismiss. Do I have any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Number 49.
Item 49, 2014021291. A complaint was filed.
Motion was made by Commissioner Collins, seconded by Commissioner McMullen. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Number 50.
Number 50, 2014021671. This complaint alleges unprofessional negligence of respondent and firm. Complainant states that the complainant signed an agreement with respondent to look at houses, but respondent showed them only one house, and that was after complainant had found a builder who would build the house complainant wanted. Complainant did not want the home that respondent showed complainant, so complainant informed respondent that complainant would be going forward with the home builder and would no longer need respondent services. At that time, respondent presented complainant with the buyer's representation agreement, and respondent reacted by sending the complainant more papers to sign. In those papers was an agreement saying complainant would pay the broker.
Is this not a complaint about commission, basically?
I'm sorry, what did you say?
Is this not a complaint about commission? Somebody not getting paid?
I can't remember. Hold on.
It's really a complaint that the complainant is a member of the public who's alleging that the licensee stuck a number of pieces of paper together and that they didn't realize that there was a buyer's rep agreement in there and that they had already told the person that they didn't need them anymore. So there's that issue. The money aside, there's really the complainant is the person who's alleging that this person didn't act in a professional manner. So while there's a question of money, there's just sort of a different issue as well.
Motion to dismiss.
Do I have a second? Motion by Commissioner Collins, seconded by Commissioner McMullen to dismiss. Do I have any discussion?
Does council, do you all have a document that shows
The buyer's representation agreement includes cancellation. Yeah.
All those in favor say aye.
Aye.
Opposed? Motion carries. Number 51.
Item 51, 2014021701. Check filed a complaint against respondent principal broker for failure to supervise the respondent agent from the previous case number 2014021671. Respondent sent a response to the complaint stating that affiliate broker has been an agent since 2012 and has successfully represented 44 clients without a single complaint. Respondent alleges that the complainant's behavior and demands stood in the way of respondent's representation of complainant. Respondent states respondent was never contacted by complainant and asked to forward any message to the affiliate broker. Respondent claims that complainant contracted with affiliate broker on a property and then attempted to cut affiliate broker out of the transaction and deny affiliate broker the commission earned. Respondent stated respondent would not be forced to have agency agreements if it weren't for people like complainant. Respondent stated that when complainant did call the office manager, complainant verbally abused the manager. Respondent stated that complainant sought out affiliate broker services and that affiliate broker represented complainant successfully and the complainant successfully closed on the home complainant wanted. Recommendation is to dismiss.
Do I have a motion?
So moved.
Second.
Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. And we have some special guests just entered the room.
We let them go home early, like the bus was leaving.
How are you guys?
Good. How are you?
I'm awesome. I came down here to introduce you to the new Assistant Commissioner for Regulatory Board.
All right.
And most of you, matter of fact, maybe all of you already know him, Brian McCormack.
Hey, nice
Congratulations.
So,
Thank you.
Welcome aboard.
Brian was previously the Director of Boards and Commissions for the Governor. One day, and I was like, you know what? I think the Real Estate Commission's still down there.
We're going to be here till midnight tonight if you want to stay with us.
We may or may not be.
We worked through lunch.
We worked through lunch. We need a raise.
Yeah, we haven't
we need a
even
raise.
stopped, so we earned our $50 today.
Well, I don't want to make you stay any later. I would, really quick, I would like to, if you guys will go around just real quick and say, Keeling is an attorney, I'll let you go around the room.
Yeah, I think we've met, but I'm Keeling counsel for several. I'm Jenica Smith. I'm the paralegal in reg boards with her and a couple others.
I'm Eve Maxwell. I'm the executive director of the Tennessee Real Estate Commission. Nice to meet you and see you.
Kimberly,
Austin.
Kimberly Smith, back in the back, who is our awesome administrator.
So whose place are you taking, and what can we expect from you?
Grover Collins.
Well, I mean, we all have name tags. up here,
Grover is
Commissioner.
from,
Lewisburg, Tennessee, and I'm a good friend of this mayor here.
I would
Of
not
Oak.
put that on public.
Y'all are.
I think we're taping still, don't we?
Don't record that. I'm Janet DeChara, and I'm from West Tennessee.
John Grease, I've lost my voice pretty much, from Knoxville.
Diane Hills from Kingsport.
We have 3 members who are absent today, who did come by phone earlier and join the meeting for about 5 or 6 hours,
Not forever.
really.
Yeah.
So that's Marcia Franks, who's from Middle Tennessee, and Gary Bloom is from Memphis, and Wendell Alexander, who's from Dresden.
So I just wanted to introduce you all to him while you were here in the building and tell you nicely as you've been to me. I really appreciated this commission when this was the very first board that I met in Memphis, actually. Their meeting was scheduled my very first day in Memphis, so I stayed there to meet the Real Estate Commission.
That was special for you.
It was very special for me, and so I appreciate this commission, and he's going to do
Commissioner Giannini, so we have Ms. Hills here, is brand new, and maybe she would like to know what this job description is of both of you, for that matter.
Please.
well.
I really would.
It's mostly all firemen. I mean, you're mostly a fireman now. I didn't tell him that. He's not in fire prevention, but he is a fireman. And so I got promoted to deputy commissioner. They couldn't find anybody else to take it. And so they promoted me to deputy commissioner, and we began looking for a fantastic job with a monumental task of appointing I was gonna say 275, but I thought 200. So, and total board members, that's got to be in the 3,000.
There's about 2,000 or so. Serving.
Okay,
I appreciate that.
You're not going to take any credit, are you? That's extra.
2,000's a lot.
It's a monumental task, and so he has a great knowledge of what we do here. He understands. He has been through, as some of you have been appointed through the process that he oversaw. Has a much better understanding of what regulatory boards does than a lot of assistant commissioners. So we're very fortunate to have him. Attorney, I know, just please be nice to him anyway. So he's going to do great. We're really excited about it, and we couldn't have. I feel like we couldn't have gotten anybody better on our team.
Thank you.
Well, and you're welcome to come and join us anytime you wish. Commissioner Giannini doesn't come visit us very often, so.
Well, when you got what do you say, 13,000 people he's got to supervise? What?
Yeah, but we're special.
Well,
You buy our lunch.
you know what? Yeah. Here's how the main way you can tell is if I'm coming to your meetings is you're causing trouble.
Right.
If you're not causing trouble, I don't come to the meeting much.
So that's why we
stay out
never
of your
see
way.
you,
That's
huh?
right. Y'all are doing such a great job, you didn't need me to come.
Well, we appreciate you coming down and welcome aboard. We're glad to have you.
Nice to meet y'all.
Nice to meet you.
Sorry to interrupt.
Try to stay warm out there.
We're going to. My kids are out of school tomorrow already.
Because it's too cold?
I guess.
Yeah.
Yeah, Grover said they're not hardcore enough around here.
I said we're not pioneers like you
Oh,
are.
pioneers, excuse me.
I haven't heard that.
Yeah.
Because there's no heat.
I thought it was on TV this morning.
Because it's too cold for them to wait for the bus.
To wait for the bus.
2 or 3 little kids turned into snowmen.
Okay, let's move on. Number
Okay.
52.
Item 52, 2014021931, complainant has purchased timeshare points from respondent for multiple years.
Motion to dismiss that.
Any discussion?
I was singing it.
All in favor, say aye. Aye. Opposed? Eve, I'm not sure who you're gonna give the second to on that. I think that was a unanimous second.
It was me. It's clearly me.
It's clearly you. Okay, number 53.
Item 53, 2014021941. Check open to complaint against respondent principal broker for failure to supervise previous respondent.
Motion to dismiss.
Discussion. All in favor, say aye.
Aye.
Opposed? Motion carries.
Item 54, 2014022401. This complaint alleges that respondent sent a form letter to everyone in the neighborhood on Realty Company letterhead telling them how to appeal their property taxes and supplied them with the comparative market analysis. Complainant alleges that respondent crossed into the role of an appraiser when respondent offered appraisal review services and gave specific appraisals for properties based on square footage. Complainant alleges it is totally within respondent's right to offer a CMA, but when respondent interpreted these sales and used them to arrive at a certain value for specific property, respondent assumed the role of an appraiser. Complainant works for the tax assessor's office. Respondent sent a response to the complaint stating that respondent did send a form letter to respondent's subdivision, as respondent does multiple times each year with real estate updates that respondent feels are helpful, informative, and beneficial to the community. Respondent stated that the appraised values used were incorrect, as proven by the $48,400 reduction in property value for tax assessment purposes respondent received, with no explanation of why. Respondent denies offering appraisal services as respondent is not an appraiser. Respondent offered a free CMA, which is within the scope of her professional services and abilities. Respondent stated that in May 2014, respondent received a postcard from the county tax assessor's office notifying respondent of the appraised value on respondent's residence for property tax purposes had changed. Since the new value was such a sufficient increase from the previous year with no changes to the property, respondent was compelled to appeal the unreasonable increase. Respondent was instructed to fill out a CMA from a licensed realtor and bring it to the tax assessor for review, which respondent did. Respondent stated that the tax assessor's office asked respondent's opinion on the value of the home and then crossed out the tax assessor's value and replaced it with respondent's. During that week, respondent stated respondent had several neighbors complain about unreasonable increase and asked respondent to prepare a CMA for their
I'd
home.
like to make a motion, we dismiss this, and if they want relief, they need to talk to the county tax assessor and ask them to dismiss the person if they're not happy with them.
Do I have a
I'll
second?
second that.
Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Think this is the last one. We're closing in.
Item 55, 2014022411. Trek filed a complaint against respondent, principal broker, for failure to supervise the respondent agent from the previous case number 2014022401. Respondent sent a response to the complaint stating she discussed the complaint with
Motion to dismiss.
Second.
Any discussion? All those in favor say aye.
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 Grover? Opposed? Motion carries. We are done with the legal report. Do you have anything else to tell us?
You can get her report in the next 5 minutes.
I do not have anything further.
Thank you.
Oh, unless you guys have questions on the consent order log, which I think was provided to you.
I think we're fine.
You have none? We
I
can
think
move along.
everybody's so tired today they couldn't
They
ask
do
a
not want to talk
logical
about consent
question.
orders. One more minute.
I'm glad you sent it to us.
Thank you.
Okay, Ms. Maxwell, complaint report.
Do you want me to just go over what has to be done? This, as in the the education really is the main thing where
Do
people
we have to do a RELO?
We
this
do need
time?
to do a RELO and education, and those are really of the items that are time sensitive. Those really are the time sensitive items. I can send
Okay, let's do.
the other information if you want it, but I can send you the other information. But as I say, the things that really are time sensitive are those two. Because we have people who want to give classes.
Okay, well, let's Hit
So
it.
whichever you prefer to do first, I'm good with.
Well, you've got, under your executive report, Arillo is there, so let's
Yeah.
just get that first.
Okay. So you all have some information on the iPads about the Aurello meetings. And if you remember, we have to write a justification 60 days. It has to be turned in to the administration no later than 60 days prior to the beginning of the meeting. So the upcoming meeting, the mid-year meeting, is in Albuquerque, and it's April the 15th through the 18th. And so we just needed to know who we wanted to go. You know, we have to put real people's names in our little slots before they can be approved. And the administration will only let us submit to 2 commissioners and 2 staff. Well, I mean, we've tried to submit more, but we haven't been successful at that.
Will Julie be back to go to that meeting in April?
I don't know.
As far as we know, she's coming back in February, so. Changes are not.
At yours and hers for staff, I would say.
That's fine. I mean, yeah, if she's, and if she wants to go, I don't know if she'll want to go with a new
With the baby.
I mean,
Just
I
ask
should say,
her.
I should say we can send 4 people, and so I'm not sure she's going to want to go with a new baby. You would know better than I would.
Dying to go.
She might be. Trevor might not like it so much.
She may need a vacation by then.
Oh, no.
Well, probably the best thing to do then is
I'd like to put my name in nomination.
okay, is
I'd like to put Eve Maxwell's name.
is to see who wants to go, and then if Julie doesn't want to go, then the other commissioners, whatever, so that we have 4 people, we can give them 4 names, and so we could do that, and that might be the easiest thing, and you can ask her if
I'll run it by her. I talk
like
to her
to go.
often.
I mean, if you can't go to this one, then if you notice that the annual conference is in DC this time around in September.
So who wants to go to Albuquerque? John.
Okay.
Cleared by schedule.
You cleared your schedule. Diane?
I haven't even looked at my schedule. I could go unless someone else would rather.
So it's April 15th through the 18th, which probably is maybe a Wednesday through a Saturday. Do you know?
It's
Wednesday
tax
through a
day.
Saturday.
Saturday.
But you'll have your taxes, of course, filed by, of course. And so we usually would try to leave on the morning of that Wednesday and then come back either Saturday afternoon or Sunday morning, depending on the schedule, which we.
No requirement we have to travel together or stay the same period of time, is there?
No, there's not a requirement that we have to travel together, but you couldn't fly first class, and take some crazy flight that took all over. Like the state books the airfare.
national parks
Yeah,
or
that's right. You can't take one of those, like Journeys About. But I mean, yeah, you can. We don't have to travel together, and one can stay longer. We just need to know that on the front end. So that when we actually make the reservations, we know that you're extending that out, because otherwise you get stuck with a ticket that doesn't really work out for you.
State has to make the reservation.
The state makes the airline reservations, yes, and yeah.
And Kimberly, is it right that we have to check out after the last day of conference and check back in, or can you separate our hotel bills without having to do that? Yeah, that's what I thought.
But you can you get one extra day for the conference. Usually it kind of overlaps that one Saturday. We just need to know. We don't need to know that today. We just need to know today who wants to go, so that we, as I said, we have to identify people. As you know, we can't just submit it for just somebody. So we just need to know the people's names, and then we'll get the more specifics after it gets approved. We just want to make sure we don't miss the deadline.
Well, let the ones who haven't been before go. I am still serving on the Fair Housing Committee. I'll get it out in a minute. And so I'm always available to go if there's not others.
Okay, so, so would it be your preference or the preference of all the commissioners that I put in John's name, my name, Diane's and Julie's, and then if Julie doesn't want to go, before we even submit it, we'll switch it out with your name?
Or check with Mr. Bloom, since he has not been before, and see if he wants to go.
Okay, because we have to have we have to have a motion that we put in the justification. So that's why, I mean, and you can have like alternates, but, we have to, part of our justification is that now we have to put, a motion in and say that the commission voted to send X, Y, and Z. And
I'll move that the commission request Eve Maxwell, Diane Hills, John Grease, Julie Kropp be approved to travel to the RELO meeting in Albuquerque, with the understanding that if any of those can't make it, first alternate would be Gary Bloom, and if he or someone else can't go, second alternate would be Janet DeCharo. Unless, Austin, do you want to go? You have never been. Okay, second.
Okay.
A good enough motion?
That's
okay.
But it needs
Do I have a second?
Second that.
Any discussion?
I just texted Julie. She's in.
She's in.
She wants to go?
Oh, wow. Yeah, boy, you read
About
those
what?
babies.
But that did not take her. I was not to answer.
She's ready for a vacation.
Let's vote.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Education report, right?
Yep.
Okay, so the education report, it's it's divided into two sections. One section is the just courses that are continuing education courses that were submitted for this month, and then the second part are the core courses. And as you know, some of those core courses, Marcia commented on the ones she looked at. I'm getting the report. That's why I'm trying to get it out of here. And then Gary looked at a course as well. And the larger report, which probably is the easiest one to start on, there were, I reviewed all the courses, and there were, they all looked fine. The instructors who are on there appeared to have the credentials to teach. And then there were two courses, I think, as soon as I find the report here, that, what did I do with the report? That I had on for discussion. One is a karate course, where it's a good course, but they actually do teach karate for the whole time. It is it's a self-defense course. And so I did that. I put that on there because I wasn't sure if that was a course that you all would want to approve for continuing education. I mean, it's a safety course. And then I think I put another one on. As soon as I find my list here, I'll be.
Well, we have
I'll be in
J1 through
business.
7.
No, there's not a cooking course on there.
We have J1 through 7 that is not anything that concerns Ms. Maxwell. Those are the ones.
Those are the
that-
Trek core courses, right? J1 through 7 are the Trek core courses. I don't know why I can't seem to find my
Yes.
thing. So there's one thing that has the core courses on it. That's J1 through 7. Those are just the core courses that were deferred until this month.
J1 through 4.
Trek core.
Oh, they're
Trek
not.
core, Trek core.
Not
One
on
of 'em's
page 1.
core.
Smith and Mold.
Oh, you're on different, that's the report she's looking for, that
I
she
found
can't
it.
find.
I have found it. I have found it. That's because I have the backup upstairs. Well, so there's one report that has that's, let's see, got 8 pages, 9 pages actually, and that's got J1 through J36, with J35 and J36 being for discussion. Do you see that?
Mr. Chairman, I'll move that courses J1 through J34 be approved.
Okay, thank you.
Do I have a second?
Second.
Any discussion?
What about gadgets and gizmos?
That's,
Is
that's.
that legit?
They're not the only people that teach it. It's a course that, it's a hands-on course where you work on the computer and they go through apps and they work on those tools that people, that licensees use in the trade. And it's, actually, I made them give me some more information on it, addition to what they submitted originally. But one of you all may have taken a course like that. It's, teaches the hands-on stuff. But it's
All right.
legit as far as if that's a course that the commission wants to approve for CE. The course has been courses very similar to that have been approved previously, where, as I say, what they do is they do teach the tools that you can use, and it's actually one of them's got this one actually has some pretty cool websites that'll tell you to use, like taking pictures and it, not Photoshop, but teaches you things like that, and building websites. So it's got those skills that licensees use in their everyday work. I wrote down several of the websites actually to go check them out myself.
Which course is that?
That's Gadgets and Gizmos, which is J12.
J12
and then like
J15.
Right. And then J13 is Evernote and the Paperless Agent, which is a little bit similar, but it really stresses Evernote, that program that you have on your computer.
Actually, those are all very good courses for.
So are we including self-defense in the approval too?
Not yet.
Okay.
Just
good.
through 34.
We haven't got to self-defense yet.
Okay.
There are other safety courses that actually that aren't action courses, I should say, I guess, that really go through more of the safety tips that you read online fairly frequently.
Okay, do I have more discussion? All those in favor of approving courses J1 through J34 say aye.
Aye.
Opposed? Motion carries. Ms. Maxwell?
So the two courses, J35 and J36 for discussion. J35, it was a fine course. Really these are on here because I want the commission to know that these courses are out there and to make sure that these are courses that the commission would like to have taught as part of the CE. The Roadmap to Success really is structured sort of like a office broker management course, so it goes through items that one would need to build a successful practice, and it starts with some of those self-motivational things. But then it does go into some nuts and bolts about the organizational tools and how to contact people and the day-to-day sort of activities that you have, and how to manage and organize your life, basically, so that you can have successful business. It is in there because it is more of a touchy-feely course, I guess. I don't know if that's the right description, but it is a little bit more like that than some of the other courses are. So that's why it's in there. As I say, I really just wanted you all to know that those courses are out there and see whether you all want those approved for CE. And then the second one, the Common Self-Defense Program Level 1, is, as I say, it truly is, appears to be a hands-on karate or judo, a martial arts sort of defense course that would teach you in the period of time, 4 hours, would teach you some very basic self-defense mechanisms that you could use if you were confronted or assaulted or taken from behind.
What's the statute that sets out the standard we're supposed to apply?
It's 1260. It's a Rule 1265.
Okay.
Ash 3.
Yeah.
76.
Yeah, there are 17 topics that are listed that the courses are supposed to fall into for continuing education. So that's all. As I say, I don't. I mean, those are whatever the commission would like to do. It's just I wanted you all to know they were out there and make a decision about how you would like those kind of handled.
What's your pleasure, folks?
So, Eve, were you able to determine on the self-defense course that it would actually take 4 hours to do it?
It would take, I mean, I've taken some courses myself like that, not this one, but I have taken them, and they generally run in 3 to 4 hour chunks. And so it appeared that it would take that if you were trying to actually teach the individuals something that they could use and have them then practice those methods on their fellow classmates.
On each other.
That's right. So anyway, it's, if someone would like to look at those, they're welcome to do that as well.
I think we'll wait till the other 3 members.
Grover, would you pull your microphone down and speak into it, please?
Oh, sorry.
Miss
I think we
Kimberly
ought to
can't
wait
get you.
till next month on those 2 courses and let Wendell's input and Gary and Marcia's. But I am glad that you've got that barbecue and the sacred cow in there. I thought that would be a good course.
That title really doesn't do much for one, does it? But the course actually is, the course is actually not, it's a good course, but the name doesn't really, I think it was just something I thought was clever.
Anybody else have any feelings on that, or do we have a motion to that effect, or what we want to do here?
Do you know of any particular urgency on these 2 classes?
I don't think there are on those 2 classes. There were a couple of classes that Memphis, I know, wanted to give, and one that I think was going to be in Upper East Tennessee, correct? That was going to be offered up there.
Oh, that's not one of it's an earlier one.
Right, that's what I meant. That's what I mean. It's not one of those. So the ones that were going to be presented in the next little bit of, like a week to 10 days, are on the big report. So the ones under discussion, as far as we know, there's not a timetable for those to be given. They didn't tell it to us if there was.
I'm happy to defer until next month, but ladies in particular are not trying to be sexist, but what are your thoughts on that J36? Is that something that...
I'm like Eve, I've actually taken one of those courses as well, and even though I came out pretty battered and bruised, it was a very good course. I mean, because not all of us have a gun in our hand when something like that happens.
Did you get continuing education credit for it?
I did not. I just took it for the practical purposes.
That's really the question. It's not, because they do look like they're good courses. It's really a question of whether it falls within the rule and whether the commission deems that it's, the type of course that they want to give continuing education credit for.
On the tab already.
I don't remember.
Is there a motion?
You want me to put one on the floor?
Yeah,
we
go
don't
ahead.
have a motion on the
I'll
floor.
move that we defer J35 and 36 till next month.
Do I have a second?
Second.
All in favor?
Aye.
All right,
Thank
we're
you,
gonna
Grover.
move those to next month.
So that leaves the core courses, and as you know, I had asked several of you to review the courses, and Gary and Marcia both sent information about their review, and Grover, I know, talked to Kimberly Wright. So I don't know whether you've had an opportunity to read what Gary and Marcia wrote, or whether you would you want to decide those, you want to read that, you would rather, Marcia's probably a better advocate for what she wrote herself than my reading the email, which I'm happy to do. It is, the person whose course she reviewed is a person who's called here and asked about her courses. So I don't, as I say, I don't really know how the commission would like to handle that.
I read it, but Now I'm trying to think. Is it a copy here for me
Yeah, there should be a copy.
of what Marcia and
Right,
and
there should be
Gary's-
Marcia and Gary's both scanned in there.
Well, Gary's doesn't really say whether he recommends
It does not, you're right,
approval of that course or not.
right.
Well, I recommended mine.
And yours was a classroom course. So it was everyone else that had a paper and pencil course. And what we did was we looked at the core courses and we tried to send them to the commissioners who did not live in the area and we hoped did not know the person who had submitted the course. So like we sent Diane one from Middle Tennessee and from maybe Chattanooga, I think, and then we sent Gary one from East Tennessee, and Marcia had one from West Tennessee, and Janet had one from East Tennessee as well, and then Grover had one from Middle Tennessee. So we tried to send courses that the commissioner who was reviewing them would not know the person.
Well, here's my question. So, on let's say Gary's and Marcia's, I mean, it looks to me like their comments are basically recommendations that if the course incorporated their comments, they would find it satisfactory. I may be misinterpreting that, but it's kind of how I see it. It's similar to what Diane's review was.
Right, I don't know about
Marcia's don't really sound like a recommendation.
It doesn't to me either. Gary's, I think that's probably right. Marcia's, I'm not really sure that hers is a recommendation. And that's the hard thing is I think she, as I say, probably is better equipped to really discuss her own opinion about that than.
Let's pull hers out. I mean, she's.
I think unless there's a different way to get this handled.
Yeah, I don't know. As I say, it happens that this person is one of the people who's called and asked about their course, but I really do feel like Marcia, I mean, it looks as if that Marcia took a lot of time to go through it, and I mean, as I say, it's the commission's decision. I don't know if reading this into the record would be that helpful.
Would it be out of order if we did it and until you were able to? I mean, till you were able to speak with Marcia and we would defer to hers to.
I'll have to defer that course.
Yeah, I think that she needs to talk. If she's going to talk about it, she probably needs to talk on the record and I mean, just have an opportunity to, I guess, further embellish what she wrote. Anyway, so as I say, it's the commission's decision on how to handle that, and Grover thought his was fine, and I don't know what you thought about the one you had.
I'd move that we approve course Grover reviewed without even having any knowledge of which course.
That was J1. I'm sorry. So he read through J1, which is Brent Maybank's Trek Core. It's on that second smaller. It's just on the smaller report.
Report.
I reported on J2.
Just for purposes, keep this moving. I'll move that we approve J1.
Second.
Any discussion? Grover, do you have anything to add to that? All those in favor say aye.
Aye.
Opposed? Okay. J1 is approved.
We have previously conditionally approved J2, correct?
Yep.
Yes.
J3 is Marcia's. Do I have a motion to defer?
Yep.
Second?
Second.
All in favor of deferring Marcia's?
Aye.
Aye.
Opposed? Okay, J3 has been deferred. J4 is yours,
Yes.
Diane?
Uh-huh. Yes.
Oh, okay.
I would approve.
She's so smart, she gets two.
I didn't, I'm not a fan of true, false, all true, false, all true, false, but the material was, all right.
Well, and I think that if the commission, in the future wants to give more,
Okay.
put some other guidelines down, then I think that would be, that would be something that you all might consider if you wanted to do that.
But I thought the material was there and in good order.
Okay, do I have a motion? Second? All in favor of approving J4, say aye.
Aye.
Opposed? Motion carries. J5 is the one I have. It has quite a bit of incorrect information in it. It also is using a TAR sales contract as their basis for the contract part of it. It is an old contract. It doesn't have TAR's name on the bottom, so it does not have the copyright on there. But it is not a current contract, and I would say that probably TAR would have a problem with having an old contract being taught as part of a new core course, as do I. So I would not recommend approval of this course without some changes being made to it.
Second.
If we deny approval, is it 6 months before they come back, or?
No, they
Get it
they
rewritten?
can resubmit it, make changes and resubmit it. I mean, sometimes we've sent it back to, before it even gets to the commission, if it, like I said, it had 4 hours and you read through it and it just doesn't appear to, and they either need to add additional information to make it last 4 hours or just cut it back. So they make whatever adjustments they
Okay.
need to make.
And I have made notes
Okay.
on it, and I will give you this back.
Okay.
All those in favor of denying J5 and sending it back, say aye.
Aye.
Opposed? Motion carries. Okay, now we're down to J6. That's trees. Who had that one?
That was the one that, that Commissioner Bloom looked at, and you've got his, few comments there. And I don't know whether he is making a recommendation or not making a recommendation.
Move to defer till next month.
Second.
All those in favor of deferring to next month on J6?
Aye.
Okay, and J7, who had that one?
Oh, they were one and the same. They're both, the one's the classroom and one's the paper and pencil.
Okay, so J6 and J7 are
Right.
deferred. All right, what else you got for us, Ms. Maxwell?
Well, so that, that's everything that's urgent, that has to be dealt with, this month. I think that, I'll just to briefly update you on the E&O. As of yesterday, there were still 8,450 individuals who appeared not to have insurance, or at least it's not in our system as of yesterday. And so I know that some of those are probably at Rice, that they're running a bit behind in getting them loaded, downloaded into our system and even loaded into their own system. So hopefully that's going to clear. The letters for suspension are set to go out Tuesday the 15th, or a week from yesterday, I guess. So they're set to go out, and IS has the computer set up so automatically those individuals without insurance will go into a suspended status, and a letter will generate to the appropriate parties. What we tried to give Rice time to clear, basically clear what they had as a backlog, and as Commissioner Grease knows, they're a little bit slow about the mail getting some of that done. So anyway, so hopefully this number will decrease substantially over what it was yesterday. And that has a breakdown of the who has not got it, as far as brokers and affiliate brokers. But that's all that really has to be done.
Would it be inappropriate to put it on our website that anybody who has not done that becomes?
We have it on, we have, like a notice of the E&O on the website. The problem is a lot of people don't seem to want to go to our website. Oh, well, I just put in Trek and it's usually about 10 down. Well, yeah, that's true. But anyway, it is on there, and we did, I did send a letter to all the principal brokers and told them to check their affiliates to make sure that they had it. And Rice has sent out notices. But that one year we sent out 11 notices, and we had more uninsured than we'd ever had. So that definitely was not the answer. And I really do think that some of these will clear. Hopefully 8,000 will. But anyway, that's all that I had to get done today. Yes.
Okay, has anybody else got anything else that has to come before the commission today?
Madam Chairman?
Yes, sir.
I don't know that we did it when we were voting on the minutes, but I would like my vote on the December minutes to be reflected as an abstention since I wasn't there.
Okay.
Thank you.
Ms. Maxwell, you got that?
I got that. I'm writing that down.
Okay. Anything else? If not, this meeting is recessed until in the morning at 9 o'clock.
You're just waiting to do that all day, won't you? Bang that gavel.
Get out of here. You would not believe, feel how cold the bottom of my purse is sitting on that floor.
I don't mean to rush you if you're working on that file, but if you're ready to go, let's call this second day of the Tennessee Real Estate Commission's monthly meeting to order. Please, this is a message to myself as well, make sure your phones are silenced and consider yourself in a courtroom and act like it. That goes to the commission members as well. All right, at this point, unless there's other business to come before the commission, I'm going to turn this over to Judge Johnson to call this hearing to order.
All right, thank you very much. Good morning, everyone. My name is Ann Johnson, and I'll be presiding as administrative judge today. As you all know, there are a few preliminary instructions I need to go through before we get to the evidence, so I will proceed with that first. Today is January 8th, 2015. We are present in Nashville, Tennessee, before the Tennessee Real Estate Commission to consider the case of Monty Moore, docket number 12.18-128154A. As I've said, I am Ann Johnson. I will not participate in the decision on the merits of this case since that decision will be made by the Commission. However, I will make all rulings of law, evidence, and procedure under the authority granted me by the Administrative Procedures Act. At this time, I will ask the Commission members if you would please introduce yourselves for the record.
Austin McMullen.
Grover Collins.
Janet DeChara.
John Grease.
Diane Hills.
Thank you so much. Mr. Grease is serving as chairman today, as I understand. And Mr. Grease, is there a quorum of the commission present?
Yes, Your Honor.
Thank you. I need to talk a little bit about the Open Meetings Act. The members of the commission are reminded that this hearing must comply with the Tennessee Sunshine Law, which requires that all discussions and deliberations take place in public and before all parties to this proceeding. During the hearing, the commission sits as a jury and must consider only the evidence introduced at the hearing and placed on the record. During the course of these proceedings, no commission member should discuss anything concerning this case with other commission members or anyone else except on the record during the hearing. Be especially careful during breaks and other recesses because failure to comply with this requirement could result in a reversal of the commission's decision if the case is appealed. Now, as far as conflict of interest and ex parte communications, if a commission member has received any ex parte communication, which is a communication with or about one of the parties in this case when the other party was not present, or if you have outside knowledge of any aspect of this case, that member is required to disclose such communication on the record. Now, I know you haven't received the notice of charges yet. You just know the name of the case. So this is a continuing instruction. If after you see the notice of charges, you realize that you have some connection to this respondent or the case itself, then I would ask you to please let me know about that. But right now, if you know that you have some sort of connection, either an ex parte communication or other outside knowledge of the parties or the facts of the case, would you please respond now by stating yes? There being no response, I will remind you again of the continuing instruction. I want to say a little bit about the evidence that you'll hear today as far as the credibility and weight to be given that evidence. In making your findings, the Commission must make the sole determination as to the credibility and weight to be given to the evidence presented by each witness. If there is a conflict in the testimony between witnesses or evidence you receive, it is the responsibility of the Commission to reconcile those conflicts if you can. If it is impossible to do so, the Commission must make the determination as to which witness to give the most credibility. In other words, you need to decide what you believe if they're conflicting facts, which one you believe is true. In reaching this determination, there are certain principles of law. If you need more instruction regarding credibility, I won't read all these factors to you right now. It may not be an issue in this case, but if you have any questions about that, I can give you further information, legal instruction about the credibility issue. The state in this matter is the petitioner and has the burden of proof. The state will go first in presenting its evidence. And I would ask you to refrain from any expression of opinion on this case until after all the evidence is presented. You will have an opportunity during the course of this hearing to ask questions of each witness. But please don't express your opinion on their testimony until the deliberation stage. The technical record, I need to read that into the record. The technical record consists of the notice of hearing and charges, number 1, which was filed on October 7th, 2014, the state's witness and exhibit list, a procedural order from me and the respondent's witness and exhibit list. Unless there are additions, something I've overlooked, I'll designate these documents as the technical record. Okay. Now I need to swear in the witnesses if they're present. Do you solemnly swear or affirm that the testimony you provide in this hearing will be the total and complete truth?
Yes, I do.
Oh, thank you, sir. All right. Now, does either party wish to call for the rule?
I don't think it's necessary.
Okay. All right. Are there any preliminary matters, motions, anything that you need to present before we publish the charges to the Commission? All right. Then I suppose if you're ready, you can distribute those. We will give the commission members time to read through this. Chairman Grease, if you will let me know when the commission is ready to proceed. Thank you.
All right, Your Honor, I think we've completed that charge.
All right, thank you. Opening statements, please.
Morning. This matter is here today based on advertisements that Mr. Moore did, and you will learn that a complaint was opened based on a website, We Sell Homes for Free. That advertisement did not list or reference Mr. Moore's firm name or telephone number, and that additional sites for Mr. Moore also did not list the firm name or number. You will find out that he did respond to this complaint to say he had hired a third party to do this advertisement,
and that Mr. Moore contacted that company about the advertisement issues. You'll learn that he will say that he would be monitoring all such sites in the future to be sure that they were in compliance, but you will learn that as of May of last year, subsequent to his response and subsequent to filing this complaint, there were still problems, including a present firm name and number issue, but other sites had a former firm name and number issues. You'll learn that some of these problems, including the advertisement of a group called the Moore Group, which is not licensed, that still existed in October of this year. Tennessee law does provide under 312 that a licensee must not use misleading or untruthful advertisements. And this commission has enacted rules that provide that advertising must have the name, broker, or firm name and firm number in each advertisement, that these must appear conspicuously in each page, and that all information must be current. Your laws also provide that any claims or offers or guarantees concerning sales or how sales are going to be handled must be made in writing, and all terms must be on all advertisements. Because these rules are not followed, because the laws were not followed, we are asking that you find that there was a violation for each advertisement, and that this commission further find that Mr. Moore did not and has not resolved this issue in a timely and straightforward manner, and that after you find that he is in such violations, that he will be required to pay all costs in addition to civil penalties. Thank you.
Thank you, Ms. Ryan. Mr. Woods?
Morning. I'm Alan Woods of the Nashville Bar. I'm here today on behalf of Mr. Moore, and I would encourage the commission members, as we present the evidence today, to consider all the facts. What the state is offering, some of which Ms. Ryan is saying, is accurate. There was some out-of-date and inaccurate information on Mr. Moore's advertisements online. I think we're going to concede that point, and that is a violation of the rules. But there are a number of other facts that the state doesn't want to bring to your attention that I hope you consider when determining what discipline is appropriate in this matter. The primary reason we're here today and Mr. Moore is fighting this is what appears at the very top of page 5 on these notice of charges, which is the state is asking to suspend or revoke his license based on these actions. Now, our position is that is a too severe discipline for the charges that are being levied against him, especially we consider the additional facts we're going to set forth, which include the facts that Mr. Moore used a third party to prepare these advertisements, that he gave the third party specific instructions of what had to appear in those advertisements, and that the fault lied with that third party in not providing all of that correct information. You'll also see evidence that Mr. Moore, when he learned of these inaccuracies on these online advertisements, contacted the third party, had them correct them, and to his knowledge, at the time, the advertisements were corrected. In the future, the problem reappeared, and he terminated his relationship with that third party because they could not follow his instructions of what information was required to appear on those advertisements. I hope you consider all of those facts and information that we'll be presenting when determining what discipline is appropriate in this case.
You want to make a short response or not?
Yes. The state is not necessarily asking for a suspension or revocation of the license based on this. It is just part in our plead that is a part of the discipline that you as a commission can determine. But I want you to know that is not what we are asking for in this matter. We're asking the court find, this commission find that there are violations and that they are violations that continue, and that the violations need to be addressed, and we are asking for civil penalties for the addressing of those violations. I'll leave it at that. Thank you.
Right. Do you have anything else to say, or we? Okay.
Not this time.
Okay. That's unusual, but I thought that might be helpful. All right, we're ready for the evidence.
I'll call Eve Maxwell.
Your Honor, is it possible I could have a word with you just outside of this for a second? Or is that out of line?
Does it have to do with this case?
Yes.
Oh, well then I think what we should do, would it be all right if the attorneys and we put it on the record?
That's fine with me. I just.
Okay, if there's something you need to talk about, if you want to come over here and the attorneys
I'm
come
glad
over.
to keep it on the record, and if I'm out of line, even asking if I can just.
Well, if you have a question, you can go ahead and ask it, and then unless you don't want it.
No, it's not anything
Okay.
personal. It just appears to me from the two opening statements that there may be a basic misunderstanding between what the state's asking for and what the respondent is here to defend against. And if that's the case, and there's any chance the state and the respondent can
Work it out?
work it out, and during a 10-minute break before we go through this whole process, I'd like to just see if that's a possibility.
Well, I'll ask the attorneys about that.
I don't know, Mr. Woods.
We're certainly more than willing to talk during a brief recess.
Okay, well.
That's my
Okay.
question. You tell us how to proceed.
Sure, no, I think that's a very good question. That's why I wanted Ms. Ryan to respond in the opening statement. Yeah, if you think, now, let's keep this as brief as possible. If you need longer, if you're making progress.
I don't think we'll need very long.
Okay, all right, so we'll say 10 minutes, and so we will reconvene at 9:40. Okay.
Your Honor, we did discuss this in the hall, and I will tell the commission that originally this commission determined that a $500 civil penalty was appropriate in this matter. And I believe that he will agree to do that, but we want to include in the order certain facts, like the fact that he has attempted to, as he said already, to resolve all the issues, and he has, since all of this, fired the advertising firm that was in question, and that he agrees to be diligent in going forward, and anything, and that's it. But I will put those facts in the record, if that is acceptable to this commission.
All right, I guess you can deliberate on the
And
settlement.
court costs, I'm sorry, he'll pay court costs as well.
Okay. I'll turn the hearing over to Chairman Grease to deliberate on the settlement proposal.
And, Your Honor, is it our charge at this point to say that's okay with us, and we give it our blessing, or we'd like to?
Yes.
Okay.
Now, I don't even have to be here for you to vote on a settlement agreement, so I really don't need to read you any charges or tell you what to do. If you have legal questions, you are, of course, welcome to ask me. But yes, you can deliberate and see if you think that's fair, and then vote.
Members of the commission, Mr. Chara.
I have a question for Ms. Ryan. Will that also include 2 days commission meeting?
Well, I did not include that, but would that, that's a traditional thing.
That's agreeable to us, Madam Vice Chair.
That's normally in our consent orders.
A regularly scheduled meeting of the commission, so if they happen to meet just one day, the day's here, he only.
Exactly.
Okay.
Exactly. Just a regular commission
Scheduled
meeting.
Okay.
And Madam Vice Chair, just to be clear, I know there'll be a clear vote on.
Within 180 days.
So the chair is anxious to have more discussion, or alternatively, to entertain a motion.
I'll make a motion that we accept the, I'm sorry.
No, pull the thing down.
Oh, I didn't thought you was pointing something on the wall. I'd like to make a motion that we accept the negotiations entered into by the two parties.
I'll second the motion to impose the $500 civil penalty, pay the court costs, and attend a meeting of the Real Estate Commission within the next 180 days.
Motion includes the stipulations that Ms. Ryan wanted to include.
That's my understanding.
All right. So y'all have heard the motion. That's the second originally made, or the motion made by Commissioner Collins, seconded by Commissioner McMullen. Let's have some discussion on the motion.
I think that it I mean, certainly that penalty is within the range of, I think, something that I would consider reasonable, and based on what we've done in the past, I think, within the historical actions that we've taken on the sort of facts that I've seen just based on reading the charges and hearing the opening statements. So I think it seems reasonable, and I support it.
I had one fact that I think probably should be added, is that Mr. Moore's record is very clean with this state and commission, and that's another reason I suggested that.
Oh, and I'd also like to say it appears that Mr. Moore has done everything he can to clear the matter up and continues to do so, and hopefully you'll be very diligent in these websites, because we all know they can scrape them and take them wherever they want to, so just be very diligent in that.
Ms. Hills,
No.
come on, say something. Call for the question, do something.
Call for the question.
All right, we have a call for the question.
Good. Just moving my mic.
All right, any need for a roll call vote, Your Honor, or just need a record of how the commission?
However you usually vote.
Roll call.
Roll call would probably be
All
best.
right, let's do that. Ms. Maxwell, if you'll call the roll, please. If you're in favor of the motion offered by Commissioner Collins, you'll vote yes. If you're opposed, you'll vote no.
McMullen,
Yes.
Grease,
Yes.
Hills,
Yes.
DeChara,
Yes.
Collins,
Yes.
all yes for the present
Motion
commission.
passes unanimously. Back to you, Judge.
Parties, anything else, any questions you have or anything else you need to say before we adjourn?
No, Your Honor, but I will tell you that I will draft basically an agreed order to be approved by Mr. Grease, and I will send that to Mr. Woods prior to being submitted.
I would just like to thank the parties for their preparation and for their working together to come to a resolution. I think it's good.
Right, then this hearing is adjourned, and I'll turn things back over to Mr. Grease.
And thank you, Your Honor, for your great direction just a few minutes ago. We appreciate it. And thank you as well for coming in today. All right, Ms. Maxwell, we're back to the regular agenda of the Tennessee Real Estate Commission. Is there anything else that needs to be handled this morning?
I don't think so. I think we concluded everything that we needed to do.
All right,
What,
Ms.
I have a
DeChara.
question
Okay.
for Ms. Maxwell. This TAR Commissioner Q&A, is that
Yes.
something that needs to be addressed today?
It was just to remind the commission that the commission's been invited to the question and answer session that the Tennessee Association of Realtors has every year. It's in March. This year, it's Tuesday, I have the letter. It's like March the 25th. It's a Tuesday, and from 11 to 12, as it has been in the past at the Marriott. And over the last several years, the commissioners that were able to participate in the question and answer, which is usually moderated by Mr. Russ Farrer, they attend. It's not part of our meeting per se, but we do have to notice it because it's one or more commissioners that are gathered together. And I just wanted to make sure that the commission knew that they had been formally invited by letter. And I think that might have been one of the reasons why Mr. Sexton was here yesterday.
And is that?
It's, I do have it here. I just didn't, it's,
I appreciate you asking that question because I didn't know a thing about it.
I didn't know if you all, yeah, and I was thinking it was February. That's actually, I put it on the agenda because I had thought in the back of my mind it was February, but it's not till March.
Yeah, it's March.
So.
Thanks, Robin.
We had a little more time than I thought we were going to have. Let me find the date in here. It's Tuesday, March the 24th, and it's from 11 to 11:50.
That's in Cool Springs?
And it's at the Cool Springs, which is out there in Franklin, the Marriott, where it has been the last several years. And that's, as I say, that's about all the information I have. And as I say, it's usually moderated by Russ Farrer and their questions from the audience. And I think many of y'all have participated in it in the past.
other, we do have, I was going to wait until the judge left, but to the attendees, and you may not necessarily realize this, but you dodged a big time bullet today when those two attorneys agreed, because it looked to me like they were set up to talk a while.
They're attorneys.
I know.
Have to earn their keep, right?
That's right. Other comments from commissioners or particular items of interest?
Yeah, I am really impressed with our chairman for having the fortitude to say what he said this morning. I appreciate it, and I'd like for all y'all to clap and give him a hand.
I think you should.
Now the real credit should go to the judge who picked up on a discrepancy there in opening statements and couldn't say much, but I read body language well enough to just at least ask a question. That's what I think happened. Thank you, Your Honor, again. All right.
For asking the question. That's a good thing.
All right, Commissioner Hills, anything to say on the way out of town?
No, just stay warm.
Commissioner DeChara?
Have a good day.
Mr. Collins has already spoken. Anything else you'd like to add?
Have a wonderful day.
And the only downside to this settlement is you missed how the great value Commissioner McMullen adds as an attorney to structuring a response, finding the fact, conclusions of law, and all those kind of items. And we didn't get to use your expertise today, but I hope that's okay with you.
I'm okay with that. After yesterday, a day like today is good.
Didn't hurt your feelings.
No, I'll go back and bill somebody else.
That's right. All right, if there's no other business to come before the Real Estate Commission meeting, we are adjourned. Travel safely. Make sure you sign out.
Thank you, Mr. Bruce.
Well, that's a good deal.
Thank you. That was good. Good say.
Yeah.
That was setting up for a long. That was
awesome.
You did great.
Oh, that was